truth live from where they create. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Okay, y'all, they're ready to start. Hold on. They get ready to start now. Hold on, y'all. Hold on. They're ready starting. Good morning, everybody.
Yeah.
Good morning.
We got to dig in here.
Y'all, they're in here. They are in here. They really didn't start yet. Officially didn't start. So we're good. We're good. Good morning. Good morning. Hey, Sunday. Hey, Lady Leo. Hey, Margie C. Hey, Tyler. Hey, Steen. Hey, Todd Glass. Hey, Tank. Hey, Naughty Lynn. Hey, Cutie Pie. Hey, Ann. Hey, everybody. Hey, Pretty Chick. Hey, Coco. Hey, VK. Hey, CMT. Hey, y'all. Good morning. We on time, y'all. They haven't really started anything.
I wouldn't, honestly, wasn't following it too closely. What part of why? So, like, what happened to your client?
We took a plea. We were the first to take a plea. We actually did the motion for mistrial when Judge.
Like back in November. I got you. Yeah, no.
And I were co-counsel.
Wait, you and Bruce were?
Yeah, Bruce is my mentor. We try. Yeah,
I didn't know that.
that's who introduced me to murder.
Well, can you come back and can you try this murder case later this month then? Because
All right, that's who got me. We have a murder case in Cobb County.
No, I'm serious.
March.
This is my oldest case.
Yeah, I saw it. It was older.
Harvey's is my second oldest.
I'm not coming back to try for him though.
But it's not so bad.
I know.
He'll give you like quarter of the fee, I'm sure.
No, he won't.
He doesn't need the money.
He does it, but he's not giving it to me.
It's like a 10 witness case. Come on.
It's how many?
It's like a 10 witness case. It's nothing. You got a self-defense.
I see him asking me too.
Ask him about Ivory, Jamarian Ivory. He's supposed to be in like the islands right now or something.
Yeah, he has a trial starting in Virgin Islands. I think this next week, Monday.
Did he end up? I was hoping to get kicked though.
No, I think he's going.
He's there.
Yeah, they're going.
You
You can prep this thing in 2 days.
I couldn't.
Did you?
All right, Judge.
Yeah, why so Gardner's gonna
I'll
be
give you
out?
Friday
Yes, yay! We are so
No, tell
excited.
the state just get that man a deal.
Well, you know,
They're short staffed. They need to go ahead and resolve some of these cases.
yeah. My impression has been that, you know, compared to kind of the Paul Howard days, there's more flexibility there.
Yeah, it is.
There have been joint resolutions on a lot of murder cases. Whereas usually just tried every one of them.
Yeah.
And sometimes over, you know, the parties are just like that far apart. Well, Well, I want life. Well, I want 30, and they'd still go try it, and it just kind of felt like
That's this case.
not the best use of everyone's time. Okay, well, I'll see you on the 27th. All right, I'll be looking for your entry. I didn't know you had that connection to Bruce.
Sarah and I, well, we have a murder trial in Macon County. Who's been called Sarah? We have that next month. I'm trying it with Sarah.
Oh, that's the one? Is it Macon the same one that I mentioned? Yeah.
Told you I'm trying to get done. I'm break.
Yeah.
Make some money.
I hear you.
Don't have to worry about fighting for anybody's rights for a minute.
No, if I'd gone through that, I'm in twilight zone of a, situation with where you were 10 months for it. You're like, what do we? I don't know.
Coco, you in here? Where Coco at? Hey, lady C. Where Coco? Coco, you here? Where Coco? Coco, I got your fine. Thank you.
What do you? I heard there's what, 2 of them left.
2. Oh yeah, defense.
What's your read on it? I don't know anything about the case. You think it's going to be a trial?
Probably so. Mr. Johnson, Eric Johnson's client, Eppinger probably won't take a plea.
See, okay,
Mr. Johnson probably won't. Think they want a little attention too. They want the type of attention that we were able to get from it. I don't know why. Because one thing it didn't do.
I thought Mr. Johnson already got enough attention.
Right.
Sure. Not the kind he might want.
That is for sure.
Yeah, we don't fly on the wall. We don't fly on the wall. They forgot that they're alive. We all said that they wanted attention, right? Did we not say they wanted attention? Did we not say they wanted attention? Too late, we heard it. Now they want to mute, y'all. Good morning, Bonnie. We heard it. Too late. Oh my God, y'all. We heard it. Oh my God. Oh, this is some good stuff, isn't it? Sunday say somebody text them haters. Oh my God, this is some good stuff. This is what happened when you go around the world. So they are gonna have Stephanie. They said, listen, Stephanie, the judge asked them, well, how's the case going with the 2 that's left for the state, right? And he said, Epinger's not taking the plea because they want attention. Oh my, y'all gotta rewind it. Y'all gotta listen to it. You gotta hit rewind. Oh my God. Oh my God, this is some good stuff. Good morning, Mr. Duncan. We said it, Angel. We said it. Hey, Brandy. We said it. Wait a minute. Brandy didn't say good morning to me. Brandy said good morning. Everybody else didn't say good morning. I'm taking my good morning back from Brandy. I'm taking my good morning back. Did Brandy say good morning to me? No, she didn't say good morning to me. I'm taking my good morning back from Brandy. I'm taking my good morning back from Brandy. Too late, Brandy. I'm taking my good morning back from you because I don't see my name nowhere on your thing. You said other people's name. You ain't say my name nowhere. So I'm taking my good morning back, snatching it back from Brandy. Nope. Nope. Don't try. Did I miss you? Nope. Nope. Don't. Nope. I don't want no good morning from you no more. I took mine back. I'm being stingy. I'm taking it back. Oh. Look, Brandy is the type of person to come up to somebody. Scroll up. So wait a minute. Hold on. Did I make a mistake? Hold on. Let's see. I see tall glass. Let's see. Oh, my bad. I'm sorry. I was wrong again. My apology. Okay, I give it back to you. I give you back. Good morning, Brandy. Good morning, Brandy. I give it back. It's my glasses. I'm going to blame my glasses. It's my glasses, Brandy. It's my glasses. Oops, my bad. I'm always messing up. My bad. They cut their mics back on now? I don't see it. It's CMT. They mad because we heard everything already. We heard everything already. It's too late. We heard everything already. Too late. The world heard it. Stephanie, you missed it. You missed what happened. Eric Johnson sending Gardner a text right now. The judge is going to be going after them. Y'all got to rewind, people who y'all want to hear what happened. Just rewind. Yeah, we got time today. Let me see if Louisiana started. No, Louisiana, it's 8:00 there. They didn't start yet. Yeah. Welcome, y'all. Welcome to everybody. I heard it. You repeated. Oh, okay. I heard this prosecutor, y'all, these two prosecutors, I heard that these ladies are the fairest, the ones that have integrity. These two prosecutors right here. These two prosecutors. They're the fairest prosecutors. They're not, and they're new. They're not part of the old regime of the nonsense. These two are very, and you could tell. You could tell, even with the questioning that they were asking and how they brought it out. They're prosecutors that operate in their capacity of law. They haven't been tainted yet. These two prosecutors. And she's from England. The one with the blue jacket, I was told she's from England. She's from England. And the one with us rubbing her eyes right now, the light skin one, she's one that I know. I always speak to her in the hallway. She's a sweetheart. She's a sweetheart. Those two are good, and they work good together. Yes, he's from England. And Hilton was on this case originally, but because she was doing the YSL, they took her off this case. She was the lead prosecutor originally in this case, but they took her off because remember her specialty was. Writers, I got some information for you writers tonight. I mean, later on tonight, because guys, I got some information, writers. I got some information. Writers, I got some information. Got some information. Christine, I got some information. Got some information. I got some information. I got some information. Y'all, don't talk about me in my hair, okay? I'm gonna dance. Got some information. I got some information. My God is good. God is good. God is good. Whoop, whoop. Whoop, whoop. Whoop, whoop. Whoop, whoop. Ah. Whoop, whoop. Whoop, whoop. Riders, we got to get a meeting going on today. Whoop, whoop. Whoop, whoop. Steen, this is good. Whoop, whoop. Whoop, whoop. Watch out, Sherry. Hold on. Wait. You know, am I gonna be unprofessional if I do what I'm getting ready to do? No, we gotta keep this professional. We gotta do a live. No, we gotta do a live that has nothing to do with court. Cause, hey, Steph, I'm gonna put on those pajamas, Steph. I'm gonna put on those pajamas, Steph. Y'all. Stephanie said Steph Lover. I'm gonna put on those pajamas, Steph Lover. And you know what's gonna happen, Steph Lover. Oh, I can't do that. I forgot I can't do that. Oh man. Guys, oh my God. See, there's like so much I could say right now, but I can't. Should I sing the song? No weapon formed against me shall prosper. It won't work. It won't work. No weapon formed against me shall prosper. It won't work. God will do what he said he will do. He's not like man that he should lie. No weapon. Yes, you did, Steen. Yes, you did. Steen said, told you God is in control. Writers, see you in your pajamas later. Can Oh God, y'all silly. Y'all some silly girls. Woo! Y'all silly. Y'all silly. Y'all some silly ladies. Mr. Duncan, hope to see you tonight. Mr. Duncan, will you be there tonight? Oh, thank you, Jesus. Yes, Lord. Mimi said, what in the world? Mimi, I'm tickled pink right now, y'all. I'm tickled pink. Okay, all right, Mr. Duncan. I'm tickled pink. God will do what he said he will do. He's not a man that he should lie.
The defendant and the alleged victims and witnesses. Do we want to include and witnesses if that includes CJ or the mother? Okay. And the alleged victims and witnesses has been admitted for the sole purpose of illustrating, if it does, skipping ahead, between the defendant and the alleged victims and witnesses. And the reasonableness of any alleged fears by the defendant or alleged victims.
I don't see a problem with that one.
All right, and we'll give you, when we print out the consolidated version, you'll have that copy before, and a chance to look through that before I charge the jury.
Okay.
So you can raise any more concerns, or if you catch any other line edits. So then I'll move on. Page 1920 is about identification. I would propose striking that. Page 21 is the pattern charge on DNA. I'm not sure if either party requested it, but I think we put it in there. But there was no DNA here, so I'd say we can strike 21. We move into 22, and I don't think there was formally character evidence in this case of any kind. I mean, people talked about their background, which by inference, someone could make character findings. But in terms of someone getting up there and saying, I find him to be a good character as contemplated by 404, I don't see that. So I'd propose striking 22.
His mom, I mean, she kind of gave opinion testimony. I mean, she said she's never seen him angry. He's always been a calm guy. Like, I mean, that kind of go to, I mean, because the state's position is that he's this monster, this angry man. And so
okay, that's a fair point. So her testimony was a blanket. It wasn't just between these two.
Correct.
She said overall, I haven't seen him angry.
Correct.
So character of calmness or peacefulness. All right, that I know the state, I don't know if that ever didn't flag to me that it opened the door, but I guess the door was open. So with that, what would you say the character trait is that needs to be filled in the blank here? Or just want to say character generally and leave it at that?
My preference would be for character generally and then specify.
So we're not, that's probably the cleanest.
Generally.
Just say evidence of the defendant's character, if any, has been presented to show that he acted consistently with that character in this case.
Okay.
Second sentence would be this evidence can come in the form of the opinion of another witness. And we just leave it there.
It works.
All right. So with those notes, we move on to page 23. Mm-hmm.
Now we can also request examples of defendant's conduct. If we look at the video, the 404B,
Which one? What were
the
you?
last parenticle that says it.
So the question would be whether that's character evidence or whether that's prior difficulties. And again, character evidence, as I understand this charge, is kind of that not specific acts, but here's my opinion generally of a label I would apply to somebody. Or here's his reputation of a label. And when you point to a specific instance, you're saying, here's what you're rebutting it, aren't you? So
Your Honor, those prior difficulties, though, they can't use, that's not evidence. And they're not supposed to consider it as evidence.
what do you mean by that?
Prior difficulties, I mean, even as we just came across the charge, right?
Well, prior difficulties is coming up.
Yeah, it's coming up, but it still said, but you are not to consider such evidence for these purposes. Like, he's not charged by the state of Georgia for battering.
Oh, no, I'm talking about how Gabby testified and she characterized him, how Laurenti characterized him, how LaWanda characterized him, and sort of consistent with the state's, position of who he is as a person.
Let's back up. What is it that you're saying needs to
maybe
be done to
I'm
page 22? I'm starting with this Charles.
Maybe I'm, okay.
What is it in this pattern charge that needs to be added, changed, amended?
I was just in the last parentheses.
Uh-huh.
I was just taking the examples of the defendant's conduct which show his character.
Okay.
It says evidence can come in the form of opinion of another witness, or examples of.
Yeah. So let's do this. I mean, they kind of all start blending together, and I think I understand your point here, which is let's say the state had not introduced any prior difficulties or hadn't planned to, and mother came up and said, I don't think he's ever been angry. Well, then the state would have been permitted, now the door's open,
Right.
to then come in and say, look at these specific examples where he has been quite angry. And so that would apply. And So here, I think not only does that evidence go towards prior difficulties, it's a state of feeling between the parties. I think it could be used to rebut that character opinion. So I think I agree with the state here that we would add in the form of the opinion of another witness and examples of the defendant's conduct which show his character.
I mean, I object, but I mean, if you, I'll move that object. I mean, I some of the things which shows his.
The only thing I would say here is now that makes me a little more concerned about just referring to it more broadly as character.
Yeah.
I kind of want to now narrow it down to character trait. And so if the character trait was just, he doesn't get angry a lot, what label would you assign that, Mr. Gardner? Peacefulness.
What you say?
Okay. All right. So then I think where we've landed here is that evidence of the defendant's character trait of peacefulness, if any, has been presented. And then we go to the next paragraph, and it's opinion of another witness. Well, I think I'm also wondering if I need to take back a look at the pattern charge, because peacefulness isn't, because it says this evidence can come in the form of. That's not the evidence that it's coming in the form of. It's being rebutted by the state. So is there another pattern charge that talks about rebutting character evidence?
You know, maybe just for the sake of simplicity, just keep it as general character and we won't ask for the examples.
I'll go with that. I'll submit.
That way we don't have to get too specific.
Well, I mean, all right. I mean, if that's,
Yeah,
I mean, if it confines your arguments in closing,
I
then-
think that's fine.
But I don't want to be confined. But I'm looking to see if
because if you're, you know, if in closing you go down the lines of, mom says he was peaceful, but man, look how he acted on that video. That's kind of what you're getting at. I mean,
that's exactly what I'm going to be getting at.
so, you know, let me look at 137.10. But the other way to think about this is that, again, this charge is what evidence was introduced for his character. What you introduced, if you're saying you're using the prior difficulty for that, is impeachment to show why that witness' opinion shouldn't be believed. And we've already covered an impeachment charge, which is just saying, disproving the facts about which they testify.
And also, Your Honor, I mean, we just say that Miss Evans, Thunder Evans was called by the state. And so at that time, the state introduced the video at the 4660 address showing, I mean, so is it us opening the door or them? I mean, they showed the video
Yeah.
and then we came back and said, have you ever seen him this angry? So it wasn't that we called her to the stands like, is your son an angry man? No, it was in response, it was on cross to them opening the door to his character, showing his video and then you question him about it. That
I see your point. But they never asked her that overall question of, tell me about him generally. They were focused on the specific incident.
the incidents, but other incidents, they asked, have you ever been around any other incidents that occurred? And she answered to them, yes. And then they went in and then she questioned them further about those other incidents.
Yeah. I mean, I think we're splitting hairs at this point because the prior difficulties are in. The state has proposed, in reading this charge more carefully, the things that were introduced to just generally refer to his character were just that testimony of, and that question and answer. So I think we can keep the character trait of peacefulness. And then we go back to, it comes in the form of opinion of another witness. And then we strike the examples of the defendant's conduct where we were originally. Because again, I think that what that's actually getting to is saying, and then he volunteers and does all these wonderful things with his church and the school. And that's not what the line of testimony from the defense was.
No,
And
I
then, but the argument I think is the state can still make it because it's covered under impeachment. You know why you shouldn't believe mom's opinion? Because look how he's acting on that video.
Yeah.
All right. All clear? All right, let's move on to 23 then, unless there's anything else either party needs to add. Definition of a crime, pattern charge I'll give. 24, intent, pattern charge, which I would give. 25, presumption of criminal intent. I'll include the parenthetical and give it in its entirety. 26, state has asked for a non-pattern charge about inferring conduct before, during, and after the commission. I think the argument is that that's already covered by no presumption of criminal intent. Other circumstances connected with the act, I think, could very quite reasonably be argued include before, during, and after. Anything the state want to be heard on that?
Yeah, just because of how specific the state's gonna argue his actions were, I think we want to be clear to the jury that it's not just what he's doing at the time,
Mm-hmm.
but also what he does afterwards. No, and if we delineate it that way, then it's clear to them that they can consider everything, not just before, but during, and particularly after.
All right, I haven't pulled these two cases yet. Are either of those in the context of a pattern charge?
No.
Do you have a case that applies it as a pattern charge, perhaps? Because again, the concerns are going to be, we don't want to place undue emphasis on anything. And so if another charge arguably already covers it, less inclined to give it. And then it'd be nice to know if there's some appellate cover on that. Mr. Gardner, do you have a position on page 26?
So the only issue I have is that criminal intent is a question for the jury, may be inferred from conduct before. So, I mean, I know that we had these prior difficulties, but Your Honor, we're in a place where they're going to necessarily, there's a chance that they could convict him, not necessarily on the case at issue, but based on incidents that the state didn't charge. I mean, again, he's not charged with these prior difficulties. So I just don't want that to be an umbrella for them to consider everything that ever happened in their relationship. Oh, yeah.
Well, that's where I think you go back to prior difficulties on page 18. And it says, for the sole purpose of illustrating, if it does, the state of feeling. And I think that's what you have to hammer to show this isn't to paint his character. It's just to show what the relationship was between the two. All right, I'll take it under advisement. If y'all can find me a case that applies it as a pattern charge, we can come back to it. But right now, my inclination is to leave it out and say it's already covered by the pattern on page 25. Moving on, we have presumptions and inferences, which is the pattern charge, which I will give. 28 is knowledge. I don't see that. 28 and 29, knowledge and conduct. Those seem to be more for conspiracy cases, party to a crime cases. I don't see that here, so I would strike those both. Then we get into specific offenses. Page 30 is malice murder. I would strike without justification, without excuse, include without mitigation, since I anticipate, there's a voluntary charge here. Otherwise, I'd give the rest of the charge as the pattern. Page 31, I guess the state requested premeditation. The bench note says shouldn't give it unless asked by the jury. So I would strike page 31 and wait to see if we get questions about that. 32, motive pattern charge, which I'd give. 33, we get into attempt. We've tried to include parentheticals that ties that to malice murder, since that's how it is indicted. And so I would give that as proposed here on page 33. Page 34, I think this is only going to be relevant if someone's requesting a lesser included. We haven't really gotten to that point yet, but I guess I need to ask about that now. I know the defense is asking for voluntary. Is the state asking for any lesser includeds in this case? All right, then I would propose striking 34. Hearing no objection, we get to 35, which is abandonment. That's one I put in here. Seems applicable to me.
There was evidence of abandonment.
And I don't see any tailoring needed here. And, we might end up getting some questions on what is a substantial step and all these sort of things, but we're just going to have to figure that out. All right, we move on to page 36. Impossibility is not a defense. Looks like the pattern charge, which I'll give. Page 37, felony murder. Includes both of our predicate felonies, so I'll give that as written here. 38, causation and felony murder. Again, includes both our predicate felonies. I'll give it as written there. 39, I think someone might have requested contributing to the death. I don't see that as applicable. I think all the evidence was that Mr. Davenport died almost immediately. We move to page 40, which is voluntary manslaughter. And state have a position on that?
Hey, Your Honor.
So you don't, I mean, for the record, you're not objecting to the request?
But for the record, I would object, I believe, based on the evidence presented, the standard is it's just be some slight evidence.
Really, any evidence, right?
Right, and then in review of the testimony of the night we did, so there may have been some slight evidence, or that we don't see anything that's overwhelming, but just for the record, I would say the state would have objected.
And so if it was up to you, you'd say we shouldn't include it.
We shouldn't include it, just for the record.
Well, for the record, for
Because
everything.
I don't see, there wasn't any, I mean, although the defendant testified, nothing that he stated, even on direct, on cross, pointed to that elements that would meet the standards of voluntary manslaughter, specifically serious provocation. I just didn't see that element. We went through the videos, we asked him multiple times, at what point will you provoke sufficiently to meet the elements of that, that charge? And he just didn't have an answer. He didn't give anything that would go to that. And so, but for his overall assertion that that's why he did it, I just don't see it.
Did you get a chance to read the Allen case?
I did. We
and
talked
that's what I
about
was
it.
going
We
to
talked
ask.
about it last night.
I was going to
I read
ask
it.
for it to be added. Oh, okay, sorry.
No, we read. So myself and defense talked about the same case last, and I went back and read it, and I understand where the court will land ultimately based on that. Yeah.
I was just
Mr.
going to
Gardner?
suggest something from the Allen case be added, Your Honor.
Go ahead.
It's note number 9.
I don't have the head notes. You have to give me
Yep.
a page number or a quote or something.
It is, well, I'll read it. It says, the witness's one partner actually committed an adulterous act is certainly one manner of discovering a partner's infidelity that can be sufficiently provoking as to warrant a voluntary manslaughter charge as a lesser offense of murder. And it's this part that I would like to add. But one can also be sufficiently provoked by finding his partner and another person in such a position as to indicate with reasonable certainty to a reasonable mind that they had just committed an adulterous act. I mean, we heard a lot of testimony, even from Gabby herself, that although the state tried to show that, they were done back in January, testimony from the victim herself said, even in March, we were off and on. We showed text messages between them where they were still having sex, where they were still going out on dinner, where they were still staying with each other. We saw one text message on the day of 28 to say, you act like we go together. But right before she said, I love you.
So that gets to the proving or having evidence of an active relationship.
Correct.
What I think the state's pushing back on is saying, how is this sufficient provocation? Where a woman is found in a car with another man, how does that suggest adulterous conduct?
I mean, another man that you got to look for. If we're looking at conduct before, we got Mr. Lamonte. He's reaching out to her. They already have plans themselves going from the prior night. They're, like I said, they're still considering themselves in a relationship. She didn't tell Mr. Lewis who she was with because she was with another guy that she was interested in, that she was having relations with. Now, Mr. Lewis already under the impression that because there's been an instance where she has cheated on him, we're contacting her all day, and then we see her get out of a truck. He looks over, it's with another man, his woman out of a truck with another man. Then and he loses it. You know what I mean? She's ignored him all day. He's wondering.
So it's solely because the defense theory is that she, I don't know, would you say it was an active deception or she just wouldn't tell, or?
It was active deception. I mean, deception is a big part of this case. I mean, I
don't look, let's, in the interest of time, I mean, we could have fun and talk about this all day because I think it's a very, as I noticed, it's now contentious area of the law. But the reality is I think Allen dealt squarely with what is sufficient provocation, and the majority came down quite firmly that if there's any evidence, it's a jury question, that the jury should decide it. And Justice Bethel's concurrence outright says it, that it's prudent to err on the side of giving it. The dissent points out that maybe this means every single domestic violence case now gets a voluntary. I think the dissent probably has a powerful point there. And until we have more data, I'm going to be giving it. And I'll note that in this case, though, I think it would have been very much less than certain whether this is enough to be considered sufficient provocation. I think we can just leave it at that. All right, so moving on, page 41 is the pattern charge. Now, you requested the addition of language. I mean, I think generally that should be in writing before we have the charge conference, but if it's just kind of trying to say that this is a type of voluntary manslaughter that is allowed, I'm not seeing any other kind of clarification. I mean, I think they would know that because it's in the charges, and that's your argument. So that quote, I'm not seeing what that adds, because we're saying if it's
Because maybe, Your Honor, they may think the provocation is just catching them in the sexual act. This case says that that's not the only form of provocation. You don't have to catch them having sex with someone. It can be the
well, no, all it says here is acted only, I'm on page 41, acted only because of a sudden, violent, and irresistible passion that resulted from a serious provocation. That is so, and that's where the majority came down, is that language is so broad that it encompasses words. That was the dividing line. The dissent said, no, you have to catch them in the act. The majority said words can be enough. And I think the pattern charge and the statutory language captures that. So I don't know if we need more emphasis placed on that when it's there for you to argue. If you have another quote from Alan, nothing really jumped out at me as terms of being something that needed to be charged.
I mean, I'm still
Okay. Make your record though. If there's a specific language you wanted to put in.
the language that I read out, I would like it. I mean, but if the court denies, then I mean, it's what it is. But
Okay.
I would like that added language from the Allen case.
Just specifically highlighting voluntary can apply to infidelity.
Correct.
Yeah. And I don't disagree with you at all. I think that is the law. I just think that's already adequately covered by the voluntary manslaughter charge. So I'll deny the motion for the record. And in fact, I think we now will get to your point on page 42, where we have the adultery charge, pattern charge. So we have here a defendant is not justified in killing his partner or partner's lover. And here we are. So let's read this one very carefully. I think, as you note, we've already subbed in partner where instead of spouse. So I'm reading this and I think this captures Alan. And I think it's an accurate statement of the law. So I would plan to give 42 as written, but let's not rush 42 here. Read it twice. I don't see any issues with it.
I don't either.
All right, then we'll strike the bench note, include 42. We turn to 43. Now, this one would be a problem if we put it in there, and Alan says that specifically. So the only thing that I think survives may be that second sentence, because words alone can be enough because of the words at issue.
Correct.
So I would strike that, and it says, but then again, I think that last sentence may have already been covered by adultery here. Yeah, I think it does. I would say we strike 43 in its entirety. We've already shown the issue here is passion. And words alone is not an accurate statement of the law as applied to this case. All right, hearing no objections, I'll turn to 44. No one's asking for a lesser, so I'd strike page 44. We get to 45, aggravated assault. It's tailored to the indictment. It says intent to murder is an essential element of aggravated assault. Is that how it's indicted?
Well, it's not indicted that way.
Yeah, I think we might want to.
The one after is following the indictment, the next page of the.
Oh, okay. Someone requested that one. Oh, okay. We're striking 45. I don't know who requested that. But. All right, let's get to the one that might actually apply here is 46. There's with a deadly weapon. That's the pattern charge. We'll give, it looks like it's tailored. 47, firearm is deadly weapon, pattern charge, I'll give. 48, I think we've already handled whether firearm's a deadly weapon. All that is at issue here is a firearm, so I'd strike 48. 49, we get to possession during the commission. And there's a parentheses on number 3, and I think since there is an attempt here, we would include both, while committing or attempting to commit, because we have the, I believe, let me double check. Have we indicted the attempted murder as one of the commissions? We did on count 8. So the list of felonies there needs to be murder, felony murder, aggravated assault, criminal damage to property. Well, after murder, it needs to be criminal attempt to commit murder. It needs to be added. Strike the bench notes. Anything else to be heard on page 49? I think we'd also reorder these and have this one follow the next one. So it's in the order of the indictment offenses. So the next one on page 50 is criminal damage to property. We'll have that fall before possession of a firearm during the commission. And on page 50, we have, I guess this is just the nature of the language of the statute, but let's tailor it to the indictment, which is interfering with property, so to endanger human life. So we would strike 2 and 3 and just include number 1. Moving on, 51, excessive force, I don't think applies here. This is a self-defense case, I'd strike it. 52 is venue generally. We'll include the parenthetical. $54, no interest. 55, sympathy. I'll include the parenthetical. All the pattern charge, which we'll give. Sentencing, pattern charge, I'll give. 57, deliberations. I don't see any tailoring needed for this pattern charge. Same with 58 and 59. And then with 58, I'll give the parenthetical. So I think all that leaves us is to come back to 4. We had grave suspicion. Was Ms. Flack going to be still trying to join us by Zoom, you
I
think?
thought she was here, but I mean, let's look at grave suspicion. He said,
I'm here. I'm just
All right.
leaving my appointment.
All right,
What's
Ms.
the question about grave suspicion? Because we love that charge.
I know, yeah, I imagine so. I'm just, as I'm looking at the bench notes, there's some case law saying that it's adequately covered by reasonable doubt. And so I have.
Judge, I've never tried a criminal case where we have asked for that charge or we have not received it, including in Fulton County. So I'm just, I know that the court has some discretion, but if we're asking for it, I don't, especially in this case, because there have been so many other prior acts and difficulties that have come in. And I mean, this, if I don't know what case deserves that charge, if not this one.
Well, I would say it might be more towards an identity type defense, but you know, although I don't find terribly persuasive the argument that I hear a lot, which is this is how we've always been doing it, I'll keep it in.
Thank you.
All right, and then I think the state still had their non-pattern charge. Any chance you found some more case law you want me to look at there? We can do that. For now, I'm going to say it's out, and we'll consolidate these and have a copy for you. And why don't we plan to bring in the jury at 10 o'clock? Any other objections or things that need to be heard for the record on these charges as presented?
none from the state.
All right.
I mean, none from the defense, so.
All right. We'll be in recess till 10 o'clock. Oh, actually, nope, strike that. We're back on the record. Please look at the proposed verdict form and let me know if you have any issues with that. Sorry? I'll say it again. I'm pretty sure I did. But I'll do it again. And again, in case I hadn't formally put this on the record, I've marked the draft we just went through as Courts Exhibit 2, and I've tendered that for the record. Start like scrunching them together. And oh, okay, it's just not updating for me. So.
No, I started a new doc.
Oh.
Just it's all hidden.
Okay. Well, that would be right there above it, right?
Right, it says not good for the policy. Okay.
Maybe or just to make sure that they don't make any finding.
Right.
If they do voluntary, they stop right there, and that's the other thing they do with count one.
Okay.
Same with the felony murder.
Okay. Okay.
Because then it can mess things up if they
Right.
make a finding.
They make it fun. Oh, that makes sense.
So I try to make that or very explicit, and it's in the charges.
Okay. All good.
Any, we'll go put it on the record in just a second. But do you see any other
They're both
issues?
doing a closing argument.
Okay, did the state look at this?
Both of them.
Okay. All right.
They're both doing it. His attorney, the both of them, they're sharing their the closing argument. I learned so much yesterday about the defendant. I learned so much yesterday. I got some stuff to tell y'all. Okay, I'm coming, Kobe. Kobe's coming, want to come in here. Hold on, y'all. I'm coming. Now you want to come in here and hang with me. Come on. You want to come in here and hang with me today, huh?
Yeah. Turn away. 1, 2, 3, 4. And apparently they does make the jury single, but all of ours can be done.
The only kid he have is a kid that he had with that girl.
That's fine. Scholar, not an engineer. Oh, I am. And the diploma's around.
He does not.
Let's go. But I went there anyways. But I own someone. Well, no. There's strings attached. On zipper right, it's because if I have brains on that's the sun. Get injured.
Y'all, I found out in the text messages, she was the one that invited him over and said that you're gonna get some tonight. She was playing the game, y'all. She was playing the game.
No dog in the fight, right?
Yes, JT. Yes. Yes, JT. Yes, JT. Yes, young lady. The same night. You're going to hear it in the closing argument. You're going to hear some stuff that was said on the witness stand. But you know she had a child right after he went to jail. And whose child is that? Whose child is that? Yeah, it was talked about. We missed some stuff. I don't know. Well, y'all shouldn't have missed some stuff. I stepped away. I don't know how y'all missed stuff because I stepped away. I have an excuse. Because when I was talking to him yesterday,
she's still just gonna be able to be here. She didn't need to hear, about the snow and the gasoline.
the text messages was talking about in the,
Well, and as y'all split it up however you want. I'll just have the clocks running. I know, but gotta give me something to do.
For sure. Okay.
All right.
oh, because you be at work. Well, somebody who listened to the whole thing yesterday, or was it the first day? It was one of those days. They talk about the text messages and stuff. And look, they have it in evidence. The iPad did have it on there.
I just associate him with young Harris, but he may have just lived there.
You did enter it in the beginning.
And then he ended up telling on himself.
I know he was raised there.
Hey, y'all, he told himself about having the other guy's gun. He told
So he started the young
himself.
Harris.
You remember? The gun he threw out was the gun that belonged to the guy.
And then young Harris.
Told on
He got
himself.
an associate degree from Young Harris and later attended Emory University. And then after in the Marines, he goes to the UGA and gets a bachelor's and master's degree in history. So that's how you kill progress.
Yeah, he took the deceased guy's gun because the deceased guy was reaching to the back. You guys see, we didn't see all that. The guy
Okay,
was
so he
reaching
did
to the
down here.
back to
Got
get
the
his
zoom
gun, but he ended up shooting him first. But see, what made it wrong, what made it not self-defense is when he went and opened up and got
Judge, can I get the Zoom link?
he got the guy's gun.
What else were you asking me about? You asked me about
If you look into the
There's someone
car
else I
when
was
the
gonna
girl
look
was
up.
getting out the car, right? He was going to the back to get his gun. The deceased guy. He was getting his gun.
Judge, can I get the Zoom link, please?
He reached
Oh,
in
you
the
said-
car
okay,
and
I'm
got
sorry.
the guy's gun too. That's why he ended up shooting him with the guy's gun as well. That's how he ended up getting 16 bullets. Because the guy had bullets and he had bullets. Y'all, why y'all miss all that? See, I had to go and get the 411. Because that wasn't the first encounter with the guy. He had an encounter with the guy in at the what's the name? Yeah.
He's an impressive guy.
Yeah, they had to
I
alter.
agree. Oh, I agree with that he'll run. Yeah.
What's your email?
S.Lamar@SLamarGardner.
And I gotta share something with y'all.
Okay.
Oh, I was gonna tell y'all
All
something.
right.
I found out
Okay, so let's
her family,
go back on the record here.
his family hugged them.
And
And this happened yesterday.
first, I'll put on the record here, I've showed the proposed verdict form to both sides, starting with the
And
state. Any objection?
The grandmother goes.
Ms. Gardner?
No
I
objection.
knew it
All
was
right, as I understand it, defense has decided to split their closing. So at any point, we'll just have the clocks running here with the 2 hours. At any
grandmother on
point,
the
you can just
girl's side.
tag out.
Yeah.
We should be printing off copies of the consolidated form. We don't have those to you yet, but is there any reason we can't go ahead and start the state's first closing?
Yes, sir. I'm just testing the PowerPoint.
Okay. Is everyone a host who needs to be a host?
I'm connecting.
Oh, you can't hear me? Okay, I'll talk afterwards. I'll tell y'all later. I'll tell you what happened later. I won't forget, hopefully.
I can share.
All right, well, feel free to go ahead and pull that up if you're using that in your first closing. And Deputy Scott, if you could bring in the jurors.
All right, here we go. Here come closing.
And for the record, our consolidated packet, I'm marking as Courts Exhibit 3 and tendering.
Y'all ready? Here come closing remarks. They should have a verdict today.
No. This.
You already know he's guilty, but we got to find out what type of guilty he is. Hey, FDR. Good morning. Good morning, everybody that's coming in. You guys. You said premeditated murder. That's what you said Sunday. We shall see. We shall see.
Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. Thank you for your patience. We are now ready to begin closing. And as I indicated to you at the outset of this trial, the state, because they have the burden of proof, has the opportunity to both open and conclude closing arguments, which, as I understand, they have elected to avail themselves of today. Just a reminder before we get started, which is that closing arguments are not evidence, and it is up to you, the jury, to recall and make the determinations of just what it is, the evidence that has been presented to you. So with that, Ms. Charles, whenever you're ready, the floor is yours.
Thank you, Anna. Good morning again, ladies and gentlemen. As Judge just explained, we're at that point where we're about to turn over to you. I said from the very beginning, you are what makes the system work. Before I begin my presentation, I want to take the time to thank you for your service. Thank you for the time you spent with us for the last couple of days. On behalf of myself, AD of Washington, the state of Georgia, we want to thank you for taking good notes, paying attention, being on time, because without you, the system does not work. And so what I'm going to do is give a general overview of what the next steps are going to look like. My first half of the presentation, telling you what the law that you're expected to deliberate upon is going to look like. I'm going to start talking about your duty to deliberate, the principles you're going to be asked to consider, the crimes that were charged, an overview of the evidence, and then we're going to come back and ask you for a verdict. And so the first step is, what is your duty as jurors? You are bound by the instruction and the law given to you by the judge. Every juror has a duty to deliberate. If a juror seems to be checked out, not participating actively, it is your duty to inform the court. If the juror is simply refusing to participate, it's also your duty to inform the court. There are certain things you shouldn't consider when you're deliberating, and the judge will give you the law on that. And just in brief, everything that is inside of the circle, you should consider. You should consider the statements you heard, any expert testimony, the testimony of the victim. You heard from Ms. Gore. You heard from her mother, Cassandra Gore. You heard from Winifred Gore. You heard from his mother, Cassandra Gates. You heard about testimony from GBI, law enforcement. You heard a number of statements. You reviewed photos. You were presented with documents. All of that is for your consideration when you go back.
Yeah, I think the verdict could be today.
You're also permitted to consider the witnesses themselves and what, if any, motive they had to lie to misrepresent the truth, to be deceptive. What you're not to consider, however, is any passions that may have been displayed in open court, any public opinion about the case, any public opinions about cases in general, the system in general, whether you're unhappy with the police, whether you have any public feelings, any sympathy for the defendant. You observe the defendant at one point attempted to elicit some tears when he broke down on the stand. That was a veiled attempt to elicit some sympathy the state represents to you. You are not to consider—
There are more men on the jury than women.
Conversely, you're not to consider sympathy in general for witnesses on the state side. Some people are also emotional. That is a natural reaction as a human, but that is not part of your consideration when you come to a private law. Any prejudice you may have, or any disagreements you may have with the law, you're not to consider any of that.
Colby, could you stop making noise, please?
Finally, you are not to consider any penalty or punishment. The only person who will be concerned with penalty and punishment will be the judge. Your job as jurors is to be fair and impartial. And I know we said 100 times in a jury selection, because you are honestly seeking the truth. We're not to seek doubt. And so what is doubt? Doubt is something that has to be reasonable. And we'll talk a little bit more about that. As we explained in the beginning, when the defendant walks into the courtroom, he has a legal presumption of innocence. And what that means, it's not that he's innocent. It simply means until we have met our burden beyond a reasonable doubt, he's presumed innocent. But it doesn't mean he's not guilty. And then we come to the burden of proof. The burden of proof rests upon the state, it never shifts. And we have to prove every essential element of the crimes charge beyond that reasonable doubt. We're also going to ask you to consider intent. Some of the crimes have an element of whether he intentionally did certain things. And you're going to look at what is intent. And intent may be inferred by the circumstances, the conduct of acts. Whether when somebody does something, they meant whatever flowed from that action as a natural and necessary consequence of that act. Did they mean that?
Yeah, he meant
It
it.
doesn't mean an intent to violate the law. It simply means when they committed the act, that act was prohibited by statute. And you can look at the totality of the circumstances. Look at everything that occurred
Totality of the
during the acts and come to that conclusion whether when they committed that crime, they meant to do it.
crime of passion.
As I said earlier, you're not to show favor to either side. Your duty is to be objective, without affection, without sympathy, without favor. Your doubts must be reasonable. And what is reasonable doubt? It's not a mathematical certainty. It doesn't mean the state has to prove every element of the charged crime be at 100%. It simply means if you have a doubt for which you can put your finger on it, not anything vague or arbitrary, or you wish you could have seen more, heard more videos, heard more audios. It's not that. It's something that you can put your finger on and articulate clearly. That is the reason I have some doubts. And then that's a reasonable doubt, and you're permitted to have those doubts. We like to use a little demonstrative to
His name is
explain
Monte
further what we mean by reasonable
Lewis.
doubt.
That's who he is
We look at this
all about.
puzzle piece.
It's a murder charge.
We can note that there are some pieces missing from this puzzle piece. When you look at this puzzle piece, you know instantly that's a $1 bill because you recognize what's familiar. That is what we mean by reasonable doubt. There's no doubt that that's a $1 bill. Reasonable doubt is based on common sense. Reasonable doubt is not vague or arbitrary. On the flip side, unreasonable doubt would be based on something that was not presented at trial. Non-existent evidence, conjecture, hypotheticals, speculation by the attorneys on both sides. That is not reasonable. And so, another graphic to explain. When you go back, you'll be asked to consider all of the evidence, the direct, what you can see, hear, touch, feel, and the indirect, the circumstantial evidence, what you can infer from the totality of the circumstances. And the little graphic, we had a little snow day last week, and everyone was outside, and there's no doubt it snowed. But generally, it doesn't snow in the state. But what if one day you walked out and you saw the graphic on the other side, where the ground is covered in the powdery substance and there are tire marks going? Did someone get a carton of talcum powder and talc your yard and drive through it? Perhaps. Or is it more reasonable to say that there was a light dusting of snow overnight? And that is the circumstantial evidence part. You are to consider both of those. Some of the evidence that you'll be asked to consider is all of the testimonial evidence. Every single witness who came and talked to you, every single person who took time out of their day to come here, who are all disinterested in the case, who are simply coming to report their part in this case, what they saw, what they felt, what they observed. What is not evidence is anything that wasn't presented, any conjecture, speculation, any questions by the attorneys, any hypotheticals, as I said. None of that is evidence. And any statements that we make, that is not evidence. The only evidence you're to consider are from what you heard in that witness box. And you will be justified to infer conclusions based on your own life experiences. Because as we said in jury selection, we don't want you to leave that at the door. We want you to come in with that common sense and reason and apply it firmly to the evidence based on the law the judge will instruct you upon. You and only you determine the credibility of each witness. And you can do that in many ways. You can do that based on the manner in which they testify. You can do that looking at the opportunity to know the facts that they're testifying to, their interest or lack of interest in the case, and their personal credibility, their body English, as you personally observed it. All of that goes into how credible was that witness? How credible do you find them to be based on how they testify? Now, when a witness testifies, there may not always be corroboration for every single fact to which they testify. But if you believe that witness, that is enough. Whether we have the video or not, if you believe what CJ said he saw, if you believe what Gabrielle Gore said she saw, if you believe what Winifred Gore said she saw, that is enough to prove the facts. The indictment in this case is not evidence, so you are not to consider that. However, we do want to kind of walk through a little bit the charges in the indictment as you go back to consider. First, looking at murder. And what is murder in this case? Murder is a person with malice of forethought. We talked about that earlier when I opened, I mentioned it briefly. And malice of forethought is a very kind of amorphous concept, but what it means is an unlawful intention to kill without justification. And that could be in two ways. It could be expressed, I am going to kill you. And then I point to gun at or it could be implied. And the implication come where there is no provocation, but the circumstances of you taking that life indicates that you have abandoned your heart when you pull that trigger or you stab someone. Another way of thinking of it is you have taken your heart, thrown it on the ground, and says, I don't care what happens next. I am going to do that act that is going to take your life. Here, the malice is implied. Because the state's position is when this defendant shot Jamari 16 times, he had zero regard for his life. When he shot Jamari to prove a point, he had zero regard for his life. When he shot him within 2 seconds of arriving at the door of that truck, the passenger side, he didn't care. He was going to take that life. When he stepped out of that vehicle armed with a firearm, when he walked out, when he pulled that trigger, that was malice. It wasn't sudden. It wasn't that he couldn't resist what he did. It was already in the back of his mind. He had thought about it. He was ready, armed, willing to execute. And so when we look at the indictment, and as you deliberate, we break down the elements and we say defendant unlawfully and with malice of forethought, check. Express or implied malice, check. Cause Jamari Davenport, check. Without justification. There's no reason for this. Without mitigation or excuse, he shot him 16 times, one of which went into his heart, causing his death. None of this was justified. Malice murder doesn't require premeditation. However, premeditation can be formed and malice can be formed in an instant. It doesn't mean you have to have planned this weeks in advance, days in advance. Simply when he paused in front of that doorway and he pulled that trigger, malice is formed. When he blew that window out, malice was formed. When he ran back to the car to get that second firearm, malice was formed. When he walked back after he couldn't get to Gabby because Gabby made it inside, he testified. He watched the light go out of Jamari's eyes. Malice was formed. And when he turned himself in, he threw the second gun away. He told us that. The gun he turned in only matched one of the 9mm bullets. The handful of others were on the second gun. That didn't come to officers. He didn't turn that in. And he knows why he didn't turn that in. The deception, the consciousness of guilt had already set in. The defendant wasn't emotional. The defendant wasn't caught up in the throes of passionate, such a heat of passion that he couldn't control himself. He was cold. He was calculated. He was vengeful. He was angry that all afternoon he couldn't get what he wanted from Gabby. And he was going to do something about it. He was going to confront her. I didn't go to confront her unarmed. He went to confront her armed. During the interaction, Jamari had no time to react. It was so quick. None at all. Jamari did nothing to threaten this defendant. Jamari was sitting in his truck, waiting to exit. His truck was blocked in by this defendant. And it was done intentionally. And then after he empties the clip on Jamari, he turns to Gabby and says, "You're next." And you can see him running down to get that second fire to get back to her while she's frantically trying to get into her house. And afterwards, he doesn't call 911. He turns himself in a little bit later, but he lies. And when he lies, that the state will represent to you his consciousness of his guilt. Because he admitted when he shot, he didn't know who was inside of that truck. He said he confirmed afterwards. He was asked on the cross, was it male or female? He didn't know. He had no idea. All he saw was Gabby exit the vehicle and walk away to her home. And so come to counts 2, criminal attempt to commit murder. A party is guilty if it can be shown that they have taken substantial steps to commit a felony, even if that felony was unsuccessful. And so a couple of examples. If you wear a ski mask, you go into a bank, even with a fake gun, you can't actually rob the bank, say the bank is closed, or you go in there and the teller senses a fake gun, and you don't complete the robbery, that you have taken substantial steps to commit bank robbery. Similarly, if you're following a tourist down the sidewalk and you reach for their wallet, but you don't get to take it, those are substantial steps to committing a theft. If you mix poison in someone's drink, but they don't actually drink it, it didn't mean you didn't intend to kill them or harm them. You took substantial steps to get that end result. And that is enough for criminal attempt. And what were the substantial steps here? The state argues that when he intentionally drove back to Diane Drive, armed with 2 firearms, shot and killed Jamari Davenport, ran to his car to retrieve the second gun, told Gabby, "You're next," chased her into the house, pointing the gun at her. Those were substantial steps to taking her life, the same way he had just taken Jamari's life. And we come to felony murder, which is counts 3 and 4 in the indictment. And felony murder is a little bit different to the top count of murder, because felony murder does not include an intent element. Felony murder is an act that where you commit an underlying act. In this case, we allege 2 underlying acts, the aggravated assault and the criminal damage in the first degree. When Jamari died, because he was assaulted by the defendant, shooting him 16 times, That was an assault. The assault led to his death. Consequently, we are here with felony murder. It doesn't matter whether he intended to cause Jamari's death. It doesn't matter for a felony murder count. It's simply that when he assaulted Jamari died. When he pointed that gun and blew out those windows, he died. First degree, Jamari died. That's felony murder. But that's a felony in and of itself. There is no proof of malice required, whether it be express or implied malice. If a defendant causes the death of another while he's engaged in any felony, that is felony murder. There's no requirement that he needs to cause the death. There is simply a connection between the underlying felony and the death. It's like math. The defendant intended to cause the death. As an example of a math problem, the defendant intended to cause the death, not required because there's no intent, but the defendant shot someone, that was a felony, he died, guilty of felony murder. Counts 5, aggravated assault. Similarly, the state alleges that he caused Jamari's death when he assaulted him by shooting him with a gun. Straightforward. Criminal damage in the first degree, the state alleges that he knowingly and without authority interfered with the property of another, which is the car, the truck, to endanger human life. Because the only reason he blew out the window is to get to Jamari to kill him. And then in all of these actions, he possessed a firearm in his hand. So if you have a firearm on, whether you held it or was within arm's reach, that is possession of a firearm during the commission of felony counts 7 and 8. And I'm going to end with a couple of charges you're going to be asked as well to consider, which is the voluntary manslaughter charge. And the law reads as follows. A person commits the offense of voluntary manslaughter when he causes the death of another human being under circumstances which would otherwise be murder if he acts only, solely as the result of sudden, violent, and irresistible passion resulting from serious provocation. Not just provocation, serious provocation sufficient to excite such passion in a reasonable person. Not in sorry, it's not a subjective standard, it's an objective standard. However, if there was a time between the provocation and the killing for the voice of reason to prevail, that killing shall be attributed to revenge and shall be punished. When I come back, I will talk to you a little bit about what this case is like. That will not address me. And we'll go into a little bit more into the details of the case and what I expect you to deliberate upon when we come back.
Good morning, ladies and gentlemen. Love, deception, defeat. Love, deception, defeat. If I could sum this case up to 2 words, I'll tell you that it is love and deception that led to the killing of Jamari Davenport on March 28, 2020. I represent Mr. Galante Lewis. Mr. Lewis, a devout family man, a supporter, a protector, and a provider. You heard him testify on that stand that the one thing that he's always wanted to do, be a dad, to be a father, to have a family. He talked about the house and the apartment that he bought for his family so that they can have the American dream. Now, the state would have you believe that Mr. Lewis is a monster, a menace, a miscreant. And I submit to you that he is not. heard testimony that he made a lot of money. He used his money and power as power and control over Miss Gore. That's not the truth. He provided for her because that's what he thought he was supposed to do as the man in their relationship, the breadwinner, as the leader, as his stepfather showed him. That as a man, you're supposed to provide. You're supposed to provide for your partner. You're supposed to provide for your children. And whatever that takes, you're supposed to do it because they depend on you. And that's what he did. Now, Ms. Flack told you in opening that the one question that you would not have to consider is whether Mr. Lewis killed Mr. Davenport. We submit that he did. But it was not murder. It was manslaughter. At the time that it happened, Mr. Lewis, he lost. He's been calling this, he heard testimony, and he's been calling all day. Want to know what her whereabouts. That's not a crime. This is his lover. He's not knowing where she's at all. There's nothing wrong with texting. Where are you? Your mom doesn't know where you are. Your sister doesn't know where you are. We're supposed to get the kids. You saw messages from the day before that they were supposed to be together. March 27th, 2020, we get a text message. March 28th, we get a text message. Oh, you act like we're not together. I mean, you're acting like we're together. We're not together. The state would have you believe that Mr. Lewis did nothing to Ms. Gore in that relationship except abuse her, manipulate her, treat her as if she was less than she get clear. That is not how he saw the love of his life. That is not how he saw the mother of his child. Now we are at the crossroads. And you'll have to decide whether or not Mr. Lewis is guilty of the charges in that indictment, or if he's guilty of manslaughter. And we submit to you that he is guilty of his own. Now, Judge admonished you at the beginning that what the attorneys say is not evident. Prosecution said that the questions that the attorneys asked the witnesses on the stand not evident. But what is evident? If it's the testimony of the witnesses on the stand, that's evident. We have Cassandra Gates, Mr. Lamonte's mother, who testified from that stand. And she discussed and she narrated a couple events that occurred between Mr. Lewis and Ms. Gore. One of the events you saw, he was had a gun to his side. And she told you that he was angry. Now, the state didn't give you any context to that video. They didn't give you any context to why he was angry. He was angry because here he is driving to Ms. Gore's home, family in the car. The son opened up a laptop with a man laying on the bed, ejaculating. Now, Mr. Lewis is a man who is supposed to provide and take care of his family. He sees that his minor son sees this video in his mom's phone. He starts to think, he's already concerned at times if his kids are being taken care of properly when she's with them. And it's a valid concern. And that incident of testimony you heard regarding that, his reason is valid. Now, do I say him having a gun? Do we validate that? I'm not saying it's right. But even if he understood, he could. The flight also made you aware in opening, there would be some evidence that you would hear and to pay close attention to evidence that you hear. But she told you to also pay attention to the evidence that you don't see or hear. They didn't tell you why Mr. Lewis was mad either. She didn't. You know, ask Miss Gates on the stand, she didn't. We had to bring it out. She was never going to mention it. All she wanted you to say is that he was angry. Oh, he was about to kill her this day. We saw several, I think 6 or 7 different instances tried it. Mr. Lewis is not on trial for any of those projects. Were they bad? Yes, they were. And he admitted to it. They were bad. But he is not on trial for the events that occurred prior to March 28, 2020. The charges that he's on charge for those charges in that indictment. You are to consider the evidence for the case before you. Those projects, they weren't charged by the state. The state didn't charge those crimes against Mr. Lewis. The state didn't present those charges to the grand jury. The only charges that they presented against Mr. Lewis are those that out. Let's go to our next witness, the Lorante Lewis, his brother, Mr. Lewis's brother. Lorante tells us that he lived at times with Mr. Lewis, Gabby, at Ebb Ashburn. That's the house that Mr. Lewis had built for his family. He told us about the relationship that there was at one something. It seemed normal to him. You know, all of them lived the same time, lived at the home at the same time. That he's witnessed their relationship, he's witnessed the love from his mom. He told us that you know, there was some instances that they would have disagreements, but nothing too alarming. We have Ms. Winifred Gore, Gabrielle too. Now, Ms. Gore, she took the stand, and she told us, Lamonte was running up the hill, and he was pointing a gun at Gabby. And I asked him, "But did you let her in?" He said, "Did you open it quickly?" I said, "She jumped in quickly." "Yes." "Was it dark?" "Yes." I said, "And you still saw what you narrated?" "Yes." As fast as she said she opened the door, she still narrated. And I said, "Did she remember telling the police that?" And she did. When she was interviewed by Detective, now Lieutenant Moss, what did she tell her? She never told Lieutenant Moss that, he chased her with a gun and he was about to shoot. She didn't say that. She said that once she took the stand, or why? So that she can fit it into the state's name. She was proud. Gabby took the stand. And I'm only gonna mention Gabby briefly and then we're gonna come back. But Gabby was asked on stand, was there anything that he said to you afterwards? And she said no. And the state asked again. She said no. The state wanted her to say, he chased her with a gun. But she didn't say it from the stand. The sister said it. Why? She wasn't going to get up here and lie. She did a police report. Maybe the sister said, she got Detective Moss on here, the prosecutor asked her, she said, well, that's what she said in the police report. But then, that wasn't evidence. Her getting on the stand and answering, what did he do? What did he say after he started shooting? She said, no. That testimony that comes from that witness stand that the state told you to believe it. This is the victim herself saying that he said no. After he started shooting into the vehicle, or Mr. Davenport shooting. LaWanda Gore, Gabby's mother. Now, obvious that Ms. Gore did like him look loose. Why? We heard a testimony that she moved here from South Carolina with just she and her girl. That's all it's ever been. She and her girl. Gabrielle found a man, young man. Mr. Lewis was just 21 when they met. And everything that we heard that Mr. Lewis built and he worked hard for to provide, this is a young man doing it. Keep that in mind. we have Mr. Lewis taking care of LaWanda's daughter. LaWanda sees that, oh, they're getting serious. Maybe Gabby's starting to, listen to Lamonte a little more. She's losing her control down. Because all of them are getting to see Gabby and Winifred. But now Gabby's met Lamonte, a man who not only taking care of the son that he had with his room, but he started providing for the son that he didn't have biologically with his school. Someone else in check. He stepped up to the plate. 4660 Diane Drive. Miss LaWanda Gore owned that home. She testified on stand that at some point, Mr. Lewis moved into her home. Now, I'll submit to you, if Mr. Lewis was such a bad person, do you think she really would have let him move into that home? Absolutely not. He wouldn't have been anywhere close. He would have had been only to come and visit, but to live, absolutely not. And then we have Kaylin CJ, then play cousin, Mr. Jackson. One who was at the incident scene that night, who left, who never called the police. Whom, when he took the stand, he didn't really remember, forgot all about the video or recording or the interview that he had with Detective King. Y'all didn't hear from Detective King. Now, I'm gonna go back to what Ms. Black told you in opening. She said, pay close attention to the evidence that you don't hear. Now, Detective King, we know, interviewed an eyewitness. This is a murder case. You didn't hear from Detective King. You didn't see the video interview from Detective King. Now, this is, as I said, this is a murder case. The detective who interviewed the eyewitness is always shown. Now, why do you think that the state didn't show you that video? Because the statements that CJ gave to Detective King days after the 3/28/2020 incident, it was in favor of Mr. Lewis. They talked about the Chevron gas station on the 22nd. He got on this when the state called him on direct. What did he say? Oh, Mr. Lewis didn't speak to him. Oh, but what did he tell Detective King early on when this incident and all his memories fresh on his mind? He says, Mr. Lewis, when he arrives to the gas station, he steps out and he speaks to Mr. Davenport and CJ. And he goes into the gas station. I asked him, did you see Mr. Lewis? I asked him again, do you recall telling Detective King that he got, oh yeah, I do remember. Every time I jogged his minute, he remembered. Do you know why? He wasn't proud. He brought him in there the day before the state told him what to say, get up there. Guess what? About this thing that he did with Detective King. But you didn't get to see. But I had to bring up on cross-exam. The thing about why you didn't see that video. From the detective who talked to the eyewitness. Then we get to Gabrielle Moore. Lover, mother of the child. Ms. Gore took the stand. And she explained that the relationship between she and Montez for years, on and off, on and off, on and off. First couple of years, magic. Her testimony that sometime after the Lamont second child was born, and the argument started to rise. Drama started to increase. They started to break it up, get together, breaking up, to get together. This relationship was fiery. It was spicy. It was rage. It was passion. Fire, gasoline, fire, gasoline. And that may not be the relationships we are accustomed to. But as she told you, that was the nature of their relationship. Now you have Ms. LaWanda Gore was like, oh, my daughter wanted to read. And I said, oh, she wanted to read. She could read. They tell you, oh, she's too scared to leave. She's not too scared to call the police when he's threatening her or abusing her. She's not scared to reach out to help. She wasn't scared of Lamonte. Miss Clark asked her on cross. She told you about some heated the events that took place during their relationship. The abuse. We didn't run from anything. In fact, in open, we told you. We took claim for everything that had occurred in the case before you, and even those prior differences that the state presented to you, so that you not convict him based on the evidence in the case before you, but you consider those prior differences. Oh, if he did act like this before, oh, maybe he was trying to kill. Or maybe he did intentionally kill Mr. Davenport. He did not. Gabrielle says on that day, Mr. Lewis didn't know that she was with Mr. Davenport. She tells Investigator Moss in the interview, and Investigator Moss, we'll get to Investigator Moss. She tells Investigator Moss in that interview, what? Me and Lamonte, no, me and the Davenport started dating in December of 2019. Me and Lamonte broke up January 2020.
Yeah, both of them.
I'm not smart as that world, but it would appear to me that if I'm still dating Lamonte in December of 2019, I start to talk to another gentleman I'm having relations with while I'm still with Lamonte. That's infidelity. So we hear these claims from Lamonte when he's on the stand that, oh, she was cheating. The state said they weren't together. Oh, but they weren't. Gabrielle didn't deny that. She didn't deny. She did not say we were on and off, and she even stated that. Even when they were off, they still operated as a couple. Still went out to dinner, they still co-parented, they still lived together off and on, still had relations. Everything that a couple is still doing. We get to Investigator Moss, now Lieutenant Moss. Lieutenant Moss comes in. She's the lead detective on the stage. And she takes that seat. And I'm going to touch on what she said on the record. I think it goes straight to cross. And I asked her, if you can remember, the state on the record was asking her to look at certain text messages. Cherry pick certain text messages to show her. Because she didn't even see the messages until the day she was supposed to take the stand. Now we're talking about the lead detective on the case who wasn't familiar. Text messages that she had her assistant on. And we went through those text messages. And if you can remember, some of the text messages I told her to pull, the state didn't hand it to. So we had to pull them up. You know why the state didn't hand those text messages? You know why the state didn't have a point them out? Because it was evident that Martin and Gabby still in the nation. Now I mentioned one text message, it's just for one, March 27, 2020, the day before the incident. That night, I love you. Then the next day, you act like what is that? And this is what she did often. He would give more and more, not because to control her, because he felt like what he did wasn't satisfying, and all he wanted to do was please her. But enough, it was never enough. And all she did was string him along. Every time she wanted to go off and see somebody else, we're not together. But then you see her coming back, and they making plans to go to dinner. They making plans to meet up and have sex. We're not together. Because that's what she told him every time she wanted to sneak off to do whatever. But when she wanted money, she wanted to be taken care of. She called Mr. Lewis. And she know he'd come running. Anything to make sure she was happy. Anything to make sure that she was happy. She took advantage of it. And I'm not putting the blame on her because Mr. Lewis takes full responsibility for what he said. Y'all didn't have to get up here and figure out who did what mistake is alleged. He admitted it to. He didn't have to take that stand. We don't have to put on evidence. We don't have to put on any evidence. He could have sat there all week and said nothing. But he took that stand because he wanted you to hear your story. He wanted you to hear your story. He didn't want that story to just be told by the state. He didn't want that story to just be told by the witnesses at the stand. Because that wasn't the truth. He wanted to get up there and let you
The movie sound like movie.
And what did he say? He didn't know that before. March 28th, he didn't know that Davenport, that Gabrielle was young. And he arrived that night. He didn't know it was Gavin Davenport sitting in that white truck. They must say, oh, he came. He came to kill. Because he had a gun on him. Well, we had testimony that Mr. Lamont Lewis always carried a gun.
He always had the gun.
In fact, he would have got his gun license soon after her first baby daddy attacked him for being a father to the son that he wasn't taking care of. Oh, he had money. He had this. He had so much power over Gabby. She was vulnerable. He knew she was vulnerable. Yeah. And he didn't play on her. He didn't want to control her.
What's up?
Did he want her to do right? Did he want to know at all times how his kids were doing when they wasn't with him? Yeah. He may have wanted to know his location because guess what? He and Gabby knew the nature of their relationship. They knew each other's weaknesses. They knew each other's strengths. And one thing that we can learn from this trial and the testimony from both of them is that they abused and they aimed each other. They crushed each other, but they knew what.
Stop coughing in the phone on the mic. Turn your mic off.
And we get to Rosenberg, the domestic violence expert who paid $500 to testify, who only I would say employee or a contract that she had with this attorney. She had this company, but nobody else was calling her to be an expert with. Just the state of Georgia, for whom she's worked for,
No.
told us that she was victim advocate, or maybe Maria Washington's case. Then Ms. Slack asked her, you said you've counseled over 10 to 20,000 people. And out of all those people, now mind you, that's a lot, right? 10 to 20. But out of all those people, there was never one relationship where abuse came from both sides. I find that hard to believe. And because she's paid by the state, doesn't have any other income through that bit, who pays her to come and testify, I'll submit to you that testimony that she gave, you need to just stay there. Block it out. It's not believable. Credibility is an issue.
You silly.
Let's get to Mr. Lewis, who took the stand, even though it didn't, even though it could have been against his, he didn't go. He got up there because he wanted you to know the truth. He didn't want to hide anymore.
Yeah, because
He's had 5 years.
he even told about the gun that belonged to the guy.
Those tears that he cried from that seat, those were real tears. It wasn't to get sympathy from you. He's been crying sitting there all week. Send those pictures of Mr. Davenport. Hurting. Because he knows the family is hurt. When he arrived that night at 4660, he didn't come to kill anyone. He didn't have plans to kill Jamari Davenport. Jamari Davenport on the night of March 28, 2020 was riding in white Silverado, a rental that we heard from CJ on the stand that he had granted to go to Thompson. The day that Mr. Lewis saw CJ and Mr. Davenport at the gas station, they were inside of an avalanche. Now, March 28, 2020, when Mr. Lewis pulled up to the home, not an avalanche in the driveway. He didn't know that the burgundy vehicle Pontiac that picked up from Thompson was a CJ. He didn't come to kill anyone. Did he come with a gun? Guess what? He always carried it. And the prosecutor tells you that he comes, and 2 seconds later, he just started shooting. He walked from behind the car to the right side, passenger side of the truck. He didn't walk up to the truck. He didn't come. Who was in that truck? That was not, he did not intend to walk up that truck. He walked into that truck and do what he did. He walked behind the truck. He was going towards that room. If he was coming to kill whoever Gabby was with, why would he walk straight up to the driver's side window to take him out? Or why would he walking up? Why did he walk up shooting? If he came to kill. And I submit to you that he did not. Now, all that day they tell you, oh, he's been texting, calling, she was mad, like, where you at? You know, you heard him say that he was called. He called it several times, he was texting. But also because guess what? Haven needed an asthma treatment. He had asthma. And so she was calling Gabby, like, where are you at? You know, Haven's having an asthma attack. Your mom is having asthma issues, need a breathing treatment. Your mom doesn't even know where you are. Where are you? And maybe he did want to know for his own concerns too, because listen, this is his lady. This is his lover. I'm texting my fiance every day. I mean, if I'm texting her because I haven't heard from her all day, listen, I have the right to do so. I'm concerned. Not a crime. It's not control, not power, not manipulation.
You've been up there a long time.
It tells you that knowledge will be formed in a moment of time. He comes up, see a woman's activity. He sees a man. Now he's already having his thought that she's been cheating because she acts active. So the thought, even from that, for that reason, they were valid because we heard Gabby from this seat say what? She started talking to Davenport in December 2019. Her and Lamonte broke up in 2020. Now,
That's 2 men at the same time.
you decide what you will with that information. But for me, I mean, she told you herself. They want you to listen to the evidence. They want you to listen to the people testifying from that seat. Listen to Gabby. Listen to what Gabby told you. Now, Mr. Lewis, he faces serious charges. And the state, in charge of him, he just made a pot of gumbo crime. We got to get him with something. So this charge him with that charge. Even though the evidence they had, it didn't support the indictment. But what is shown, and what has been shown in this case, is evidence that voluntary manslaughter is the proper charge for this case. Now, we're not asking y'all to, send him home. He didn't do it. No, we're telling you, he did something. He committed a crime. But the crime for which he committed is voluntary manslaughter. That at the moment's time when he saw his lady, the love of his life, step out that truck with a moment, he lost it. Rage, passion overcame him. And he lost it. And he told you he regret that day. For 5 years, he told you that he had sat in the cell, he had time to think. And he is sorry. Monte asked she asked, well, when did you rehearse that testimony? She's like, 2 days ago when I'm talking about this stuff. He didn't have a plan to testify. And honestly, defense attorneys, a lot of times, we're kind of hesitant to allow a lot of clients to testify because sometimes we may not know what comes out at this scene. Now, I'll be honest with you. I was a little nervous when he testified. And even after he testified, I was a little upset maybe because I heard some truth I hadn't heard. But you know, Monte has to deal. He has to deal with the charge. Make his peace. And he sat up here and he told you something that even as his attorney, I'm probably going to advise again. He told y'all that he saw him moving, shot again, and he opened the door again, and he saw the light go out in his eye. I didn't know that. But he made peace. He made peace with God. And he chose to sit in that seat. Now, what I will tell you, that a conviction on the charges and an indictment against him would be a tragedy. Because the evidence doesn't support it. The evidence doesn't support a crime of murder,
Voice.
attempted murder, aggravated assault, felony murder, possession of a firearm during the commission of a felony, or criminal damage to property.
Stop that.
The evidence that was presented from this witness stand does not support the charges in the indictment. But what they do support, charge of voluntary manslaughter. Now, myself and Mr. Attorney Sarah Black had a proud opportunity to work. This is the last time when we sit, this is the last time we were here. After I finish, Black will come for a few moments to speech. But this is the last time. Now,
Come on. I'm trying to hear.
ladies and gentlemen, I'm asking you. You're tired. Did you uphold that oath? She told us on day one, that you would sit, you would listen to the evidence, you would listen to the jury, instructions by the judge, then you will file both and render the judgment. Based on the evidence in the case, the only just verdict is all fair. I had the one thing. I asked you when you ran it.
There she go whispering now. She keep going. Hey people. Hi y'all. Hi y'all in the chat. Hi y'all in the chat.
Are you sharing your screen?
They're gonna make-
Just what am I sharing the screen?
You gotta press the button.
If we could make sure Mr. Gardner is a co-host.
Yeah, he's able to.
Okay, there you go.
You just have to move up and down that. I mean, for now.
Yes, hey.
Jury, as Mr. Gardner just told you, this will be the last time you hear from us, then you'll hear from the state once more, and this will be yours. And I promise I'm not gonna get up here and belabor every point and everything that Mr. Gardner said. Really, my job today is to explain to you, I think, the most fundamental part. It is sort of the lens, the goggles, the glasses that you have to review all the evidence and to review the indictment and ultimately to make a decision in this case and to render a verdict in this case. And that is the most fundamental principle in our system, in the greatest system in the world. It's why I do what I do. I'm sure it's why the state does what they do. Probably why the judge serves the way the judge serves. And it's because we live in the greatest country in the world with the greatest system in the world. Now, in many other countries, they've got a system where they've got a not guilty, a guilty, and something called not proven. We don't have that. We just have not guilty and guilty. And sort of our not guilty encompasses that not proven. And the standard by which you are charged and to evaluate every single piece of evidence in every single count of this indictment is under the standard called beyond every and all reasonable doubt. And so what does that burden mean? What does that mean? I'm sure some of you watch crime shows, some of you not so much. You may hear things like shadow of a doubt. That's not our standard. Our standard is beyond each and every reasonable doubt. And so what does that mean? You can take a look here. I don't like Mr. Lewis. Maybe he did. Well, I saw him in a video where he's carrying a gun. His kids are there. I don't like that guy. Maybe he's guilty. Maybe he did a bad thing once, so maybe he did it in this case. That's not enough. I suspect. I don't know. He was texting her all day. So he must have been planning to do this. I think maybe that's enough. That's not enough. The standard is beyond every and all reasonable doubt. And that's where you have to look at what the evidence is and what the doubt is. And when we're talking about murder, we're talking about what the state's theory is here. What is the theory? Because I've heard an opening and in some of their evidence that Mr. Lewis was lying in wait. So then the argument is that he premeditated, he planned this, he came with two guns and he planned to shoot and kill everybody, presumably this board. But that's not consistent with the evidence. And so then what is it? Because the state also says he didn't know who was going to be there. He didn't know who was going to be there. There was evidence that came in phones or he was tracking her whereabouts, but there's no evidence of that. The reality is what you have in front of you and what's been submitted to you, what you can take back there and go through the evidence. Go through those text messages there when you saw we were calling out number page 100,007. There are 100,000 pages of records. These people like to text. I like to text. These people like to text Mr. Lewis and the score, and Mr. Davenport or Bobo. You'll see he's saved in her phone as Bobo. You'll see Mr. Lewis is saved in her phone as Woody or Big Woody. That's Mr. Lewis. Bobo is Mr. Davenport. And they're texting all day. They're now the evidence. They're not together. And they're saying, I love you. Good night, I love you. Which one is it? And that's important because when we're talking about voluntary manslaughter and what he saw and why he did what he did, Mr. Lewis, they were in a relationship. That's what the evidence is. They're telling each other, I love you. Even Miss Gore, she admitted it to me on cross. They were texting. She was looking for cars at that month, days before this. She's texting him, hey, what do you think about this car? Oh, I got this one. Look at the grill on this car. Is this? They're talking, he gets a camera, she's into photography, and all of this is in the messages that you'll have with you to review. They're talking about photography, they're talking about her passions, they're talking about buying a house in the country. Now again, is this a healthy relationship? Absolutely not. And I think Mr. Lewis, having had 5 years to sit in a jail, and he told you that, would tell you again, not healthy. But this is what they did. These were two young people madly in love, and it was a fiery, toxic relationship, but this was their normal. So if they say, oh, F you, or we're not together, or this or that, and then 2 minutes later it's I love you, and hey baby, this. What is it?
Crazy relationship.
Now, reasonable doubt. When we talk about some of the things that we heard Gabby say, and this is not at all, let me be clear, this is not at all to blame Gabrielle Gore for what happened. That's not our defense. That has never been our defense. And you said some of the questions that I had to ask for on cross were hard questions that we have to ask them. Some of the things that we got out, she said she was not dating Bobo. She was not dating Mr. Davenport, but we just know, and I don't know why she didn't want to be honest about that, and that's her prerogative. But the reality is she was dating Mr. Davenport. We showed you a text message, and we're not doing that to be crass, but again, he is on trial for murder, the most serious charge in our country. And so we had to show you a text where she's talking to Bobo the night before, or the day, I think it was the 25th, so a couple days before. Go through the message. And he's saying in a group text with her and CJ, and CJ was the witness that we saw. He was there that night. He went to Thompson, Georgia, 3 of them. And he's telling their business. Gabby came fast last night. We're all adults here. We know what that means.
Ew.
They were dating. Okay.
Ew.
And that just is what it is. Or they were intimate, whatever talking, whatever it is. I think
That's
CJ.
disgusting. We don't hear that.
Why would she admit that? I don't know. But that just goes to show you, not everything is all black or white. Not everything is all good or bad. So again, even in some of this, we heard about 7 different or 6 different prior difficulties is what the law calls them, prior difficulties. Back and forth. We heard about a lot of them with Mr. Lewis being the aggressor and the abuser. And let's be clear, he was, and he admitted to it. And again, he's not on trial for that. So when we talk about reasonable doubt, guilty most likely, possibly guilty, probably guilty. He was, did all of these things to her before, so he must have done it again. That is not the standard. It is in this indictment and that indictment number that you have been charged as the jurors with to make that decision.
Yeah, this PowerPoint been used before, Doug, y'all. This PowerPoint been seen.
Let's talk about the Chevron gas station. Why did you hear about that?
It's a Fulton County PowerPoint.
All we heard is that there was some incident that happened at the Chevron gas station close in time to March 28th of 2020, and we heard that our client showed up. Why did they tell us about that? Nothing else about it. Well, I submit to you, it's one of those things that their state is trying to backdoor in, just like some of these prior difficulties, to say to you, he was tracking her location, or he wouldn't let her live, or he was controlling her. We know nothing more about, was he invited to be there? We did hear that was where everybody went to go hang out. It wasn't a secret place. It wasn't some underground place where how would you know she was there? This in their neighborhood, these are 19, 20-year-old kids during the beginning stages of COVID when the world is shut down. And we're all just at home with nothing really else to do. But we didn't, so why did you hear about that? Is it to confuse you? Is it to say, oh, he's tracking her? We don't know. Proof beyond a reasonable doubt. You heard the state say to you, consciousness of guilt. He threw away the gun. That's what a guilty person will do. Well, the reality is, I have to say that to you. He'd had 5 years in the jail to come up with some great story as to why he did what he did. When shocking things happen, we do dumb things. It's the same reason why CJ saw this happen, backed out, and didn't call the police. We're not saying CJ's guilty, or CJ, what did he do? He called, I can't remember who he said he called, but I think it was a friend or somebody. I think it was Mr. Davenport's family member. He didn't call 911. It's not probably the best thing to do, but the reality is, Mr. Lewis panicked and got rid of that. Again, we're not here saying that he didn't shoot Mr. Davenport. But if we're talking about consciousness of guilt, what about the other things he did? We saw the car in his garage. The state, I think, investigator Weathers wanted to say, well, his garage door was closed. Is that an insinuation somehow that he's hiding it? There was blood all on the handle of that car. He had 2 days. The search was on March 30th of 2020, 48 hours later. Mr. Lewis had 2 days to wipe that car down if that's what he was going to do. He had 2 days to get the car fixed or to paint the burgundy just streak across his car. He didn't do that. The evidence, he didn't hide the car. They found the gun and the gun receipt in his house. Again, he didn't get rid of that. He could have gotten rid of it. He didn't. All we have heard and what the evidence is that he did what he knew that he could do, which was, I need him returned. I need to get turned in. And that's what he did. He gave him days later. Let's talk about this criminal attempt charge. Because you've heard us say, this is a voluntary manslaughter case, and we submit to you that this is a voluntary manslaughter case. I want to talk to you about the criminal attempt to commit murder. Because the reality is the evidence that has been submitted to you in this case, there is no evidence that Mr. Lewis was going to or even tried to kill and shoot Gabrielle. The reality is that if that was what he was going to do, and that was on his mind as he was lying in wait and planned to do this, there was a moment, you saw the video, and again, if you guys want to watch that video again, I don't know that it'll go back there with you, but if you want to see it, send us a note, and we'll come out and you can watch it 100 times, whatever you need to watch, but that's something you'll be able to do. But watch it again, because you'll see when he gets out of the car, there's a moment where she's just in direct line of him. I mean, almost parallel to him. If he wanted to shoot her, that was when he would have done it. And if he didn't shoot her then, the reality is too, I mean, there are theories that he went to the car and grabs another gun, which that's not what he told you. But even if you don't believe that, I mean, he's got 2 guns now on him. When he goes to the door, why is he not shooting? Why is he not pounding on the door? Why is he not trying to break in the door? Even Gabrielle's mom said, no, he didn't pound on the door. He just kind of stood there. Which is consistent with someone losing it and like, what did I do? There's no evidence of a criminal attempt to commit murder. You'll also be charged, there'll be a charge in the law that you get on abandonment. And to the extent you think that he was going to shoot her, you're also allowed to abandon criminal activity. And so even if you think that he was going to shoot her, at some point he obviously decided, I'm not going to do that. And it's not what the state's going to get up here in just a few minutes and tell you, oh, well, he didn't do it because the door was closed. I mean, it's a thin wooden door. This man's got apparently multiple guns. He's a big guy. If he wanted to get in that door and wanted to continue harm, that's just something we have to be honest about. So please read the charge and abandonment on the big charge. I don't want you to forget the burden of proof. Like I said, it's the most important thing in this case. It's not probably, it's not possibly, it's not most likely. It's proof beyond every and all reasonable doubt. And you have to look at that for each charge. You all are allowed to disagree on what you think is proof beyond a reasonable doubt. You don't all have to agree that it's the same thing. It can be one thing for one of you and another for another. I urge you to deliberate. I urge you to talk about this. I urge you to listen to each other, but I also urge you that if you feel strongly about something, you're also allowed to say, this is what I believe the evidence showed, because each and every single one of you have been picked hand selected by us to determine the outcome in this case. And thank you so much for your time.
State. We can hear y'all. We can absolutely hear y'all. Yeah, we can hear y'all.
Ladies and gentlemen, quite frankly, I'm offended. I'm offended because this defense attorney got up here and approached you, addressed you, and misrepresented the evidence. The state does not want you to look at the defendant as a menace, and therefore he's guilty. The state wants you to apply the law. The state wants you to look at the facts, look at all of the circumstances in this case, look at the evidence, and then come to a decision as to what is true, what speaks truth to the charges in this case. The state wants you to consider not the speculation, misdirection, and red herrings that the defense has just got up there and told you. The state wants you to focus on what is objectively true. And we're going to talk about what is objectively true in this case. I urge you not to fall for the red herring of blaming Gabrielle. That is not why you're here. Gabrielle is not on trial. Lamonte Lewis is on trial. Don't fall for the red herring that something in him just broke. That is not what happened in this case.
What?
The defendant chose to confront Gabrielle, not because he just suddenly came upon her with somebody else. He went there to confront her. He went there armed to do exactly what he did. He didn't know the name of the person inside of that vehicle. He didn't know the sex of the person inside the vehicle. All he knew is that she was with someone else. He did not know whom, and he was going to do something about it. Now, in his mind, he's thinking, well, she must be with another man. And whoever that poor man turned out to be, they were going to get it back. He went hunting for answers, hunting for Gabrielle.
Uh-oh, she messed up her PowerPoint. Uh-oh, her PowerPoint don't work out. What happened? Look at the lady in the seat, y'all. She twirling her too. Oh, she told us to hold on. Look at that. Look at that lady in the seat. Look at that lady in the seat.
Let's discuss the defense's case. Just now they gave you a lot of stuff, so I'm going to call it. All of the witnesses that were interviewed in this case by detectives, they were interviewed and they were interviewed audio and video. You saw no videos of any witnesses, yet defense counsel wants to infer and insinuate to you, well, the reason why you didn't see the video of CJ is because we have something to hide. We do not, and defense counsel knows this. In trials, we don't play the videos of the witnesses when they're investigated by the detectives. They testify themselves. Defense counsel knows that. That is a mistake.
Yeah, that's not true. They did it on
Defense counsel says, well, you didn't hear from Detective King, so what are they hiding? What he failed to tell you is that defense counsel of the state stipulated to Detective King's testimony, because what he did with CJ was a photo lineup, and that's going to come back with you. The photo lineup is simply where he sat with CJ and gave him what's called
no,
six
they
facts.
showed.
There's six people who look very similar.
I'm sorry.
And you pick out who it is that you saw shoot.
Let me show
And
you.
he took the photo and says, this is the man I saw shoot, and that person is Lamonte Lewis. And that is in evidence because it was stipulated to. So we're not hiding Detective King. That is a misdirection by the defense attorneys. They tell you, well, LaWanda Gore hates the defendant, she doesn't like him, and so she has an axe to grind. So when she gets on the stand and tells you he's not welcome to her house, it's because she has a motive. Well, Ms. Gore told you what happened. In the beginning, he was welcome to her home, but she noticed his jealous streak. She noticed his meanness. She noticed when he would get angry, he would take things back that he bought for the kids. When he got angry, he would walk away, and then he would bring it back when things got back good. And she says in her home, she's not going to put up with it. Yes, they're kids and they're still young, but she didn't want that back and forth tension in her home.
Oh, did
And so after 2019, he was no longer welcome. That has nothing to do with whether she likes him or hates him. That is all about ensuring the sanctity of her home and ensuring that in her home, she can enjoy the peacefulness of the house that she pays for. She doesn't have to give the defendant comfort to abuse her daughter in her presence. Take that elsewhere. That's what they're determined to do. She doesn't want that in her house. Then they talk to you about, well, we gave you all the prior difficulties, and that's because we wanted to say he did it before, so he's going to do it again. That is simply not true. We tell you these things because we're trying to give you insight into the relationship. Understand why Gabby would react the way she does. Understand why the text messages would say the things they say. Understand that push and pull constantly. It's a cycle. Rosa James explains it. It starts with the honeymoon phase, the tension building, the reconciliation, and it goes back into the honeymoon phase. It is a push and pull constantly. And Rosa James didn't testify because she was paid. Rosa James testified because she's one of the experts in our county who deals exclusively with this type of circumstances.
But
She testified, and she testifies both for the state and the public defender's office. Either side, whoever needs her assistance, whoever requests for her to give an opinion on a case.
And
She
whoever
has
sees a
no
balloon.
knowledge of the case beforehand. She has no knowledge of the investigation beforehand. She simply comes to the stand, and whoever asks her hypothetical questions, she gives it based on her experience, based on her training, and based on what she has observed with the demonstratives that we showed you, the power and control wheel, and how that behavior fits. If it doesn't fit, she will tell you. If it fits, she also tells you. There's nothing nefarious about the fact she gets paid. Every expert gets paid. Defense knows that. But they're trying to muddy the waters and have you look the other way.
What's wrong with her thing? She don't know how to control that thing.
Winifred and Gabby's statements were entirely consistent with what they told law enforcement. Again, defense counsel is having you look the other way. Lieutenant Moss is a seasoned officer. She would not have taken out warrants for criminal attempt with testimony invented during trial. The only reason these warrants were taken out is because the testimony they gave in court matched what they said in 2020, that he absolutely was chasing her. He absolutely retrieved the second handgun, and he absolutely said, "You're next." Just because he gets to the door is closed, there's a house full of people, he doesn't shoot, and defense counsel wants you to say, well, no big deal. All of the steps he took to put Gabrielle in fear of losing her house that night, all of the steps he took. We heard the 911 call. You heard LaWanda Gore's anguished cries on the call. He's gonna kill my daughter. He was gonna kill both of them. That was their understanding that night. And while they were trying to render aid to Jamari, another car pulled up and they testified. They all fled back into the house. They were scared he was going to come back to finish the job. He didn't abandon, he just failed to execute. And they tell you about the text messages. Well, we didn't show you everything because we're trying to hide something. And again, that is simply not true. We focused on text messages leading in the hours leading up to this incident because they give insight to what was building in Lamonte. And we'll look at those again.
No, that's not true. Come on now.
You heard testimony that
no lies on that.
there is an on-again period and an off-again period, but who initiates the on? Lamonte. He plans dates, outings, trips for the kids because he knows Gabrielle loves her children. So he uses the children to get to Gabrielle. He positions himself as the provider to get to Gabrielle because Gabrielle wants to move on and she's tried to move on multiple times. He keeps pulling her back because he thinks by virtue of the money he makes, by virtue of the fact he's on the lease in his apartment, he has more than Gabrielle. So he can impose on Gabrielle and tell her, he testified, I see her potential. She doesn't see her potential. I see it. So I'm going to mold her into the woman I want her to be. Ignoring completely what Gabrielle wants. And for her own vulnerabilities, time and again, she falls for it. And they go back to that cycle. CJ did not forget what he told law enforcement about the Cascade incident. In fact, again, there's more misdirection. What was the Cascade incident? What was the purpose of that? It happened prior to this. CJ's testified in 2025 for an incident that happened years ago. He's not gonna remember verbatim everything that he told officers.
Oh, so we're
What
making
he didn't
excuses
say, I
for
didn't
everything
say, he
that
says, I
happened.
don't recall. CJ is not practiced. He's remembering things from 4 years ago. And the casket incident is important because it tells us more about the nature of the relationship. Defense counsel said, well, we don't know if he was invited. Well, yes, we do. He was not invited because when Gabrielle saw him, she ducked. She didn't go say, hey, what's up?
Why did she
CJ
duck?
testified and
Why did she
Gabrielle
duck? 'Cause she was
testified. They
hiding.
were looking at him from a distance and he's circling around. He walks past, Jamari doesn't say anything, but he's looking. He's looking for Gabrielle. And she doesn't want to engage with him. So she hides from him. But nothing happens that day. But again, it tells you the flavor of the relationship at that time. Defendant testified because he wanted to tell a story he'd been rehearsing for a couple of years now. And, he says, I had no plans to kill Jamari. I don't know what happened. I just came. What did he say? Oh, yeah, I came to bring back the Nintendo Switch.
He said snap.
Very important at 9:24 at night to bring back a Nintendo Switch for a 2-year-old. Critically important. Couldn't wait till the next day.
He said
But defense wants you to look at the evidence and say, well, we don't know what happened, so we just throw all kinds of charges at him because we don't know what to make stick. That is just not true.
Come on.
The job of the state is to seek and do justice, and that means charging a defendant with every crime.
Lady,
that he did.
Yes.
We don't have to go either or to please the defense. Well, could it be manslaughter? Maybe. Could it be that? We don't have to cherry pick. We're saying he did all of those things because he did.
Yeah. You guys are funny in this chat.
When he came to that door, he admits that he saw the light go out of Jamari's eyes. How could he have seen that? Because if you check the video, he shoots, goes off camera, he's running back to his car, he's coming back, he goes back to the front door. So I submit to you, as he's going back to his car, not on video, Jamari's there and he's probably moaning in pain. And so he goes into the vehicle. And that's the only way you could see it. But why would you go into the vehicle? He just killed a man and you just did it because you were suddenly provoked and you panic. So you spend time with the body before you move away.
He said
Gabrielle admitted that she was talking to Jamari, and she admitted that there was some overlay in the time when she disconnected from the defendant and started to really engage with Jamari. She said they had not yet started a formal relationship, as we say, this is my girl, this is my boy. They weren't there yet. They were in the initial talking stages, and that's consistent with everything she's told law enforcement. It is consistent with what she testified to. The defense is trying to make you think that she lied, that she was not with Jamari, that is simply not true.
You just said it before. I'm confused. She said
when they went to Ebb Circle, Laurente testified when he came to the house that night, 2 things he observed. The car was not outside, but the front door to Ebb Circle was wide open. He called out to his brother, didn't get a response, and that was unusual. That door was wide open. He got back home, dropped the guns, and booked it. Hit the car, and it was gone. When he was gone, in those 2 days, he figured out what he wanted to do. But he didn't stay at his house. He left it. So there was no time to clean up the car and get rid of blood. He wasn't there because he didn't even realize he had left the blood because he parked there so quickly and left so quickly because he doesn't want them officers to come find him that night. He is gone.
He came to the station and turned himself in with the attorney.
So they say as well, defense counsel, well, he didn't shoot her, so maybe he didn't attempt to kill her. So we have to wait until he shoots and misses to charge an attempted murder. That is not what the law authorizes. That's what defense would like, but that is not what the law says. And your duty is to apply the law to the evidence. So just because he didn't pound, he didn't do it because it's a house full of people. Gabby's no longer within
contradicting
reach.
herself now.
Jamari's dead. So now he has to configure, what do I do next? So now he goes into self-preservation mode.
I'm sorry, y'all. I was on her side
gotta
for a
go,
minute, but
Dodge.
now she
I gotta
got
go.
lost.
Until he can find a spot where no one's gonna expect him to be and figure out what his next steps would be. And that's what he did. And he threw the gun away. And then they tell you, well, you know, Gabby must have been cheating, and when she was cheating, he saw it, he found her, and then that authorized him to become so enraged and passionate, and that is what caused him to snap, and so he's only guilty of manslaughter. I submit to you that is not the law. The law says, in cases where there's an intimate partner relationship, and you come upon your partner in a situation where you have reason to believe they're being sexually unfaithful, and you come upon it without, at the time,
She can't
doesn't
even
have to be
know
at the
right.
time. If it was recently that you learned, you thought maybe they were cheating, and then
They
at
were
the time you
cheating.
see them cheating with the person you suspected, that may be voluntary manslaughter.
She
But in this
cheating.
case, we look at the video,
She was
and
cheating
all we see is Gabrielle exiting a truck.
with the man at night. Won't answer the phone. That's
In a
cheating.
dark corner somewhere. He had no prior knowledge. No one told him, hey, I saw Gabby and Jamari ducked up in the corner 2 weeks ago. I think they're dating. He knew she was dating other men because they had broken up.
No, they didn't.
In fact, in the messages, he tells her, I want to meet this nigga. Why would you want to meet the N-word of your girl that you're still in a relationship with? It doesn't make sense. What makes sense is they were broken up and they both knew it. What makes sense is he knew she had moved on, but he needed
She
to
didn't move
approve of it.
on, lady. She
I want
didn't
to meet this
move
guy.
on.
Why can't I meet this guy? What are you hiding? She's hiding her business. She doesn't owe him any answers at that point in the relationship.
See,
She's moved on and is trying to move on with Jamari, but he is not done yet.
What?
Simply put, ladies and gentlemen, the law does not authorize you to shoot and kill a man in cold blood because you see him talking or dropping off your girlfriend. That is just the bottom line of this case. Take it all around, take it all the other layers away. That is the bottom line.
Oh, geez.
Lamonte was not a man in love. Lamonte was a man obsessed with his own self-importance. Lamonte was obsessed with his own self-worth. The money, the house, the cars, the good job. He thought he was the bee's knees, and she, she should be grateful. He's even giving her any attention. And how dare her try to hide from him? Who does she think she is? Lamonte was jealous. Lamonte was a control freak. He was vengeful. If he wasn't gonna have her, nobody was gonna have
That's not true because he would
her.
have
She was
killed her.
always gonna have problems with him.
He was
no
going to kill
matter
her first.
who it was, until he got good and ready to move on. He was manipulative. He didn't know that there was a video. Because you see, his daughter testified, everyone in the house, but the squirrels had messed up with the wiring and the ring didn't work and all the cameras were not working. So, but for that video, we would have a whole different trial today.
Oh, Lord. Now we're talking about the video.
And he wants us to believe he loves Gabby so much. And when he goes to confront her, he doesn't just walk up to her and say, can we talk? What are you doing? Where have you been? He instantly unloads. 2 seconds, we all watch the video. Then Counselor keeps talking about provocation, passion, but what they're not telling you and they're glossing over is the law says that provocation has to be serious. It can't just be, I'm pissed. It has to be elevated. It has to be something that you see with your eyes, that you sense, that you touch. something that is tangible. Just seeing your girl exit in a truck, I submit to you, ladies and gentlemen.
Wait
that's
a minute, y'all.
Serious provocation, enough to justify the use of games.
She's not answering the phone. She said it's
There's time to talk,
voicemail.
to reflect, and time to reason. That is not voluntary manslaughter. They want you to believe that he talked to her. He said, hey, they're trying to get Cedar to give some statements. So if there's time to engage her like that, that's not a snap. That's, I'm not getting the answers I want, so I'm gonna do what I'm gonna do. And let's look at the evidence. This was never a justified
You're
trial.
funny. Oh my God, you're funny.
act. This was never a heat of passion.
He-
For the sake of the
She
children.
said it was not heat of
Delonte
passion, y'all.
And Gabrielle can't do communication. And you have all the records to go back if you need them, but I did a snapshot of what I thought was most relevant to the timing. If we look at a timeline, right around 5:52, she tells him, you question me like we still date. You try to control my life and any situations like we still date. That's on March 28th of 2020, about 4 hours before the incident. She's telling him, stop questioning me, leave me alone.
Huh?
And he responds a minute later, and you're right, bro, we're not together no more. So how can he then claim to be so caught up with Gabrielle that he couldn't stand the thought of seeing her enter the vehicle such that he could take that man's life? Then we go back through the whole slew of messages. At 6:15 p.m.,
She's
from Lamante, shaking my head. I asked you where you are. That's it. He's only focused on where she's at.
Wait, where's the message about her?
And he says, once I asked you that,
where that message?
Funny. This is around 6 o'clock that evening. At approximately the same time, she's texting her friends. Woody's acting stupid. Then she goes down, 6:33 approximately. Call Winnie and my mama, because he started telling her in between those text messages he wants to get the children. She's telling him, call Winnie and my mama. Then she tells her friends to make it seem like he was coming to get them, and he didn't. But he says he's coming back tomorrow. So the friend says, so he never went? She says, no, he didn't go to get them. So initially, when he wanted to get the children, he wanted to know where she was at. And she wouldn't tell him. She says, call my mom, go get the kids from them. He wasn't happy with that. So he didn't go get the children.
Wait a minute, but he did get the kids.
But as the evening progresses, he says, I don't care who you end up with. That's a man in a relationship? No. He knows, and he's confirming that they're not together. Then, a little while later, at 6:40 p.m., she texts her sister and says, he just DM'd me, said he finna come. So after a back and forth, he relents and says, I'm gonna go pick up the children. Her sister says, as he's coming to pick up the children, it's 6:42 p.m., Winnie tells Gabby, he gonna look at your location on Haven's tablet. Because she shared the location of the children through the tablet. And Gabrielle responds, I turned it off.
See,
So if he has the
turn
kids,
off.
he doesn't, and the location is off. He now doesn't know where Gabrielle is.
Why you turn the location off if he's not with you? If you're not together, why you turn the location off? See, she just gave something away on her own. Why would she turn the location off if he's not with her? She shouldn't care if he knows where he's at, where she's at.
All right, that's fine. All right, members of the jury, let us know when you're ready to resume.
Right, here.
See, yeah, answer this. If y'all not together, why would you care if he knows your location? I wouldn't care. He sees my location, all right. You see me, I'm all the way in another like 2 hours, 3 hours away. And why you gotta turn the location off? Because you already
Recess for about 5 minutes here.
she knew there was something going on between her and him still. That's why she turned the that's why she turned the location off. Because if this dude is not with you, why the heck would you care if he's looking at the location? You wouldn't care, right? That's what I'm saying. You wouldn't care if he knows your location if y'all not together. It can't be that little boy. This is that's 5 years ago. That little boy is big now.
He's gonna get it.
Oh, okay. Yeah, yeah. All right, let's go ahead and just put that on the record now then. They want to, no. They want to-
Oh, we're gonna.
Oh. Yeah, I'm leaving too. Okay. We'll come.
Let's get here.
Oh, from the head? JT funny. He said it's from the head, look like a little boy. Might be the same. But why is the location on the little boy's thing? Bottom line, the parenting arrangement, she should have made plans and advice. She wasn't going to be there if it was thought to be there. See, the prosecutor is not showing the part where she said, I'm going to give you some. That's gotta be funny, y'all. Remember, they broke up in March and she said, I'm going to give you some. Why is she not showing that part? I'm going to give you some in March while they not together. Because it supposedly broke up in January, right? Why are you still sleeping with the guy in March?
Okay.
I can't beat the leadership.
Oh, okay. So what is it that you're looking for?
Ain't working.
And then what day? So the other day, y'all, I called Dallas and said, Dallas, where you at? She said, Mom, you know my location. You got my location. I said, I don't look at that stuff. What I need to look at that stuff for? All I got to do is call you and ask you where you at. I won't need to look at no location.
Okay, good. Sounds good. She's like, I need to get.
If she used to track the kids with it when he was with them, she could have used it to track the defendant to invite drama. I mean, I see both sides. I always saw Switzerland. Yeah, it's two sides to it, y'all. Both of them was toxic. That's what we've been saying. I ain't on nobody's side. I just trying to figure out why the prosecutor told that lie, talking about they don't use interviews. Yes, they do. They did it all through YSL. That's all we kept interviews. Did we not see a whole bunch of interviews with the investigators and the person giving the interview? Why they didn't give that? Yeah, we are professional YouTube jurists. We don't. No, we're not part of this case. We all have our opinions.
They'll have, I mean, I know they're not gonna have 100,000 pages printed out. They're on a disc, so I think sometimes in cases like that, because of video, they're not gonna have the video like that. They want to review it. They have to come out here and ask them. So I think with examining the text, I think
We
this
got a
will
no
see
dog in the
come out,
fight. We
put
just
it up,
want to
put it
see
where they
fair,
want to
equal
see it, or other
justice.
dates
So far, we have.
they want to look at.
That's all we want. Fair, equal justice. They're cracking up back there, y'all.
What's that? 36. Okay. You can just add that, right? All right, ready to go on the record? Yeah, well, everyone's here. Oh, Mr. Lewis is here. Oh, Mr. Garner needs to come back. All right, let's go back on the record. I was asked by defense counsel to take something up while we're in between on a break from the state's closing. So, Mr. Gardner?
Yes, Your Honor. Your Honor, just based on what has come out in closing by the state, especially that civil cause of voluntary manslaughter and the definition of provocation and what's considered provocation. I know that the state, I just feel like that once they retire to the jury room, that, you know, they'll believe that if you have to catch someone in a sexual act for it to be provocation, and that's not the case.
Well,
We're
what's
talking about lay people who don't understand the law as we know it.
and I understand your concern. I'm curious what your notes show you the exact quote was, because that's
Ebony said that she said something to the effect that you gotta catch him in a sexual act. Next time it's ready, you don't understand how you gotta catch him having sex.
we can run it back, and I can try to get a I mean, we'll have to search for it, but that wasn't my understanding. There were a lot of like conditions of this, that's not what this is, that's not what this, and it seemed to be more in the way of argument to me.
Yeah.
The quote, you're still saying just that same quote from Alan.
The same quote, because I mean,
Yeah.
we have to.
But the other aspect here is a matter of procedure. After we've already agreed to well, I know with the reservations, but the charges have been finalized and we're in the middle of closings. It seems a bit out of the ordinary for me to start adding instructions that the parties may not have contemplated or addressed.
Yep.
No, I'm saying, sorry, but I don't know if you recall, but I requested, it was, you denied it.
I'm just thinking procedurally, wouldn't the proper course have been for you to object at the time the statements were made, and then we could remedy it if it was an issue?
Yeah, he should have objected.
There's no time.
He should have objected.
Objected, closing unless we referred and shifted or what they. And I guess I should have.
He should have objected when she said it.
I just did. I mean, I didn't.
You should have objected because she was out of order saying that.
Hearing something that may be true. So, I mean, it was just a matter of.
All right, let me turn it over to Ms. Charles. Ms. Charles, do you recall the extent of your quote? So if so, we can try to find it in the rough drafts of the transcript here.
If I'm wrong, I'll see.
Yeah.
My recollection is I referenced the law, I read parts of the law, and I said in various scenarios that would constitute serious provocation. It wasn't just sexual infidelity.
She did say sexual. She did say sexual, didn't she?
Which is correct. Prior information he would have had that would inform that what he saw was her being unfaithful. Whatever.
Play it back. Let the.
It was only sexual.
You did say sexual. I heard sexual. Didn't y'all hear sexual?
All right. Well, I'll see if I can find the language here just in a couple of minutes. Again, I just point back to the pattern charge, which, the jury will be referred to as the law, and we'll go back to them. And the voluntary manslaughter pattern does not tie itself down in any way. It just says you decide whether this is sufficient provocation.
Yep.
So as I took the state's argument, they're saying the facts at hand don't meet that standard. Not that as a matter of law, this could never.
No, she said law. The law.
But we'll see what we can find. So let's go off the record.
She said the
and
state. So she is.
I don't know if Ms. Smith, you can do a search for. I think it was like that's not manslaughter. Maybe a keyword. Or that's not voluntary manslaughter. I don't know if it was the full phrase.
He said if he's wrong.
Ms. Charles, how much time do you estimate you have remaining? Any idea? You've got an hour and 10 technically.
The better part of the hour.
All right.
Oh, well, I gotta go to the restroom.
Isn't that what you're just doing?
I mean, the family stopped me.
All right.
He said, wasn't that what you was doing?
I talk for
All right. Feel free to step out now if you need to. If you don't think you can last an hour, sure.
Kobe. Leave my socks alone, Kobe. Leave my socks alone, Kobe. I guess
Just play it if you want to. It's fine.
it's almost 12 o'clock, y'all.
You think you found it? Okay.
Oh, it's I could video.
I want to hear her say it. Shout out to Sylvia and Chad for getting the daily work. Yay, JT!
Without, what?
at the time, it doesn't have to be at the time. It was recently that she was already thought maybe they were cheating, and then at the time, see them cheating with the person he suspected, that may be voluntary manslaughter. But in this case, we look at the video and all we see is Gabrielle exiting a truck. She's not kissing anyone. She's not hugging anyone. She's not embracing anyone. They're in a dark corner somewhere. He had no prior knowledge. No one told him, hey, I saw Gabby and Jamari ducked up in the corner 2 weeks ago. I think they're dating. He knew she was dating other men because they had broken trust. In fact, in the messages, he tells her, I want some tea.
We're not back on the record yet, but Mr. Garner, was that the exact moment that you were referring
probably
to?
Before I didn't hear it though. I just
Okay. I think right where we started playing that, Ms. Smith, you can come read it if you want to, or even play that again.
Gotta start from the beginning.
Sometimes the words don't always come out perfectly, is what I'm saying.
If you find your partner in a situation where you have reason to believe they're being sexually unfaithful,
She said,
and you come upon it without, at the time, it doesn't have to be at the time. It was recently that you learned you thought maybe they were cheating, and if at the time see them cheating with the person you suspected, that's a assault. But it's not.
Ready? All right. Let me know when you're ready, Ms. Smith.
I have to connect again.
Yeah.
did I play it again?
All right, we're back on the record. I believe we had located the portion of the closing where we could play a recording, a playback. Council, I believe we both heard that. Mr. Garner, anything further you want to say for the record?
nothing further, Your Honor.
Do you stand by the request on these new grounds?
I mean, I think that the charges, and I forget too that these charges will be going back with it. And I look at the charge that's in the document, I think it's appropriate. Maybe I misheard. She said, but I think as long as we're sending this back to the commission.
All right, understood. And I'll just note as well that I didn't see in the language or at the time it occurred and based on a preliminary review that it made an explicit finding of law that was inaccurate in any way. This is not a words alone case regardless. And I think there's a reference to a situation and infidelity. So I think is encompassed everything here. And then setting aside the fact that I think if you do hear something definitive like that, that is one of those times you just got to stand up and interject.
Yeah, you have
and
to
we take it from
interject.
there. So with that, let's bring back the jury.
Yeah, you have to interject when you hear it, sir. Don't sit back and wait. That's what I like about this judge. He's fair.
But don't worry, I can't smell you. I can't smell you.
Last for the jury.
Rise for the jury. Everybody rise for the jury. You want me to open up the door for you? Okay, I'll open up the door for you.
Thank you, Deputy Scott. Members of the jury, just as a roadmap where we are, we'll resume the state's closing in just a moment here. And I'll just let you know that each side is allotted 2 hours for closings. So the state currently has at most about an hour and 10 minutes remaining. And from there, I then need to charge you on the law, which takes about 15 to 20 minutes. So my suggestion would be that we power through. But if anyone feels very strongly that they need some sustenance, feel free to make yourself heard. All right. So with that, Ms. Charles.
Thank you, Your Honor. Ladies and gentlemen, before we took the break, we were talking about why he took the kids that day. Earlier, he didn't want to have the children. But remember, she shares her location. And if you look at it when he's picking them up, he could care less with his two little boys behind him. He is fixated on that iPad because he wants to know her location. But it was one step ahead of him. She turned it off. This wasn't a good dad being, I'm gonna take my kids and look after them. This was a means to an end. Let's continue. 3:36 p.m., what do we have? Now we know he has the iPad. What did Gabrielle say? He messaged me through the phones, 2 phones. He FaceTimed me and also through Haven, which is the name of their child, iPad. He says, at approximately 3:36 p.m., do you know where the little boy's Lamont charger is? But it's from Haven Christopher at iCloud.com. Right here. He's using his son's device to contact her. She says, it's in the bag. I never took it out. Anything to get her to engage with him. It continues. After she says, it's in the bag, never took it out, he responds to her, oh, now you want to respond. After forwarding my calls, I just don't understand what you gotta hide. Crazy, you didn't even answer your son's FaceTime. Why is that? They continue. He's at 7:45 p.m. He says to her, IDKY, I don't know why you're trying to hide it from me, shaking my head, not even tripping on that shit. But I submit to you, he already started to trip. It was just building up. Then the message continues, we're about 8 p.m. Gabrielle, I thought you were going to be back at 8. If you're not going to be here anytime soon, please let me know. She responds, shaking my head, I'm still on the way back. Then we get to about 20 minutes just before the incident. We know he has dropped them back to the house by 9:20. How do we know this? At 9:27 p.m., he says, you told me you'd be back at 8. I've been calling you, bro. Shit, not even cool. Gabrielle, I dropped the kids off with Kanaya and weed. 9:27. And then we look at his phone records. What do they tell us? Approximately 20 minutes before he shows back up to the house, he is calling her back to back. These 12 calls, 6 of those calls, approximately 20 minutes before he shows up. And you can tell she's not answering because look at the length of the calls. 0.8 seconds, 0.02, 0.03, 0.06. She doesn't want to be bothered. He won't let it go. consecutive phone calls, back to back. And then defense says, well, he didn't go home. He was already there because he just dropped the kids off. Well, he did. He didn't go home, but he didn't leave the area. He went 2 miles down the road near Welcome Park. That's where he sat, waiting. And that's where the cell phone tower coordinates put it right at the time, at 21:24, on the night in question. He is at Welcome Park, round the corner from Gabby's house, waiting. And we look at the time the 911 call comes in at 21:40, wasn't very long after Jamari was dead. Ladies and gentlemen, there simply was no serious provocation to justify the death of Jamari Davenport that night. He was executed mercilessly, and Gabrielle was going to be next. He's walking up casually. He's not angry. And he told us he wasn't angry then. There is nothing going on. He's getting ready to leave. He's blocked in and he shoots. What in any of this interaction constitutes serious provocation such that this man has 16 entry wounds in his body? What? Besides the jealousy, anger, and rage of one person in this entire dynamic, one person, the defendant, Lamonte Lewis. And we know he meant to shoot to kill. Because let's look at this scenario. Gabby testified when she got on the passenger side, she was right in the intersection of the walkway to the front door. The truck is parked. And what does CST Green tell us? One of the first things he encounters is a gun holster at the bottom of the driveway. The only person with a gun at the bottom of the driveway was the defendant. So you are at the bottom of the driveway. You haven't seen anything yet, but you take your gun out of the holster. That is intent. Because when you take your gun out, I submit to you, you intend to use it. And he continues to walk up with the gun drawn. And then you see the cascade of casings right there. He came to execute a mission and he did it. He didn't care who it was. In his mind, he was clear. Gabrielle was with someone else. She wasn't responding. She had no right to do it. She's not responding to me. I can't control her. Who does she think she is? I'm going to make an example. I'm going to teach her. You don't play with me. And that's what he did, right there. And Gabrielle is standing right there where the star is approximately. She's telling you what's happening at the time. She's screaming ahead of, please stop. No, don't do it. Stop. But does he stop? No. He enters the clip. And you heard from the ballistics expert, Ms. Bagwell, the clip holds 17 plus 1 in the chamber. He entered. And Gabby, it's another angle you can see clearly. He is right here to the right of the truck. All the casings are scattered. And look how close it is to the front door where the casings end up. This defendant clearly was on a mission to kill that night. It wasn't about engaging. It wasn't about being sad or caught up, a man in love. This was a man who wanted to kill. And he did. And then we have a curious shot straight in to the windshield. Remember, there were 2 guns. And I submit to you, when he went back down that hill, grabbed the second gun and came back, as he was going past, because Gabby got away from him, but he's not sure, he says it as well. Oh, I wasn't sure if he was going to shoot. Well, why would he want to shoot you? Unless that is because you shot him. I submit that he did one last shot to make sure that boy was dead. Look at the distance to the front door. But for her sister's quick thinking, Gabrielle will be lying on that stoop. Because remember, she said she was up in her bedroom. She had to come down. This is a letter. And then we see a second holster. Remember when he put his hand in? I submit that that was the other gun's holster. Because why else would it be there with another shell casing? The defendant clearly used two guns to shoot Jamari, but he only turned in one. And remember, the only comparison that was made was to a Taurus 9, and only one. All of the others, the collective of other bullets, did not come back to any of the guns he turned in, nor did it come back to the gun that was found in the car. Because the gun in the pocket wasn't a Taurus 9, it was a Taurus 40. There was no 40 caliber cases, projectile bullets discovered anywhere on scene. And so we know that gun was never discharged. Every single bullet casing fragment came back to a 9mm handgun. See here, item 3C, 9mm bullet to the neck, up here. Matches the handgun turned in by this defendant, 15A, Taurus 9, right here. But the collection that really wriggled his body comes back to either of any of these handguns right here, Beretta, Diamondback, Celtic, Ruger, Sig Sauer, or another 9mm. But that second 9mm, he told us what he did with it. He told us he threw it away. And then he threw it away because, as I said at the beginning, that is consciousness of guilt. And then defense wants to argue that there were other guns not tested. Well, officers did test him. You heard from the brother, he says his Jimenez was taken from him. It was tested against all the other 9s. His Jimenez 9mm excluded, was given back to him. We had the 4 guns. Every gun involved in this situation was tested. And the only gun implicated was the gun of Lamonte Willis. And let's look at the location of this gun. They were trying to misdirect him. Again, more red herrings and distraction. Look at the position of this firearm. This is the handle, right here in the crevice. Muzzle is facing in here. Broken glass littered in the pockets next to it. That gun was never touched. That happened so quickly. Jamari had no time to react. He did not see this coming. And curiously, they make a big deal about, Lamonte's license to carry and is legal. But so was Jamari right here. He was Georgia gun license. So this isn't an illegal firearm. So if he had used it, he would have been within his rights. But he didn't. He couldn't. He was executed in 2 seconds. And more than that, it was a Taurus 40 caliber pistol. And then we look at his home video. When Lieutenant Moss does her canvas and locates his home, we find a curious thing at 9:52 p.m. I remember the 911 call came at 9:40. She says, depending on the route you use, it could take about 12 to 18 minutes, just depending on where you go. So shortly thereafter, he's coming back home. He's coming back home, opening his door, and you clearly see the 2 guns. See the 2 barrels right here, 1 and 2. Gets home, grabs some stuff, puts the car in the garage, takes off. Because by the time his brother comes in, the front door is wide open, he's nowhere to be found. Ladies and gentlemen, there was only one aggressor in this entire situation. And that is the defendant. And when you're the only aggressor, when you are the initial aggressor, the person who initiates all of this, you are entitled to deadly force. Based on his testimony, he admitted he was angry. And this was before he ultimately shot Jamari to death. He didn't stay home. When he dropped the children back at about 9:27, he didn't go home. And he said he had to work the next morning. He went to Welcome Park nearby and he waited. He wanted to see if he would at some point engage Gabby, because what he's doing while he's at the park is calling, hoping maybe at one point she answers. And he decides to circle the block. I'm gonna go back around because in his mind, he already told her, you should be back by now. You should be back by now. There was never any evidence of any credible threat by Jamari Davenport that warrants what happened to him. Nothing that justifies his injuries. Only the defendant's words that he was so in love and so cut up, he snapped. But I put it to you, we should not listen to the defendant. They're self-serving statements. Of course he's going to say that. And I submit to you, we simply cannot trust his words. But we cannot trust him. And as you can see right here, from his house at Epps Circle to Diane Drive and Welcome Park. Red pin at the top is the Diane, first pin is the Diane Drive location. Coming down Welcome Park, literally right in the same vicinity. Coming down to Epps Circle. Depending on where you go, less than 20 minutes. He had every ability to do what he did. And he also had every ability to reflect, because there was time between that distance when he decided to go get his weapons, carry his weapons, go to the house, drop the kids off, come back, hang around. All of that is time to reflect and reflect on what he could do if he encountered Gabby and if he encountered her in a situation that would upset him. But instead of using that time to reflect and to cool down, he built up and he built up and he kept building up. By the time he met them, he was done. He was at 100. Nothing was going to stop him. Not even Gabby walking into her door and ignoring because her back is to him in the video when he starts to execute Jamari. Gabby's not engaging with him. No one is. And he's upset. He is pissed. Did the defendant act with an abandoned and malignant heart when he killed Jamari and then turned to Gabrielle? The answer is 100% yes. Absolutely yes. He shot a man within 2 seconds. 2 seconds. After he dropped his holster, took the safety off, walked up to that vehicle, he unloaded. And then he told Gabrielle maliciously, you're next. Because he had unloaded the clip. So he had to go get the second gun. You're next. This is not heat of passion. It never was passion. The passion was gone. This was a somewhat pseudo co-parenting, codependency. We have children together, so we have to talk. And so I'm going to talk to you to the extent that I have to engage with you, but I am not romantically at that point involved with you. And that's what's going on. The defense says, well, he didn't intend to kill Gabrielle because he didn't pull the trigger, he didn't bang on the door. That is not the law, what he intended to do. There is a charge you will hear when you go back to deliberate about abandonment. And the law says when you abandon, when you try to do something, you stop, you got to stop before you attempt it. You can't say, well, I couldn't, there was something standing in my way, like a front door, like a bunch of people in the house that stopped me, or she ran faster than I could. That stopped me from fully executing my intent, so therefore I'm not guilty. No. If when he ran back down the second time and kept going, maybe. But when you take the gun, run up, holding the gun at this girl's back, because Gabby says, quite truthfully, I saw him run to get the gun and I'm booking it to the house. My back is to him. I don't know how he's holding the gun. The only people who could see how he's holding the gun are the people inside looking out. So when the defense says Gabby doesn't know what happened, Gabby's lying, that is simply not true. Gabby is telling you exactly what happened. She couldn't see whether it was up or down or to the side because her back was to him. Her concern was to get inside. But the sisters and the mother are looking, and they can tell you, as you heard in the 911 call, as Winifred testified, they saw him coming up behind Gabby with that handgun. And Gabrielle told officers, Lieutenant Moss testified, after he emptied the clip, he turned to her and says, you're next. And, just seeing a man dropping off your girlfriend in her driveway, it's just not a license to kill. Just simply isn't. He took all of the substantial steps. There was no serious provocation. And everything that the state has charged him with is absolutely valid. I remember we talked about felony murder earlier, and I said there was no intent, necessarily no intent element. When you raise a handgun, fire 16 times, even if we don't have to prove intent or motive, but we can show it by his actions, because everything he did was intentional. And now he wants you to accept all of what he did was okay, because Gabby was the love of my life, because I love Gabby. How do you love someone and go to confront them with a loaded weapon? There's zero, no evidence besides his self-serving statements that he acted in a heat of passion. I submit to you that is conjecture, that is speculation prepared for this trial. There was simply no objective, independent evidence that of any circumstance warranting heat of passion. And then on cross yesterday, he became very curious. Do you read direct? He had a clear memory of everything that happened, and he knew what he did and why he did it. But then when I crossed him, suddenly, I don't remember holding the gun. I don't recall. I don't remember. My mind was gone. It was not. He knew right from wrong. He stalked her. He kept up with her location. He tracked her for various means. He armed himself because you know what? He thought he was smarter than all of us. He thought he was smarter than Gabby. He thought he was smarter than everybody else in the situation. But for that surveillance, which he did not know existed. When he saw Gabby exit the truck without further context, that does not justify being told you're next. While he runs back to his car to get that gun. Just seeing somebody drop off your girlfriend, not knowing if it's male or female, that does not, without more context, justify being shot, the driver being shot 16 times. And he told us clearly, he did not know who was inside that truck until after he shot. So how could he then say he was seriously provoked when he didn't know if it was male or female in the truck? Simply, he was angry at Gabby, and whoever had her was going to pay, because he didn't have her. Defense wanted to say, oh, well, this is a good man, you know, he did good things, he went to school, he had a good job, he paid the bills. You know who else is a good man? Jamari Davenport and his family who had to bury him. They are good people. Gabrielle Gore is a good person, and she did not deserve to be aggressed and feel that her life was going to end that night. LaWanda Gore is a good person, and she did not deserve to be in a 911 call crying out, he's going to kill her. But it doesn't matter what his lawyer thinks. It only matters what the law says, and it only matters what the evidence says. Our role as prosecutors is to earnestly seek truth. And all week, that is what we have attempted to do. Because the truth in this case, the only charge he is not guilty of is voluntary manslaughter. He's guilty of everything else in the indictment. There's no manslaughter charge. Nothing he does fits the element required to support a voluntary manslaughter charge. Everything he did supports the charges as indicted. More red herrings, I want you to focus on as you deliberate. He was in love with Gabrielle. That's a red herring. That's misdirection. He thought someone would shoot at him. That's a bogus lie. No one reached for a gun. There was no gun presented. He did not arrive angry. Another bold-faced lie. And on the stand, he says he doesn't remember holding the gun. When he remembered holding the gun on direct with his lawyer, he just forgot when I asked him questions. So more lies from a defendant who is trying to manipulate you and misdirect you into letting him off. Because remember how we testified? It was me, I did this and I did that. This is all about him. You watched the videos repeatedly. You heard the testimonies from CJ, Winnie, LaWanda, Gabrielle. You heard the defendant understand. The mild-mannered, soft-spoken person on the stand, I submit to you, was a rehearsed act. And I submit to you further, the reason why he told us where the gun was is because he hadn't practiced that answer. He didn't know how to answer that question. He wasn't prepared for it. Because when I asked the question, he would have to rephrase, stare at me in silence, not want to answer, because he's thinking of what can he say, but the pressure right here, he capitulated because he did not rehearse. Everything else you saw present, I submit to you, was rehearsed. This is not a mild-mannered, soft-spoken defendant. The real Lamonte Lewis is staring at you on that screen. The real Lamonte Lewis is that man who is pushing his mother out of the way to get to Gabrielle in front of his children holding a firearm. His mother has to drag him away from and to stop him from hurting Gabrielle in front of the same children he claims to love so much. This defense is the one who put his hands around Gabrielle's neck and choke her, leaving all kinds of marks on her neck. Choke her so hard that she will feel as if she's being strangled. And then they come up with a story. Well, you know, they saw the sexually explicit content on the iPad, and that's why he did that as justification for pulling a gun out of one of his children in front of them. Gabby told you what the real story was. She walked in the ring with the children. One of them does have an asthma problem. He got upset about that. Fair. They get into an argument. Fair. On the way back, they're arguing in the car, according to Gabby. Also fair. But Gabby, Gabby is mouthy. She talks back. And he can't get her to stop talking back unless he arms himself. So that's what he did. But his mother is present. His mother's like, look, cut it out. Stop. And the mother is telling Gabby, and Gabby's so, at this point, she told us she was so tired of having guns pulled on her. She told him, just pull the trigger. Because what more do you want from me? And the mother is saying, he's snapping. Go in the house. Get away. Because it took her a minute to get him under control. And he was determined to hurt that girl. But for his mother holding him back with that gun. There is simply no evidence that he was in any peril that night, that in any situations justified him using that gun. He was the only aggressor. In fact, he was the initial aggressor. And now he wants you to believe he doesn't recall or he was fearful of being hurt. That is simply not true, ladies and gentlemen. That's just a red herring. Jamari did nothing but give this girl he was dating a ride. Jamari did not aggress him. Jamari did not point a gun at him. At the end of the day, the law does not authorize you to shoot someone 16 times just because you see them dropping your girlfriend. I put that in air quotes because we're all clear. At that time, there was no real intimate relationship. There was a co-parenting intermingling, but there wasn't a relationship by his own admission. There is no evidence. The defense said in their statements that the evidence would show that he was acting in the heat of passion. There is no evidence of that. The only evidence shows he was angry. The evidence shows he abused her financially. He held his money over her head. He abused her emotionally. He abused her physically. The evidence shows he wanted to know her whereabouts at all times. The evidence shows he went to confront her. The evidence shows he went to confront her armed with 2 deadly weapons. The evidence shows he drove approximately 18 minutes back to her house. The evidence shows he did not find Gabrielle kissing, hugging, lying, any situation that would constitute an infidelity. She wasn't talking, she was in a corner, hugged up, whispering in the corner. Nothing. Absolutely nothing but exiting the ride that dropped her off, going into her home. This was a cold, calculated, manipulative defendant. So when would he be justified? If at some point they would have posed a threat to him, sure, but there was never any threats. If at some point he encountered a situation for which that situation could amount to, I caught you cheating, but he didn't catch her doing anything. He didn't even know who she was with. So how is it that he now says she was cheating? You don't know what she was doing. That's all that build up in your own mind. And simply put, just because you have delusions in your mind, hypotheticals in your mind, what ifs in your mind, the law does not lie or rest on the mind of Monte Lewis. The law rests and lies on the mind of the reasonable, objective man. In this situation, would the reasonable man have reacted that way? I submit to you, no. He has zero credibility. What was his priority when he turned himself in? Self-preservation. Because by the time everything unfolded, his brother testified, by the time it happened, it already hit Instagram, it was on the, everyone was calling each other, they knew something had happened. And he learned there was a video. So he knew he couldn't have been hiding for too long. They were going to catch up to him. So he turned himself in, but he throws away the critical weapon. And he pretends as if I'm this good guy. I'm going to give you 2 guns. This is what I used. Lying, even at the very beginning, lying and deception. And then, he understands, he says, this is hard for me. I want to take accountability. Me, wow. Ladies and gentlemen, don't let this defendant manipulate you. This was always about him. But what he did was just not justifiable. He thought no one else would see. He thought he would simply blame Gabrielle, as if Gabrielle would set up her own murder. Gabrielle would set up the man she's dating. Gabrielle would set up a situation where Lamonte Lewis would be justified in reacting the way he did. He has zero remorse. Everything he said, understand, I submit to you, is an act calculated to manipulate you into giving him some type of sympathy, which I remember we said in the beginning, you are not to consider. He absolutely had an abandoned heart. 16 entry wounds. And so, ladies and gentlemen, I submit to you that the defendant is guilty. Absolutely guilty of every charge in the indictment. And if you look at the entirety of the evidence, witness testimony, his physical evidence, all of his actions, you will come to the same conclusions as I have presented today. Why does it matter? It matters because Gabrielle deserves the truth. I always say the truth is relentless to those who doubt. And the evidence authorizes the finding of guilty on each count. Gabrielle has suffered enough at the hands of this guy. Set her free. By your verdict, speaks the truth to me, that set her free. Jamari Davenport also deserves the truth. And the evidence on the indictment as it relates to Jamari Davenport.
There's been an objection, Ms. Charles. Approach. All right, members of the jury, before we resume with the state's argument, I have a instruction for you, which is that some of you may have noticed, as I understand it was very quickly on the screen here, that on a PowerPoint there was a reference to a custodial statement of the defendant. That is a typographical error put in there from the state. That is not in evidence in this case. And it's nothing that you should consider as part of this case, and I instruct you on that. Anything further, Mr. Garner?
Nothing further.
All right, Ms. Charles.
This defendant thought what happened in the dark would never see the light of day. Jamari Davenport was a son, friend, brother. And what he did was so egregious. He took Jamari's life cold blood. And in this county, that is simply not authorized. Fulton County is not the Wild Wild West. Jamari was no threat, and his life ended on that cold, bloody driveway. But his story doesn't have to end there. By your verdict that speaks the truth, you can lift his burden. You can bring peace to Gabrielle's life once and for all by rendering a verdict that speaks the truth. And that truth is, on count 1, he is guilty of murder. On counts 2, criminal attempt, he is also guilty. On counts 3 and 4, felony murder, he is also guilty. On counts 6, 7, and 8, he is also guilty. I submit to you that he is guilty on all counts. Thank you.
All right, members of the jury, it is now my duty to charge you on the law that applies to this case. You'll receive a copy of these charges during your deliberations. You are considering the case of the state of Georgia versus Lamonte Lewis. The grand jury has indicted the defendant with the offenses of murder, criminal attempt to commit murder, felony murder, 2 counts, aggravated assault with a deadly weapon, criminal damage to property in the first degree, and possession of a firearm during the commission of a felony, 2 counts. You'll be provided a copy of the indictment during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. The presumption remains with the defendant until it is overcome by the state, with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason, and does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in this charge, to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, and stipulations of the attorneys. That is, any facts to which the attorneys have agreed with approval by the court. And evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch, and may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The parties have entered into stipulations that have been approved by the court. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where the parties stipulate documents and exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. The jury must determine the credibility of witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witnesses' manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based on that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility. This may include evidence of bias towards a party, and this can include specific instances of conduct of the witness in question that may relate to the witness in question's bias toward a party. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, the defendant does not have to present any evidence nor testify. Evidence of prior difficulties, or the lack thereof, between the defendant and the alleged victims and witnesses has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victims and witnesses, and the reasonableness of any alleged fears by the defendant or alleged victims. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine. but you are not to consider such evidence for any other purpose. Evidence of the defendant's character trait of peacefulness, if any, has been presented to show that he acted consistently with that character in this case. This evidence can come in the form of the opinion of another witness. You should consider character evidence, if any, along with all the other evidence in deciding whether you have a reasonable doubt about the defendant's guilt. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there's a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. The defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, or other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. A person commits criminal attempt to commit malice murder when, with intent to commit malice murder, that person performs any act that constitutes a substantial step toward the commission of the crime of malice murder. When a person's conduct would otherwise constitute an attempt to commit a crime, it would be a defense that the person abandoned efforts to commit the crime, or in any other manner prevented its commission under circumstances showing a voluntary and complete abandonment of that person's criminal purpose. Any abandonment of criminal purpose is not voluntary and complete if it results from A, a belief that circumstances exist that increase the probability of being discovered or caught, or that make more difficult the doing of the crime, or B, a decision to postpone the criminal conduct until another time. If there is any evidence of abandonment, the burden of proof is on the state to establish beyond a reasonable doubt that the attempt was not abandoned. It is no defense to a charge of criminal attempt that the crime the accused is charged with attempting was, under the attendant circumstances, factually or legally impossible of commission if such crime could have been committed had the attendant circumstances been as the accused believed them to be. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and criminal damage in the first degree are felonies, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault or criminal damage to property in the first degree, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. In considering the malice murder or felony murder charge, you must decide whether the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of malice murder or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter, which I will now define for you. The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. For voluntary manslaughter, the state must prove that the defendant, 1, caused the death of another person, 2, under circumstances that would otherwise be murder, 3, enacted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, 4, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. A defendant is not justified in killing his partner or partner's lover for past acts of sexual infidelity of his partner, or to stop what appears to be an act of sexual infidelity of the partner. However, if the evidence shows that the defendant killed his partner or partner's lover, not out of malice or revenge, but as a result of the defendant's sudden, violent, and irresistible passion arising from the sexual infidelity, then you may consider whether the defendant is guilty of voluntary manslaughter. The passion must have been caused by the defendant's discovery of his partner committing an act of sexual infidelity or the defendant's recent discovery of past acts of sexual infidelity of his partner. The state has the burden of proving that the killing should not be reduced from murder to voluntary manslaughter. For aggravated assault, the state must prove that the defendant, 1, assaulted another, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. A person commits the offense of criminal damage to property in the first degree when he knowingly and without authority interferes with any property in a manner so as to endanger human life. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on his person or within arm's reach of his person, 3, while committing or attempting to commit a felony, which is a crime against or involving another person. Murder, criminal attempt to commit murder, felony murder, aggravated assault with a deadly weapon, and criminal damage to property in the first degree are felonies, which I've already defined for you. The term firearm includes any handgun. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it may have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue may be proved by direct or circumstantial evidence, or both. If, after considering the testimony and the evidence presented to you, together with the charge of the court, you should find and believe, beyond a reasonable doubt, that the defendant in Fulton County, Georgia, did on or about March 28, 2020, commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe the defendant is guilty of an offense, or you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk to each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You're also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous. That is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. And in just a moment, I'll ask you to retire to the jury room. Remember, do not begin your deliberations until you receive the indictment and any evidence that's been admitted in this case that we are allowed to have with you in the jury room. Final note, along with these items, you'll also be provided with a verdict form, which lists all of the charges. And as highlighted in the charge, indicates that as to certain counts in this indictment, you're going to make a finding on voluntary manslaughter or murder, but not both. So just follow the indictment and what it says. I'll also note that because it might take a few minutes for us to compile the exhibits, you can feel free to get lunch or to make a decision about whether you're breaking for lunch or whether you want to work through lunch. But I do understand the food is here for you if you want that. So with that, is there any objection to the charge as given by the state other than any objections previously noted? Mr. Gardner?
No, Your Honor, but I do want to make a correction. You held up the form and said go by the indictment. Did you mean the verdict form?
I did say that. Yeah, I meant the verdict form. I'm holding the verdict form. And so that's what this will be provided to you and what you should follow. Anything else, Mr. Gardner?
That's all.
All right. Then with that, you may retire to the jury room. All right, we'll be in recess. Actually, no, we won't. I have to compile the exhibits. We're off the record, but we need to put on the record what does go back and what does not. So, counsel, if you want to go ahead and start compiling, and then when you're done, let's put on the record if what's being held back. Yeah. All right. And then you can put this with the indictment, the joint one. I think I had it as court's exhibit 1. Must have signed indictment.
Oh, verdict to the verdict, right. It's on the end, so. It'll be, if it's not gonna come back. Yeah, they didn't say come back. That's true. Yeah.
And then these are the.
Yeah, I'll go and text.
I think the one with the laptop, I forgot to bring it up with them. If they come in asking for it, then I'll bring it up with counsel.
I don't have no pictures. I'm sorry, Miss Davenport. I don't have it now. I'm sorry. I got some soup. That's all I got. You got, that's all I got. I mean, small weeks.
I did cashew today.
Oh, cashews are much better. Yeah.
I wanted something so. Yeah, but you told me you were holding on to them. Did I? For Miss Small, for 10 months. Yeah. Yeah, like I said there.
Oh, there was a text. That's
Say what?
You have a good memory.
Depends on what I'm being asked to remember. All right.
She was out of a poor kid.
Like what? Lamar? Brian said he called me. That's what he called me.
Sorry.
Yeah, I have this.
Here you go.
Thank you.
You want both of them?
Yeah. I promise.
Yeah, it's someday when you're.
I have issues. Why? I have problems. Why? It's all of them now. I'm my own worst critic, so. Yeah, just set it up real nice for me. What?
She has.
Sorry.
GBI and all.
So whenever you're not going back in. What is that?
That's the, this is GBI and all.
This is the most not going back to the camera.
Flex.
Continue.
It works.
No,
Depends what's in them.
I just remember.
I go by my cheat sheet here.
Yeah.
Is that Eddie? Yeah, I.
No, that part, if they have like. And it.
Yeah.
They're saying no.
They're saying no, no, then let me go back. Come on, Fred. Come on, Fred, seriously.
The most senseless rule there is,
The what?
no one knows what the continuing witness rule means. I don't know what it means. Doesn't make any sense. But we can
They
kind of
were
make
in
sense
the
of it. There's a,
days.
you know,
Yeah, but then I.
a dispute.
Go through the box, I end up not doing it. And maybe I did it. You want me to go through?
Stay slick, man.
Well, I have to go. And I'm gonna share it. I mean, just have to do that.
Let me get my cheat sheet.
Yeah.
Where you go practice? Where you go practice theater? Have you ever worked for the state?
You got that one folder right
No, we're
there?
not sending this back.
Thing in that one folder right there?
Never say never.
I never see care reports back then. All types of care reports, they don't.
No, they go back.
Show me.
I know, well, one of the jobs I'm like,
They don't go back,
they didn't let them go back.
Yeah, they don't go back.
They
They had no
Like other
secret.
cases.
Talking about unk and all that, but you know.
And they were talking about. No, he went to get.
I was going to get
his
it.
Yeah.
See what goes back and what don't.
Indeed. Moss too.
Where are we at? Y'all still making your way through it? All right.
We are arguing
Still on
back
the
there.
camera.
Okay, anything else?
I'll drop the report back to you.
Well, that one, there might be some case law on.
You got for it?
I'll take the box and put it back in the camera.
Yeah, report right ahead.
I guess that's all go back to the.
All right, I'm ready.
But the phone records are on the disc. It's on 870.
I thought they printed a stack of them out.
No, they didn't.
There's no-
It's 1600. I need to
Too large.
print out.
Oh, they're gonna want a laptop then, so we're,
100,000 pages.
It's on 870.
all right, well, we'll have that conversation when they start asking questions.
Don't wait for the judge, give them the.
Yeah.
Can you hold it just in case?
Yeah.
That's right. Try nothing. You've already been appointed. I was filing the order while you were doing your closing.
These go. What is this? It's all tops. Some of those are all tops. We'll give a business all tops.
I hate to continue with this rule.
You know about, it was.
It was paper, not a disc. Okay. Long.
All of this are- Yes. I don't think she, no, she just. I mean, it's some photos. So you finished with it?
Yes. And then we'll take, check.
Yeah.
Good job.
They're about to start right away. We have to go back and regrade. It was 52, 52A. That's what next. Yeah.
Because I asked.
Because she.
Yeah.
Because I was gonna.
Yeah, because I asked you from, Tuesday, you told me.
Yeah, no, that was the plan originally.
Yeah.
And I went back to my office right before. No. No, I'll go back to June.
And, that box? Oh, yeah, everything.
But this probably,
All of
There's
us.
no report.
Did you check to see if they were secure?
Go ahead, open them out, I can secure it. We can get the locks.
Yeah, there's gloves in that, this one. You were asking about the autopsy report?
Yeah, I was making sure they can go back.
Okay.
Okay. You need to go, you need to study, because my case is always getting indicted to Edwards and, Harnessville. So I don't need anybody new. Oh, we should. It's exhibit 254. Exhibit
something to do, okay? We're not gonna, we're gonna open those. But this doesn't have to, oh, 220.
It says just, oh, okay, so 229,
Okay. It's on one.
not 230.
Box right there. 231.
Yeah,
Okay.
I was talking to Dallas, y'all. Okay, where we going?
Those the weapons.
Let me see. Is Louisiana up? Hold on.
Yes, sir. You ain't gotta send them back.
Let's see.
That's it. Just need to open those.
Okay, Louisiana don't have one today. I thought they have one today. Today.
That's just.
I'll be back, call me.
William, William.
I'm gonna just, I gotta go to Judge Rock. Is it Judge Rock? Do you know what folks?
Roth? Oh, state court.
I know.
He'd be on the second floor, I think. Oh, there we go. Go with what he says.
I knew it was somewhere lower. 3F. 3F. Or just call me.
Okay.
That's it, huh?
We ready?
We're waiting for, you gotta go recreate evidence.
Just printing something off?
Yeah.
Uh,
No.
52A and B, what's that? What's 52A and B? Vivids?
The video,
Like just the discs?
they don't know, Vivian is the security stuff, security around the system.
The videos?
Yeah.
So it's just gonna be a disc?
Yeah.
All right, why don't we just, we can just go ahead and start. We already know what's on, what we need to put on the record. Why don't we just go ahead and do that? We ready to put stuff on the record?
Did you find out about the CAD report?
Find out is, it could be interpreted many ways. I can't say I'm enlightened. I can make a stab and, I'm thinking what I'm reading here and I'll, walk you through what I've found, but I'm thinking CADs go back, autopsy reports do not. That's, yeah.
Had a case for CAD reports. I mean, cause they have notes.
I want to say I generally have, and I think I have whenever with other judges, but this should not be a rule. They don't do this in federal court. You just send everything back and let them figure it out. But if you want to preserve your objection, that's what we'll put it all on the record. You ready, Ms. Smith? All right, let's go back on the record for the purpose of summarizing what exhibits will be going back to the jury and which will be staying with us due to the continuing witness rule. I'll also flag that for the videos, there's just discs going back for now, including a disc of text messages. At some point, if the jury asks us they want to review that, we do have a laptop that's been stripped of Wi-Fi and all programs, and so we can have that conversation. Maybe you can start thinking about it now, whether we just send that laptop back with them for all silent videos and the text messages. As I understand it, unless there's consent, the audio video would have to be reviewed here in open court. More to the point, continuing witness rule, as best I'm ever able to understand it, is a focus on whether the writing is little more than a reduction of or substitute for the witness's oral statements. If it's little more than a reduction or substitute, then it stays with us. But if it's not a mere summary, then it goes back. And so, for example, with a CAD report, it's admitted as a business record. It's not in the form of a statement. It's just got a lot of data on there that the witness then explains what it means. And comparing that to other things that have been held not to be summaries versus other things that have, like depositions and written statements and that sort of thing, I think a CAT report's more in line with a medical record, which apparently is allowed to go back, even though that might have statements in it. Make sense of that. Anyhow, for the record now, if y'all could detail, let's detail what's staying out, and we'll assume all the other exhibits are going back.
So we do know that the medical examiner's report is staying with the court, not going back to the jurors.
The GBI reports as well.
The GBI reports are staying with the court and not going back. Although I object to the CAD reports going back, I mean, I do understand that that objection has been denied and they are going back.
That's right. And if we want, let's just identify those exhibits. So I believe the objection is to exhibit 3, 4, and 5. All right. So it's noted for the record, overruled. We'll allow those to go back. And that's because the state wants them to go back. Is that right, Ms. Washington?
Yes, Your Honor, that's correct.
All right. What else?
Your Honor, there were 2 demonstratives that we did use with Ms. Rosa James. Those are not going back. Those were exhibits 876 and 877.
Got it. I agree. What else? Anything else?
I believe that's it.
Yeah, GBI, all files, I think that's it.
Okay. And we have those separated in different piles?
Yeah.
All right. Then I'll allow, we'll have both counsel put them all in one bucket with the indictment and up, and we'll send that back to the deputy, but not until both parties sign off. So with that, we'll be off the record in recess.
Thank you, Your Honor.
Okay, great.
Everybody in the verdict form goes within.
Did she go to 52 in? Yes.
That's the disc for the vivid.
So I guess you gotta wait for it. Well, yes, but I agree that they can get it and then we'll. Okay.
So those, they gonna stay here.
Yeah, that will, that go, no, that's just, this goes back, right?
With them? Yeah.
Yeah, that go by, yeah, that's.
Yeah. Are the guns locked? The 3 guns?
Well, I didn't know. It's still sealed. It's still sealed.
Unlocked. You wanna look
I
at
mean,
them?
if they open, they can open them. if they want.
Well, I won't open it because I'm down.
Yeah.
Yeah.
Oh, well, let's check.
Yeah.
My bad.
Are they sealed?
Yeah.
Really, so you have to take it out of the thing, right?
That's just big hole.
Yeah, yeah.
This is, outside the walls. First trial.
Oh, that one look like it's secure.
Yeah, but it still can be taken, the plastic thing.
Oh, okay.
We can.
What you gonna do with that, about that? Just wanna hear it, so. This one.
Even if it's not now.
You said, got the red on it. So, it's
We're gonna leave the animal up here. Okay.
All right, guys, we're going on another trip someplace else. Hold on a second. Hold on. I don't like this lady. I'm gonna send her. Oh, I'm gonna open up. We're on jury watch. We are on jury watch. Verdict watch, I mean. Verdict watch is where we're at.
Okay, you need to unmute.
Hold on a second, you.
You need to unmute.
Trying to, but it's
There. You unmute.
Are you hearing me now?
Yes, I can hear you.
Okay, thank you.
Okay, you are welcome. I'm glad you were able to get that figured out. So, now calling 24W003395A, B, and C. These are the Township of Ypsilanti versus Stephen Uche. Can I get names for the record, please, starting with the deputy?
Yes, Deputy Benjamin Silver at the Washington County Sheriff's Office.
Thank you. And sir, please state your name for the record.
You mean me?
Yes,
Your
I
Honor?
mean you. Yes.
Okay, Stephen Uche.
Okay, thank you. Today is the date and time set for an informal hearing in these matters. What I have is a citation dated December 20th, 2024, that charges that on or about that date, you operated a motor vehicle on Whitaker Road at or near South Huron River Drive, and you failed to stop within an assured clear distance. That's the A ticket. As part of the same citation, you are also cited for having an expired plate. That's the B ticket. And you are also cited for having no proof of insurance. That is the C ticket. So these are all civil infractions. There are no criminal penalties associated with these. No jail time, no probation. There are, however, fines associated with these, and there may also be points. So before we get started, Deputy Siller, was there anything that you wanted to say?
Yes, thank you, Magistrate. I was going to offer to drop the failure to stop within an assured clear distance citation from this and just keep the expired plate, no proof of insurance.
Okay. So, Mr. Uche, the officer in charge of issuing these citations is offering to dismiss the A ticket. That would leave you with the B and C tickets. Okay. Which I believe these do not carry any points. They do, however, have fines associated with them. Okay. So do you wish to accept that offer?
Yes, Your Honor, but can I explain about the plate?
Okay. So if you're going to accept the offer, then there's no need to explain anything. If you're basically accepting responsibility for the other two tickets, then you would just have to pay them. Okay?
Your Honor.
Is that what you want to do?
Your Honor.
Okay, I'm just asking, it's a yes or no question. Is that what you want to do? Otherwise, you have three options. You can accept responsibility for any of these tickets. Basically, you would pay them. If you want to accept with an explanation, then I can take into consideration any mitigating factors and potentially lessen or eliminate the fine, but not the points. Or if you want to deny responsibility, then we'll have the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. If you want to accept the officer's offer to dismiss the A ticket, That leaves you accepting responsibility for the B and C tickets. Okay, is that what you want to do?
Your Honor, I will accept that, but can I just say one or two words, please?
Yes, if you must.
Okay, Your Honor, I am coming out from a stroke that was devastating, that nearly killed me in 2020. I am still recuperating from that stroke. I was in the hospital for 2 months and was relearning everything. Seeing, I had 2 surgeries in my eyes. I was not talking, my mouth was bent. I'm just recovering from it. Last year, I had a relapse and I was, the 911 came in and took me to the hospital again. I stayed for 2 weeks. So I'm still recovering from it. I'm homebound. I help myself with this walking sticks, all these walking sticks, all these walking sticks, or this can. I'm just learning to live again. But on the 20th, I had a parcel that I got from my children, and I called friends to help me to the post office. I didn't find anybody. So I managed that day. My car was, somehow helped to start. I have not driven it because I was not well. For a long time, I have not driven my car. So I came out to drive to the post office. It's on my return that it happened. So I am saying why I didn't have insurance and change my plate was that I was not well. And since I wasn't going out or driving the car, I didn't feel that I should. Now I know that maybe I should have, but I didn't have a plate. I didn't have insurance, correct? But it was because of my ill health, and I'm recovering from stroke that was really, really bad. If you check my records, you will see that I don't have any problem with my driving or with problems. So please, Your Honor, I'm pleading, I'm recovering. Paying my rent here is as difficult for me. I have been borrowing money to even make up and pay rent. At times, meals on wheels serve me every day, bringing food to me. They send nurses to help in the therapy here. So you can see that I'm disabled. I can't write with this hand. I can't use this hand, my right hand. I can't use it. Initially, it was clumped like this.
Sir, okay. I appreciate your explanation.
Okay.
I appreciate the fact that you have had health issues. I'm glad that you are out of the hospital and recovering. At this point, the officer has dismissed the citation that has points associated with it. That leaves a fine for the other 2 citations. And I can give you time to pay those off, and you can do a payment plan if you need to. But you are sentenced to pay the fines and costs in the B and C tickets. And I will set you for a follow-up court date in a couple months to see how payments are coming along. But at this time, your hearing is concluded. And everyone is free to sign out of Zoom. Thank you.
Thank you, Madam Chair. Have a good day.
The judge is wasn't that judge mighty rude? The judge was mighty rude. He just said I jumped off the plane. Hold on, y'all. Let's go. I was trying to find Louisiana. I'm sorry. All right. Chelsea sent me something. Hold on a second, y'all. Chelsea sent me something. Hold on. Dun, 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 dun. Let's see. They're not doing anything in that one, Chelsea. Nobody's doing anything in that one. Hold on. It's nobody. Hold on, y'all. Let's go ahead on. Yeah, I'm trying to find something for y'all. Trying to find it. It's not to be found. Trying to find y'all something to watch. Yeah, I went to try to go into a revocation hearing in another state, right? Let me tell you, I went in there and I was inside the Zoom meeting. I was like, oh, heck no. I hurry up and got out of there so quick. I was like, I want these people to see my face. Oh, no. We're not doing that. We are not doing that. We are not doing that. We are not doing that. All right, hold on. Let's see what Chelsea sent me. All right, she sent me something that's pretty old. But we're going to go ahead and play this one for us. That's real old. That's 3 years old. I didn't watch that. That's super old. Can we watch Judge Perkins then? That's pretty new. That's an hour ago. He was just live. Okay, let's see what we're going to do.
You have to get to work today, is that right?
No, just
Therapy.
Yes, sir.
Okay. All right, that's getting to work. That's getting to work on yourself. Okay. All right, I have a question for you.
Yeah.
What's your favorite animal?
Probably a tiger.
Tiger?
Bengal tiger, yeah.
Okay. That's my granddaughter's favorite animal. I tried to convince her it should be elephant, but she's not buying it, so.
It's more animals, but.
Yeah. Okay. You know why I ask. I ask because you asked that question of Alex, who related to me.
Yeah, I mean, something my New Year's resolution is to draw a little bit more. So I thought I'd ask both you guys what your favorite animal was and kind of get to work.
Yeah. Well, I think that's awesome. You know, if it's a little trigger like that gets you back doing that thing that, you know, opens up again your creative mind. I think that's really good. You know,
it's not for me. I'd rather do it for somebody else. That's kind of what gets me going. So.
Okay. All right. So since both Alex and I said elephant, that's it. You stuck with elephant. Yeah. Okay. So we both said elephant. I'll be curious to see what you come up with.
probably different style, maybe different angle of what it is, but
Uh-huh.
yeah.
Yeah, I don't think I'll demonstrate my elephant since we're on YouTube. It will be so embarrassing. The elephant that I do for my grandkids. But yeah, I'm glad you were open to that idea of just getting back to your art, because I think that'll be. I don't see any reason why that won't be really good for you.
Agree.
Yeah, awesome. And I guess that's what I had. Alex, what do you have for Carlos?
Yeah, well, good morning, Carlos. Good to see you. No, I mean, you've just been on top of it, you know, while juggling, you know, your mental health services, doing the DV treatment, job searching, you know, so, you know, you're really staying on top of all of your requirements and, you know, really taking in what you're learning from, you know, from these different services. So I just always appreciate you, you know, being very communicative. I know that there's been a lot of changes these last few months, and, you know, that hasn't, you know, deterred you from doing what you needed to do. So I know we talked about the SAD lamp and trying that, right, during this time of year. So I have that. I'll get back to Josh to get to you. So give it a shot, right? We said worst case scenario, you don't like it, you can bring it back, you know, we can use that for someone else. But you never know until you try. So, and then also too, I will get connected with you because you do have those job interviews coming up. We do have some resources as well if you need clothes for interviews. You know, we also do have a connection with a warehouse in the community too, so we might reach out to see if they have openings as well. So just keep doing what you're doing, and you know, if you need any support, especially for job employment, just let me know. But you text me like every other day, so
Awesome.
we can as well.
Thank you. I appreciate it.
Josh.
Carlos, it's good to see you. I'm excited about your resolution. I know nobody asked, but in case you know you need more inspiration, my favorite animal is a polar bear.
All right.
You know, I think it's pretty hard to draw. You know, all the white fur. Well, actually, fun fact: their fur is not white. Did you know that?
I didn't know.
It is clear.
Weird.
It is the light reflecting off of their clear fur that makes them look white.
Weird.
Fun fact. Anyways, outside of drawing, have you been up to anything?
Just going on runs, working out, staying consistent with that.
Good. It's good to see you. Keep up. I look forward to maybe hopefully seeing some drawings or art. Yeah.
Appreciate it. Thank you.
Isaac.
Carlos, how are you?
Doing all right. How are you?
I'm good. I don't think we've seen you since the new year. How were your holidays?
Pretty laid back. Just hung out with the family, ate good food, nothing too crazy.
What was the good food?
Authentic Mexican food.
Okay.
Yeah.
Okay, like what?
Tamales, pozole, enchiladas, stuff like that.
Sounds phenomenal.
Yeah.
You said your favorite animal is a tiger, theirs is an elephant. So is this a art project that you're doing going to be for an elephant or for a tiger, or do you know yet?
Yes, I do all of it. Keep me going.
Maybe a polar bear too?
Yeah.
Okay, well, I was trying to think of my favorite animal. I think it's probably at this point.
I know what it is. You want me to tell you?
Go ahead.
It's a Hawkeye. Come on.
I was actually genuinely going to say like an eagle. I think that's pretty cool. Maybe not a bald eagle, but like a golden eagle. I think they're very cool. So, you know, someday down the line, maybe I'll commission or ask you to do an eagle. That'd be cool. But you said that art is going to be part of your New Year's resolution. Do you have any other New Year's resolutions you want to share?
Just trust myself a bit more.
You said what?
Trust myself a bit more.
Oh, that's a good one.
Yeah.
That's a good one.
Yeah.
Well, I am eager to see that come to fruition this year, but yeah, keep up the good work.
Thank you. I appreciate it.
Where is the information? Letters are.
Thank you.
Yep.
There should be two of them.
Two?
Yep.
So, like you, Carlos, I'm curious how a guy from Nebraska decides that polar bear is his favorite animal. Josh, you have some explanation here.
It's unfortunately, not unfortunately, it's not that mysterious, actually. My teddy bear from when I was 2 years old was a white teddy bear that I named Polar Bear, and that's really it. Luckily, the Omaha Zoo had polar bears the whole time I grew up, so
Luckily for the zoo, but not for the polar bears.
Right, sure.
Yeah.
It's a wonderful zoo.
It gets pretty cold. It is
It's
a
a
wonderful zoo.
very nice zoo.
One of the best in the world.
Henry Dorley.
Yeah. You're one of the few people out here that even know that name.
Oh, it's phenomenal.
Anyways, it is legitimately, if anybody cares, one of the consistently top like 5 zoos in the world. It has like, I think, the most species of any zoo. But so that's yeah. I think just 2-year-old Josh just latched on and has never let go. But I mean, they're really cool. They are, an apex predator. They also, I don't know.
Yeah, they are. I'm going to share that with you too, because I'm going to ask you this. What school, what college in the country has their mascot as the polar bear?
I might assume Alaska, Juneau or something. That's my best guess. I don't know.
No, that's a pretty good guess. Isaac he's contemplating.
I can't think of.
Well, you can think,
My
but
guess would be Alaska, University of Alaska. I don't know.
No, there's one school that does, and it's the college that I went to. Bowdoin College in Maine.
Interesting.
And the polar bear became their mascot because one of the
Traveling to another court because this one here is getting on my nerve. They're talking about polar bear, mascot, and all this kind of craziness. All right, here we go.
All right, thank you. Date of December 23rd of 2023. The bench warrant issued because you failed to appear for an arraignment on August 8th of 2024. The court had mailed you a summons to appear. Do you recall why you were in court that day, ma'am?
My addresses are mixed up on both these papers. These are not my current addresses. They have not been for the past like 5-6 years.
Okay,
So I was
what are you saying? Did you get the notice?
Correct. Yeah, I did not know I had a warrant. Both of these warrants, I did not know.
Okay.
Yeah.
All right, so we're gonna get you arraigned on the charge.
Okay, but Kathy's back. Hold on, y'all. Hold on.
There is.
This is 4. All right. What's both?
Do we have this? Because we can use this.
The ring. Okay.
I have a CD.
Oh, perfect. Then we can do that. All right, we'll take a look at the laptop. And when you're ready, we'll go on the record. All right, we're back on the record. I've received a note from our deputy. I've marked it as Courts Exhibit 4. It says, can we please see the videos of the shooting on the 28th of March, 2020 and the April 19th, 2019 ring video? The notice here and available for inspection. So because they asked for the 2019 ring video, we have to bring them in for that one. I know. Hold up. They've also asked on the note to hear the 2019 ring video. Unless there's consent of the parties, that's not something I can send back. And so we'd have to bring them in here, tell them, You can watch it as many times as you want, but it has to be with us. And so any position on that, Mr. Garner?
I'd rather have them come and open, listen to it in open court.
All right. And so I'll advise them of that. But then I would follow up and say, for the March 28th video, because that does not have audio, we are going to provide you with a laptop. You can use it however you see fit, except it should only be used to review evidence, not for any purpose, et cetera, et cetera. Any concerns with the court-provided laptop? As I understand it, you're volunteering a CD drive for our use today. Any issues with that going back with them?
No.
Okay. So I'd ask the state then to tee up that exhibit. Could you identify the April 19th video exhibit? And as she's looking, we can go ahead and bring in the jury.
Isn't that the one with the quiet ones when he's coming in the house with all those guns? Remember that one?
All right. So we'll play exhibit 22 one time. And I'll let them know how, the mechanics of this, that if they want to see it again or at a higher volume, they're just going to have to put that in writing and tell us. And as I noted, Court's Exhibit 4 is this note. It's now tendered as part of the record.
All right, for the jury. I'm sorry.
Thank you. Please be seated, everyone. Members of the jury, I received your note requesting to review some of the exhibits submitted in this case, specifically 2 videos. A few things to share with you. One is that you've correctly guessed the only way we're allowed to communicate with you now is through writing. So that's how it works. So thank you for putting that on paper. The next thing I need to share with you is that under our rules of evidence, that for videos to go back to a jury room, they cannot have any sound. So for the video from March 28th, as I understand it, that does not have any audio. We're going to provide you with a laptop with a CD drive, so you can have that back in the jury room. The laptop does not have any Wi-Fi capabilities, and it should not have any other programs. Just in case that's not true, I'm instructing you that you're not to use that laptop for any other purpose than to review the evidence submitted in this case. So we'll provide that to you in just a moment here. As for the Ring video, anything that does have audio, you can review it again and as many times as you'd like, but you have to do that here with us in person. And so with that, I'll ask the state to republish that exhibit in its entirety.
Go in the house! Daddy, go in the fucking house! You hard-headed, girl! You hard-headed. And you don't care about this. The baby is watching. You don't care? Them folks don't, you're not going to be able to see them, you keep on. You're not going to see them, period. That's fine. You just go in the house. I thought. You just go in the house. Everybody, you see my house, God, you talk too fucking much. He's laughing, then going to house with his stupid shit.
All right. Unless there's another note in writing you want to just give to me now while we're all here together, I'll ask you to go back to the jury room, and we'll also have Deputy Scott take the laptop and CD-ROM with you. We have to put it in writing. So if y'all want to confer with each other, you can, and put it in writing. That's my understanding of the case law.
You saw that, right? They wanted to see if she was scared of him. Yeah. They didn't show the other part when he came back.
Absolutely. Well, we'll see.
Y'all see that, right? They want to see if he was scared of him. Because they didn't ask to see the part where he came out. And remember when his mom was pushing him back and he came out and pushing his mom? That's the one. They didn't show that part. They showed the part where he inside. She would have been running inside the house. They want to see that part. They want to see manslaughter or murder. Yeah. They're trying to see whether or not to give him manslaughter or murder. It was toxic. Because I'm surprised.
All right. With the consent of both parties, I would ask whether the jury has selected a foreperson, and if so, for the foreperson to identify themselves. All right. And then a question for you, ma'am. Would you like to watch this video again?
Yes.
All right. And how many times would you like to watch it?
Twice,
Twice more.
please.
All right. State may publish.
Okay, here we go, y'all. They're playing it again.
Daddy, go in the house! Daddy, go in the fucking house! You hard-headed, girl! You hard? And you don't care about this. The baby is watching. You don't care? Them folks don't, you're not gonna be able to see them, you keep on. You're not gonna see them, period, that's fine. You just go in the house, I thought. You just go in the house. Everybody, you see my house, God, you talk too fucking much. He's not gonna be going to house with his stupid shit.
I'm laughing at the mom.
Daddy, go in the fucking house. You hard-headed, girl. And you passing over, and you don't care about this. The baby is watching. You don't care? Them folks don't, you're not gonna be able to see them, you keep on. You're not gonna see them, period, that's fine. You just go in the house.
You're gonna see him, period, that's fine.
Everybody, you see my house, God, you talk too fucking much. He's not gonna be going to house with his stupid shit.
Yeah, she can go inside the house, y'all. She
All right. Let me inquire with, after having viewed it another 2 times, I'll check back in with the foreperson. And ma'am, if you could remind me of your juror number. 31. Juror 31, is there anything else that you would ask of us while we're out here now? It relates to this video.
Not that relates to that video, but I did request to see the video from the shooting.
All right. And as I mentioned, that one we are going to let you and are able to have it back in the jury room with you, along with a laptop, and you can do with it what you will. So with that, I'll ask you to retire to the jury room and resume your deliberations, and we'll have that for you shortly.
Yep, that's what they was watching to see whether or not yeah, we're on the same case. They're deliberating right now. The jurors are deliberating. They're just trying to determine whether or not it's manslaughter or murder.
All right, starting with the state, anything else we need to have on the record?
No, Your Honor.
Mr. Gardner?
No, Your Honor.
We'll be in recess.
Like in our room.
Think it was all back. They're trying to see if he was provoked. Yep. Yeah, she would have been like, no, get him away from me. Get him away from me. No, she was like, he ain't gonna see him anymore. He ain't gonna see him anymore. And the little kid, you said the little kid waving to him. The little baby was waving. Mm-hmm. All right, y'all. Let me go back to the other court. She wasn't scared. They were abusing each other. They were. YRS, they were. They were both abusing each other. It was very toxic on both sides. Both sides it was toxic. I ain't on nobody's side. I'm on the children's side. They were not doing right in front of those children. They were not doing right. Both of them. Shanika says, even worse, to say that moment, shake my head. I've been having a panic attack. Shake my head. All right, yeah, let's go to the other side. All right, we're gonna stop this. He knew she was a little thought, and she was playing with his pride by sneaking and geeking, only hitting up when it was convenient for her. She wasn't even in a hurry to get exactly the kids. You saw that, and she was still standing after the mom had to push her inside. And mom had to call her bitch. Man, I just wish it didn't get to that point. He should have been a little bit more level-headed. Instead, he seemed like that was the only woman he had. Like he was all up smitten by her. Come on, dude. You don't do that. There's a lot of other women out there you could have been having a good time with. Come on. Now you lost your whole life doing something stupid. Doing something stupid. Being a hothead. He just want to be around there to sniff it. Let me stop. It's not nice. Stop it. All right, yeah, let's go. What you miss? You missed them asking a question to watch the video. All right, let's go into our, let's take our plane someplace else. Hold on. We're going to take the plane back to Laura. Oh, she went off, y'all. She went off. We missed her. Dang on it. We missed the judge. Yeah, what do you think of the closing remark of the attorneys? What do you think about the closing remark? I was asked, what do you think about the closing remark? Come on, y'all. I need y'all input. The closing. What was the girlfriend's name? Oh, Gab. Enzo, you're right. Me too. That would upset me too if I found my kid. Oh my God. Oh, oh, oh. Seeing a child watching something like that on the iPad? The child? Oh man, I would have been to the roof. To the roof, seriously. A child. We're supposed to protect our children, not allow them to get desensitized to this world madness. Imagine exactly, Alethea. And look, here's the thing that gets me, right? You said, but I mean, he really poked hole because they made it seem like the relationship was over, right? But she was still in a relationship with the guy, even though she said they no longer together, right? Because she started dealing with that other guy in December 2019, and then supposedly she broke up with this guy in January 2019. But then they saw text messages from from her on March 22nd. March 22nd, she told him that she's going to give him some. I can't take her to court and try to get custody, but if you didn't have time to get a video of your child watching that, it's word against word. And then, did y'all see those pictures, y'all? I'm not trying to be funny, but did y'all see the pictures? The supposedly bruises and stuff, the elbow, and then the neck. I was like, well, where's the mark? I look at the neck. I'm like, where the mark? You didn't see a black eye. I'm not saying that she deserve a black eye, y'all. I'm not saying she deserve a black eye, but I'm as big as he is, as big as that dude is. I would have seen some like bruises on her arms, and I'm not trying to get the girl beat up. I promise you, I'm not. Because remember, they said when they came out there, they arrested both of them. So he had marks on him as well. They arrested both of them. And so say you're right, but the court can do a phone drop, whatever it's called. You can't erase it from the cloud. That's how they catch predators, though. It may take some time just to hold your head and be smart about it. Get legal help. Yes, I feel she should have help to be held accountable. Her name is Sarah, but I can't remember her last name. Her name is Sarah. Sunday. Sunday say we still didn't find out who was on video. Sunday, stop it. They didn't say who it was. They didn't say who it was. Oh my God, Sunday silly. She said we don't know. We don't know who it was. It's one of the menses. My son is in his last night. He came walking over here. I prayed, took some Benadryl and cut my lights. I made him watch this before I woke up in the morning. He was back over there. Shake my hand. You see? You see? You see? And here's the deal. The men get in trouble. The men get in trouble every time. I just pray your son be fine. He doesn't end up like any of these people. Look, just like that guy the other day, y'all. The guy who the girl told that she was armed rape, and then he goes and go crazy and go start shooting up and then end up killing somebody that has nothing to do with it because she lied. And guess what? Nothing happens to the girl. Nothing. But I mean, it's not the girl's fault that he react like that. But the point is, had she not told him that, it would have never happened. But it's sad, y'all. A judge is back? Okay, judge is back, y'all. They came a decision already. Sarah wears a lot of light colors, y'all. She likes colors. Clothing. She loves colors. Well, the other ones wear dark colors all the time. We want to hear what y'all saying, Judge. Yeah, I'll put it on record, whatever they're about to say.
Yeah, I would. I mean, they're not gonna look at them, but they're gonna search the ones they want to search. They need to see messages leading up to. And it's good.
Let me know when you're ready.
If we can inquire, if they want the specific pages, but those text messages were, I can give.
Oh, they want the text
They haven't
messages.
asked that,
y'all.
so I don't think
They
we
want the text
need to go give them more than they want. So
They want the
let's go back on the record. I've been handed two written notes by Deputy Scott.
They want
The
the
first
text-
I've marked as Courts Exhibit 5 reads, could we get clarification on what disc has the shooting on it and which video is it? And my proposal would be to write at the bottom of this note, Exhibit 28, and that's it. Is there anything else you think needs to be on this note?
No, Your Honor.
As I understand it, the disc itself has a sticker on it that says 28.
20.
20.
Yes, 20.
Okay.
Thank you.
So I'm writing Exhibit 20 and signing that.
Now here come the video, the text message.
Is there more than one file on that disk?
No, there's only one video shoot.
Okay, then I think I'll just leave it at that. The second note we received, I've marked as Courts Exhibit 6 and reads, could we please get the physical cell phone records from Gabrielle's phone? As I understand it, an exhibit was tendered. It's one large PDF file. And
They want the text
that
message, y'all.
consists of all the cell phone records that were admitted in this case from her phone. They didn't specify, what kind of records, but there's just one document with all of them. And the exhibit number for that is
70.
which they already have in evidence. They now have a computer that can review a PDF. So I would propose writing on here, Exhibit 870, which you can review using the laptop. All right.
They didn't ask for his, just asked for hers. Uh-oh.
I'll say Exhibit 870 rather, contains a PDF which you can review on the laptop.
They thinking like us, y'all. They thinking like us. They thinking like us.
All right, and with that, unless either party would like to review these before I hand them to Deputy Scott, I will give them to him now, and we will remain in recess until we have further word. You're in recess.
Did you have a cast or something?
You're on, not on mute, Miss Vortis.
You're not on mute. He said you're not on mute. It's what it's. Oh. Look at what's name smiling. Sarah's smiling, y'all. Look at her smiling. You see Sarah smiling? Look at her face. See? Let's look at the what's the reaction of the prosecutor?
I thought you broke your arm. I was like, she's in class. I was like, yes? But that's why I thought you were late, because you had to go to the doctor. Oh, I'm glad you know you're break.
No, we hear everything they saying. They're gonna mute us.
Okay. I'm almost finished, so you can get on.
This thing's still in New York, finna get fired.
We can hear them.
Deep careers. Yeah, absolutely.
We hear you. I'm gonna text them and say we hear you.
I'm interviewing some people next week. I want a mini me. Try.
Yeah, that might be her. Yeah. Marshall.
Get your phone. I just texted. You ain't even looking at it.
Doing her thing, man. Let's turn the light off.
The light's on.
Pick up your phone. Pick up your phone. Look at my message. Pick up your phone, Gardner. Pick up your phone. Don't say nothing else. You're gonna be held in contempt from with us. Oh my God, God, we can hear y'all.
You fucking violated the figure for that.
Oh my God.
You scared Wright because Wright thought that boy was gonna get him. Wright thought that Jew.
We can hear you.
Remember when we came in the sheriff was like,
Oh my God, you're talking about the white dot.
We complained about everything.
what about the Baptist?
Yeah, we hear you.
Wrong as hell, but then you.
Outside of
Oh my God, I tried to tell him we could hear him.
What about the bad?
Oh my God.
Because that was the first county for real that I have ever seen the lead detective sitting at the table. I've never saw that. I've never seen that before. Yeah. That was too much. We did bats and jobs, but everything.
Pick up your phone.
Because we had to fucking defend them other ones because they were all coded. Well, in some cases we did, yeah. And his client should have been going home.
His client should have absolutely. He got real. That was the definition.
Yeah.
Oh my God, I gotta call him. We're hearing all the conversation. Hold on, let me go get my phone. I text him.
Go and let it go. Yeah, that's what I think too. Oh, how you talk to him?
think he's not.
Cause you're gonna try that case.
He hired me on that one case, but then it was like, there was something. Something else that was not. And what I hate is that they were in the hospital. So it actually went. And I told him, he had like over months and months too. It's not like before we did.
Did they mute it? He got his phone now. He got his phone. He sees it.
I like him. Yeah, he told me he talked. I do, I'm about to go. I did, first one I just did 1 month, because I wanted to see how I liked it. Then the next one we did like these, kind of tailored, I believe, 60, basically 60 reels.
Okay.
So I was like, let's just do it all day and get it
Right.
done.
How much do you charge for a month?
Well, I was like the 30 reels plus, maybe it was like 2,000 or 2,500.
Okay.
And then we did, like I said, the 60, and I need to go this and then okay, do it to this email.
Okay, let me see. What I do with this?
Or just Sarah B. Flack at Gmail.
Okay. Sarah B. Flag.
They're gonna change the conversation now. He's gonna change his conversation. Look.
The light.
Oh, okay, let me call him.
Oh, there's a light, y'all. They got a verdict.
You got good eyes. I just looked up.
They got a verdict.
Good eyes into theirs. The light.
Yeah, I'm calling.
Nothing.
I'm calling.
They got a verdict. What do y'all think?
All right, buddy. Can you hear me? Yeah, it's on again, huh? All right.
It's harder, like if you never.
Yeah, cause that shit was, it was confusing, yeah.
Y'all nervous? Well, I don't know why y'all nervous. He muted it.
Right here. The spectators can hear. Right here.
He said the spectators can hear us.
Whoever screaming.
He is so embarrassed. say thank you. He did say thank you. Yep. I said, yup. He said, so y'all heard me us talk about the judges? Yup. Look.
And they tested it out. They got a trigger, so she was suicidal. So. 4 years. No, it's Angela Mazzotti.
Say what?
You wanted to review the correction.
We'll do that later.
Why are we so quiet, y'all?
Ready?
He put his hand to his face, y'all. Shake my.
All right, we're back on the record. I've been handed another note, which I have labeled as Course Exhibit 7, and I'm tendering for the record, and it reads, can we get the password to the laptop, please? And so I have written on here the username and password and signed it, and if there is no objection or need to review. So that's different. It's different.
It's different.
Uppercase and lowercase.
I just forgot to type on
Okay. Let me look at it just to make sure I wrote it right.
Don't say it too loud, Judge. Don't say the password too loud because we're going to hear it.
All right, unless there's anything further, I'm handing that back to Deputy Scott, and we will go off the record and return to recess.
Look at Gardner. Look at Gardner, y'all. Oh God. Oh. Oh my God. Look at his face, y'all. Oh. Oh. Look at his face. Smile. You can't the camera. Wave to us.
How you doing over there? I'm about to get on that one. Yeah, I'm finna get off right now.
Oh, what you guys doing?
Checking emails.
Oh.
We don't have individual laptops. So we have to. They don't
Even in
want,
your office?
they don't give up. Everybody don't have a computer in the office. And they have some upstairs on the main floor. Everybody in the world is trying to get on them.
Oh.
Yeah, we don't find a place to
Trying to
log on.
figure out how we
We're gonna
see
do it
them.
on our emails. Absolutely crazy. Like that's the system.
Yeah. My eyes are running. I think they muted now. I think they muted. Yep, it's muted now. They muted it. You guys are muted now. Tell them they muted now. Tell them they muted. It's muted. Tell them it's muted. Type in the chat. It's muted. Y'all muted now. It's muted. It's muted. I gotta tell him it's muted now. Hold on, let me tell him it's muted now.
He trying to take the camera down. Look, he trying to take the camera down. He fixing his suit. They're trying to take the camera down. You guys, oh man, this is so fun. This is so much fun. Gardner is the last name of Lamar Gardner, and I don't know Sarah's last name. Tomorrow is court, guys. Don't forget we got court tomorrow. So we did have us listening to a whole day of court on mute that day. LOL, we're getting better. What time pajama party? LOL. Pajama party? That was yesterday, Miss Richard. That was yesterday. We said we having a pajama party tonight. Did we say we having a pajama party? Oh, I know what we're talking about. Oh. CMT, what was our dates for Jimi Hendrix? I mean Hendrix, no. Jimmy, isn't it this week sometime? Okay, they said that Jimi Hendrix, it says here. His hearing is wait a minute, hold on. Oh. They canceled his okay, they it looks like he's getting out, y'all. Looks like he's getting out. Hold on. Okay, it looks like he's getting out, y'all. Hold on. I'm gonna read it. It says oh, he got 110 days, run concurrent. Yeah, he got 110 days, y'all. They revoke it, and the terms of his probation is 110 days. So he's going to be in jail for 110 days, and they probably gave him time already for where he been. So, y'all heard me? Did y'all hear me? Did you guys hear me? Oh, he got time served, y'all. Yep. He was sentenced to 110 days. He got time served. We're gonna do a live about this. Chelsea, I need the, I need the real one. Hold on, I need to pull it up.
I mean, clearly there's a difference. I think we can concede there's a difference. They think there's a difference, but I'll just say if any, whatever. All right. Is there any need for me to charge them on this, or and we're not on the record yet? Or I'll ask this on the record. That's fine. We're ready. All right, let's go back on the record. I've now received another note from Deputy Scott, which I have marked as Courts Exhibit 8 and will tender for the record now. It asks, what is the difference between count 7 and count 8? Those are our two possession of a firearm during the commission counts. There's actually a difference in some of the charging language, but the biggest thing is that there's different predicates alleged. My proposal would be that instead of bringing them in to charge them, I'll just write on this note, send it back out, and tell them, please refer to the indictment to discern the difference between counts 7 and 8, if any. Any objection from the defense?
No, Ron, thank you.
All right. Okay. Notice available for inspection if anyone would like to see it. Otherwise, Deputy Scott will take it back. We'll be in recess.
Yeah, I'm gonna have another. I'm gonna have another one. Let's go to the job. I never knew that, man. Take a minute, I never thought we could get on these people. I never thought we could get on there. What the hell is somebody put these on? No. None of it. I'll tell you that, man. I'm not sure. Wait, you don't be done. Wait, no, you're not. No, that's fine. Everyone we got here, you come sit and check your minutes. Yep, that's what I'm saying. You can do everything up here. All we got.
CMT, the reason why I didn't want to put that guy's thing in there because I didn't want him to, you know, kind of get us. So I was gonna go ahead on and get into the Zoom.
When he asked.
That's what I'm saying. You guys are Jackson? Yeah, she 100%. Sorry, remember what I said? We got the all yeah, no, rest around. But you gotta be most touch. Anthony. Every day. That's just stop. Stop. You see, you know, it's all that. This is fortunate.
JJ, you said we need you to do a live for free Wendy Williams. We know once you start covering it, everyone else will follow. What's going on with Wendy Williams?
You know. You know what that was. You think? I mean, they're at 7 and 8. I have heard it. I have heard it. Don't say that. Yeah, that's not I was thinking again backwards up. No. I'm self-soothing because I'm scared. I hate this part. Yeah, I am. My worst, the worst part. This is the hardest.
I did. Okay, they said something fell on the wall. Okay. Okay.
That's in your face, facial expressions. I'm scared you got the kid right now. I'm sure it is. I will let you know. Okay. All right. Look, I put a text message to kids on the numbers. You are. You're more confident than me. You cannot. That's right. Right after this, go head out. Huh? What? I'm gonna sit up. You say that at home. So after this, I'm gonna make us fuck up. Yeah, because Asia's not done now. Just gonna have to pick from the leftovers.
They muted now. She did an interview today coming out and saying she's being locked in a conservation ship and institution against her will. She needs Black people to help her like they did Britney Spears. I don't want to miss it with, okay. All right, let's go someplace else. My phone, where's my phone? Hold on, y'all. Let me find my phone. I gotta find my phone. Hold on, y'all. Let's move over someplace else. Let's move over now, Josh, forever. I'm gonna check it out, Josh. I don't know if I'm gonna do it, but I'm gonna check it out. Another one?
Judge Camise is coming out there.
Another question from them?
It's in here.
Are they not looking at that?
Guess not.
It really is.
Right here. I mean, it's buried, but. All right, we'll put all this on the record, but I would say that I will read them. I can bring them back in and charge them on what it says here. A person commits criminal attempt, substantial step. No, we're not on the record. Don't worry. Don't run. Or I could just say generally, I'd refer you to page 5 of the written charges.
Yeah. Yeah, the definitions on post. What's the right on
Yeah. And the definition of attempt
It's on page 5.
is on page 5. Okay, and then I'll add up.
I think it says criminal attempt.
A person commits criminal attempt to commit malice murder. When with intent to commit malice murder, that person performs any act which constitutes a substantial step. If they want to get more specific and start asking about, well, what's a substantial step? Well, that's a different thing entirely. But if they've just asked generically, what is a definition? I think I just have to refer them. All right. All right, last one was 7, I believe. So this is 8.
Did you do it?
Can you go grab the other note I gave you? The last note that was in there, because I just forget what number I'm on. No, this is the new one. I just put it on there. Yeah. Oh, you have 7 there? Which one did you just mark as 7? Okay, then yeah, we are on 8, right? What'd they do after that one?
They asked for something.
Oh, the difference between the 2 counts. Okay, so this is going to be 9. Okay. That 8? That 8? Okay. All right. All right, you can give it 10. All right, you ready? All right, we're back on the record. I've received another written note from Deputy Scott. It reads, "What is a definition of, quote, criminal attempt to commit murder?" Quote. I've marked it as a Court's Exhibit 9, which I will tender to the record. And I would propose writing on the note and sending back to them. The definition can be found on page 5 of your copy of the written charge. Leave it at that. Okay. Any input to that from the state or defense, starting with the state?
No, you're right.
All right. With that, notice available for inspection before we send it back, and we'll be in recess.
It's not the email, it's just your name. Okay. Yeah, just Michael Don Scott, right? Yeah, Michael Don Scott too. I'm too. I did pull down. See, it tell you, it even tell you. It was on, I just had to do it. Okay, here, close it at the top. Okay, go ahead.
But I thought I might as well, while I'm in here, try and do it again, just to keep my brain sharp and have me doing something while I'm in here. You know what I mean? And
And then I'm just trying to keep those relationships open with my family. They'll visit me twice a week, you know. Just they're trying to stay supportive and then tell me to keep my head up. Because I know that when I get out, I'm going to do good. This last time, my first violation, I ran away from fortitude. This second time out was the first time I'd actually had out, and I did amazing. And I've never held a job that long before in my whole life. You know what I mean? I liked my job, and they've got it waiting for me as soon as I come home. Already talked to them. It's a really good job. So
it's a construction job, right?
Yes, sir.
Yeah. Okay. Sorry to cut you off. We can go there. What is I've got your written submissions about your plan, but if you're granted parole, what would the plan look like?
The plan would be to just parole to an apartment. I would have my girlfriend get an apartment ready for me. I would have that same job ready pretty much the week I get out. I could go back and start working there. You know what I mean? And then maybe try to find some outside support class, just a group, something to attend, just as a constant reminder. You know what I mean? Just to keep my head focused and not to dig into trouble. Even though I have no want or need or anything pulling me to do drugs or to do bad. This last time, like I said, I don't know, I just felt different about it. I just was motivated and pushed, and I feel the same way right now. I just want to get out there and just follow through and just complete parole since I was so close to doing it this last time.
Okay. I think you mentioned you're in MRT. I don't show that there's anything documented. So from the board, as they're reviewing your file as of now, it's as if you're not in MRT. So if you are doing MRT, I just talk to the program facilitator or your case manager, make sure it's up on the documentation so that we get that accurate. Okay.
Okay.
You don't have any disciplinaries. Housing staff gives a positive report of your behavior and attitude. How's your mental health?
My mental health is really good. I feel really good about it this time.
Did you do a mental health evaluation on parole, but nothing was recommended? Is that right?
Yes, sir.
Those are the questions that I have for you. Is there anything else you'd like the board to know?
Yeah, I mean, I was really close to completing parole last time. I hope that this time I can get out there and do it. I have no doubt that I'm motivated and pushed to stay on track this time and to get past those last couple months and get this thing done, because I'm not going to be coming back here my whole life. I started when I was young. You know, I caught my first case when I was 18, but I'm done with it already. I just want this to be over with and to move past and to have a family and have a life. So.
Okay. Well, if you are granted another parole, I do mention that pattern of behavior, right, that led to the actions that brought us here. That certainly was concerning behavior, and I would encourage you to work on identifying risk factors, planning for those things, and using resources appropriately to maintain that safe behavior in every aspect. I think that would be my encouragement. At this time, I'm going to take your case under advisement. I put together a report of what I reviewed prior to today's hearing. I'll include what you and I talked about at today's hearing in that report, and then I'll submit that to the members of the board, hopefully by tomorrow. There's 5 members of the board. They make decisions by majority vote. Usually that takes, we say, between 2 to 4 weeks. Sometimes it's a few days. Sometimes it does take a couple weeks. We'll send that to you in writing through the mail, and it will also be posted to the board's website when the decision is made. So with that, thank you for being here today. I wish you the best of luck moving forward, and we'll go ahead and conclude.
Thank you.
This is a rehearing for William Spangler, number 220357. Is that you, sir?
Yes.
My name's Scott Manning. I'm a hearing officer with the Utah Board of Pardons and Parole. I'll be conducting today's hearing. I am going to be taking testimony from you. If you'd raise your right hand, I'll swear you in. Do you swear that the testimony you provide today will be truthful and accurate?
Yes.
Thank you. Did you receive at least 7 days written notice of today's hearing along with your blue disclosure packet?
I received the blue disclosure packet, but nothing about the hearing date. Well, I don't know if I skimmed through the blue packet, but I didn't see nothing about the hearing date, so,
Okay. Well, you do have the right to receive notice of the exact time and date of the hearing. If you'd like to, we can postpone it and reschedule it for another date, or if you're willing to waive that notice, we can continue today if you'd like to. How would you like to proceed?
let's just continue.
We'll do the hearing as scheduled today.
Yes.
Okay. So that blue disclosure packet, it contains the new information since your last hearing that the board has received. It will be considered as a part of all the information that you received in past disclosures as well. Part of the purpose of today's hearing is to allow you to point out any errors or inaccuracies in that disclosure packet. What I'm planning to do is quickly review what's happened before today's hearing. Then I have some questions for you about really the new information since your last hearing. And then at the end of the hearing, I'll give you the final word. But at this point, are there any errors from the disclosure packet you'd like to discuss with me?
Not that I noticed.
Okay. Looks like you returned from your 5th parole in September of 2023. You had an original, so parole violation, an original hearing in January 2024. After that hearing, the board revoked your most recent parole and scheduled today's hearing. They said they expected you to comply with your case action plan, complete residential substance use treatment or substance use treatment as evaluated to be appropriate, and have no disciplinary violations. Just to review, you have a maximum expiration date of October 10th, 2033. That's the 0 to 15 from 2018. So that's the longest, the maximum amount of time the board can retain jurisdiction over your case. Based on your most recent convictions from this most recent parole, your guideline called for, gave a recommended length of incarceration of 9 months. That guideline passed on June 9th of 2024. Obviously, the board is not bound by the guideline in determining the timing of a release or the appropriateness of a release. They consider all relevant factors in your case to make that decision. So I have some questions for you about what's new since your last hearing, but wanted to give you the opportunity to speak first. Anything that you want the board to know or anything that's new since your last hearing?
No. No, not at all.
Nothing? What have you been doing? What's been going on? It's been about a year since your last hearing. What's going on?
I just got sent down to this county. I was up in Cache County and got sent down here to do the programming, and I put in for Garfield, but they sent me here to Beaver, and then I just got into the program like a month or something ago. So I guess yep.
Okay. Yeah, so it looks like you started the pre-treatment about a month ago. Is that right?
Yeah.
And what did you, but you said you were trying to get into a program in another county, but just that didn't happen, or what led to what caused the delay?
Yeah, that's what it was. Is I put in for Garfield, but they sent me here, and so it's a longer program here. So, but it took me a minute to get down here, and then I did a couple months before I got into the program. But I guess I kind of just sat around hoping that it would change, but it didn't. And so I ended up getting into the program, and now I'm in there now. So.
Okay. What have you done so far since you've gotten into the program? Are you taking classes? What do you do on the day-to-day basis?
Well, I just barely began the program, and so I do 30 days or something like that, 30, a little bit more than that days in this where I'm at now, and then I go to the real program. So I haven't even really started that, but I start classes tomorrow in one of their programs that they gave me a folder for. But other than that, it's just been 3 hours at the table every day since I started. So.
Okay. And do you know how long the program is? Have they told you that?
I think it's 10 months.
Okay. And I guess it's been a year since your last hearing. I think the reason we're here with today's rehearing, you've had the 5 paroles. I reviewed those. Really, the pattern of behavior has been absconding from facilities when you're in the community. Looks like it's generally been either that or relapses to drug use and then absconding from various facilities within a few weeks or months. I guess you haven't really been in a program, but over the last year, have you gained any insight about what you plan to do differently if you're granted parole to break that pattern of behavior?
Well, I've been doing so now. My younger days were a lot worse than these days, and so some people don't see what I see beneficial, you know, because I used to get in trouble multiple times a day, didn't care about tickets, and now I watch about, you know, I don't have any I don't get in trouble in here anymore. You know, I have the occasional hiccup with the absconding and stuff like that. But before my first parole, I got out and I got out of the halfway house. I was the only one that didn't use drugs in the facility. I got my own apartment. I got 2 vehicles, and then it all crashed. And so that's what got me back to my PVs. And it's just, I don't know. I've kind of been a little angry at myself but trying. Putting forth the effort to get back on my feet is where I'm trying to return and not get in arguments and fights like that, because I used to do that every single day, and now I don't have any violence on my adult record and other than my robbery. But I mean, I used to get in multiple fights a week, so it's like I've really changed. It's a life or death thing back when I was younger. Now it's just little tickets to me, and some people see those as big issues, and I see them as just a slap on the hand. But when I could, but I need to take them seriously, you know, because those are held against me just like, you know, it's not a good thing. It's not a good thing here. No, it's not. But you know, just me being able to sit here and not get in trouble is 100% beneficial to me. As long as I can sit and think about it, and maybe in the long run, I'll find out where I can, you know, leave from here and stay out. And so that's what it is to me. As long as I could just keep my hands to myself and be happy, you know, it's 100% beneficial to me, even if I'm sitting in here. But hopefully I find my way out soon, you know.
Okay. Well, I'll tell you, in reviewing your paroles, there's one thing that has become abundantly clear, I think, is that if you abscond, if you walk away from a halfway house, or if you don't report for multiple appointments and AP&P doesn't know where you are, that is an automatic failure of parole, and we're going to be exactly where we are right now, right? So I think at this point, do you feel that you've made progress in your ability to do that, to report as directed, work towards having a job and in a residence that you're communicating with your agent? What are your thoughts about that?
Yeah, well, I think I can that I can move up from here. I think that I can stay on task with my programming and the people around me. Staying positive where necessary, but being positive isn't always the right answer to some people's questions. But you know, I think that I can find my way through this and return back to being able to live in a house and out in the city with people where I want to be, instead of, you know, just throwing my life away and returning here.
Yeah. No, and I didn't want to come across that way. I think step one in the process is, yes, you can, right? You could get on parole and report as directed, stay where you need to stay in a facility. But, you know, I think there needs to be some planning, some decisions made that you're going to report, because the absconding, it really is just a pattern, and that's kind of why we're here. So thank you for your comments, and I'll note those for the board. And I think as you're doing positive things in the facility, finding a way to transition that into parole is kind of the ultimate goal. Do you have any thoughts about, as you're getting into this program, how do you plan to approach it so you can plan and use that in the community?
But in my head, these programs are just they're here to kind of guide you, but you really gotta put the effort in to do a lot more than these programs, because they're here to help us, but they're not the greatest help ever. So I'm trying to reach more in my life. I sit back and want to further my education, things that are bigger than these programs, because I've been dealing with stuff like this, and the whole thought process of why we're here, and the people, and why the programs even, why they're here, and why you guys are here to help us, and I've been in a lot of this transitioning, and I'd like to further my education and stuff, high school.
What do you want to study, or you said you want to do education? What does that look like for you?
Well, I do have a couple credits that I need to make up here. Maybe I can make them up here, but I've taken them in different jails, and I've had them not. I've had some of it tossed away, so I should have maybe already been done by now. But I guess, some of it didn't even get reported. But now I'm on. I want to get out and be able to get like my CDL and stuff like that, because and just being able to handle equipment. My driver's license just got. I need a new one. I think that went bad this year on February. So.
Okay. So working on your GED, eventually you'd like to get a CDL, get your documents and everything in order as well. Yeah. I think that kind of goes back to my other point. Parole is meant to help you with those things, right? It's accountability. It's making you safe in the community, helping you with that. But, if you abscond and you're not communicating with your agent, you can't use the resources to help make appointments, get those documents in order. Would you agree with that?
Yeah, I do. My mother just got back to she's always been there helping me with my documents and stuff, and we've kind of bumped heads ever since I was a kid. My father wasn't around, and so whenever things went wrong in the house, it was kind of, I took the blame, and I was a troublesome kid, and I kind of felt like the fatherly figure, and the steps that I took when I was younger to try to help out around the house. I used to get in fights all the time, but it was for the right reason all the time. I never got in trouble. And then as I got older, I just started becoming bullheaded and mean, and I get after everybody, people that were innocent. And now that I had to take a step back and realize that, I had a problem with anger and yelling, and I've learned to hold those in, and that's just been the biggest part with me, and that's the biggest part with it. Anywhere you go in a jail facility is people and the heat in the room. Everybody, once you get angry, everybody else does it, and they're just willing to pull it downhill, And so it's like,
Okay.
I'm finished with that. I want to move up in the world, but sometimes it's like people try to use that against you. It's like, if you throw it away, then throw it away. But if you're going to pick it up, and we need to come together at the same time, because we can't be bumping heads like me and my mother. And finally, me and her are coming together. She's starting to see that I put forth effort to be here. I just the little absconsions and stuff. It's a pretty big deal because, now my record, I'm thinking about getting my record expunged when I get out of here. I'm a hunter. I got my robbery. I didn't even mean to rob the dude. He went to rip the mirror off my car, and I pulled a gun on him after stealing some steak. And so I'm hoping that maybe that can get expunged. I heard that that's a possibility. My mom, she just got hers expunged because she had punched her mom when she was younger. And so she got hers expunged to run a daycare. And so hopefully maybe I could go back to that. The violent life, I lived in for a long time, but I'm an outdoorsman. I enjoy the grass and the trees and birds, and dealing with all this, the gang life ever since I was young is just, I've had enough of it. Gang life and police, and everybody try and turn one on another. It's like, the gang members against cops and cops against gang members, and I just want to be equal with everybody here, we got good and bad people in all of our circles. So
I do know, I think you had a disciplinary December 29th of 2023. So this happened before your last hearing, but it hadn't been documented at the time of your last hearing, so you weren't able to talk about it. Do you remember this incident? It was May 14, B09. I think it says they found a broken needle in your bunk. What happened here? Why'd you have this needle?
Oh, well, that had come. It was in a bag. It was in in one of the laundry bags, and I pulled it out and taped it to a back of a book. It must come out of laundry, but it was stuck in the bag. And so I pulled it out and taped it to a back of a book, and then they found it. It was maybe a 1/2 inch long needle. It had a thread hole and everything to it. I was like, maybe I'll use it for a piece of clothing. So I stuck it to that. It wasn't that I went out of my way to find it. It found me. So, and then I just kept it. That's what had happened. I did 30 days in hold for that. Went back to the kitchen, did 2 days, and then they told me that I had to come down here for programming. So I put in for the program, and then they sent me down here. And yeah, probably try to get back in the kitchen and stuff while I'm down here. Some type of work, I do a lot of exercising, but it's kind of small down here. I'm from Davis County. The sections are 8 times the size of this. I feel anxiety. But
I know you haven't had any disciplinary since that one though. So it's been about 14 months since your last disciplinary. We did not receive a report from housing staff, but we didn't get any negative reports as well. I didn't get a board packet for today's hearing with your release plans. I think at your last hearing, you said you plan to live in Ogden and work in construction. At this point, if you are granted parole, what would your release plan be as far as where you plan to live and work and treatment you'd like to do?
Well, my mother, she said that she might allow me to have a room back in her house, and or I can hit the halfway housing. But I gotta go back and I gotta get all my documents straight with my. I think I still have my wallet, but I need my ID and stuff like that. And then probably finding a house is the hardest part for me with felonies. It took me quite a while. The reason I landed at a house last time in my first parole is because I was the only one that didn't do drugs in the halfway house, and so they just ended up giving me some dude's apartment that got kicked out. They're like, "You're the only one in here that deserves it, so here you go." And so that's how I got into an apartment. Before that, I spent months on searching for trailers, felony friendly apartments. It was crazy, but that's my big issue is finding a place to live and then getting up on my feet. So, but as soon as I get to the halfway house, I should be able to run into all of that. I mean, they make it easy to do that. So.
Okay. Well, those are the questions that I have for you. Is there anything else you'd like the Board of Pardons to know?
No.
Okay. At this point, I'll take your case under advisement. I've put together a report of what I looked at and reviewed before today's hearing, and I'll include in that report what you and I talked about today. I'll submit that to the members of the board, hopefully by tomorrow. There's 5 members of the board. They make decisions by majority vote. Usually that takes between a few weeks for a decision to be made. It can be a couple days, but sometimes it does take a few weeks. Once the decision is made, we'll send it to you in the mail in writing, and it will also be posted on the Board of Pardons website for anyone in the community that would like to access it there. So with that, Mr. Spangler, thank you for being here. I wish you the best of luck moving forward, and we'll go ahead and conclude.
Okay, thank you.
All right, we came in too late. We didn't get all of it, so we'll be back at another time for the other hearings. So that was in Utah. Okay, we're going back to McAfee.
127. I should have got that first.
So cool. Anybody else still up in information? Yes. Please, talk about something? Thanks so much, Sean. And this is like. Good, that's the same.
If you're not expecting don't trust them. Don't click on pages that no attention to they may have type in website and follow quick ones rather than clicking on links. When in doubt, contact your IT security and thanks for watching. And remember,
You got enough information now. I appreciate you, man. We can bullshit, man. Okay, all right, what else can you say? Already one. Type of, I know that, but anyway. You are not staying. Right. Like, look at that. What is this? No, before? Yep. Okay. Sorry, I'm saying, Lieutenant Lee, I helped him do that. I got a mom. Yeah, that should be. That was it. That's all they got. That's it. Retraining. What months? Don't get certificate. Don't get no more else. That's scary now. Just say. Hey. Oh, count, she made GAs. They not, oh, she went to our office.
Oh, they might have worked it off.
Yeah. Print that thing, man. You gonna print that thing, man. Print it, come out over here, shit. I hope it. 4.58. Yeah. Yes. Let me print this damn thing, man. You gotta take it in? I gotta take it, I clicked on it. When you clicked on it? I clicked on it, last week. Oh, you did one too? Oh, you, I really said W-2. Oh, you think, no, you're like me. They say you hear
They hit me up, 2 weeks, they hit me up 2 weeks ago.
You go ahead and take,
That's why I know Monday was my deadline.
let me go ahead and take, I don't know what my man like.
And print it out, I mean, yes.
Yeah, it should be, yeah. It should be coming out in a
This is
second.
some real quick, like,
Huh?
it's gonna be.
It should be coming out. You warming up.
Let me see.
Yeah, it's warming up.
Okay. It's gonna be.
Here. Put that little Tennessee's mailbox.
It's gonna be true or dare, right? You know, but yeah, you should have got your email, right? I see, you should have got your email. Right?
Saying that if you don't take it. He said I need to take it, but then where you go? Did you win the power there, Mason took it?
No, it sent it to my email.
What was the title? What was the title of the email? Security training or something?
They tell you the deadline. See right here?
What's the name of it?
It said it no before.
Okay, I'll be right
Again,
there.
they say, they look and say, please complete. Tell you like right here, see, you only have 5 days.
Okay, so I'll go ahead and do my, should you?
I'm trying to go, they gotta. How is that? This is like, wait a call.
Down. No, it ain't. Shit, I'm telling you, I'll be like,
I'm trying to put it in. See, that's the thing, man.
push it in.
I do like
Yeah,
it.
yeah.
Try to get it. There you go.
It's a court.
Leave it up, there you go, that's it.
Lit up, then.
Yeah, leave it up. Make them up.
Lit up, but they ain't still lit up. They normally start flashing, stay lit up. Get my stuff off the flash drive.
Right. You want me to let you?
You know, stay lit. That, I can pull it, I can make tracking for them.
Send it to your person, yeah. You know, you can download a little bit. Stop. Or stop. Oh, no. Yeah, I mean, you know how many people found out this morning? Man, it was a whole lot, about 10 people. People just tired. I was telling you, mom, do. You know, I ain't gonna have no 3-day week, so you have a 2-day weekend now. Let you have it. Be nice, man. That fucking. Baby, I know. He got something. Oh, yeah, look over there.
I have one iron day.
Crazy, man. Crazy.
Guys, we've been here a whole day. It's almost 8 hours, y'all.
You still have these weekend games. Oh my God. Wow. At least you have. Is that heavy driving?
So Lieutenant Madden.
Oh, I'm not going out.
What's she going? She's going up to the 8th floor, like.
I'm gonna get myself a salad.
Well, hold on a minute. Dang, I can't get my. Please. She went to APS, man. The girl in command post, Ms. Butler, she told me she been investing in football. Then she made some money out of it. Butler's command post, it's computer special. Who that be? She be in command. Yeah. Yeah. She said she been doing the Bitcoin thing. She said she put $1,000 Bitcoin. She made about $18,000. She put 1,000 on it. Made 18,000. What's the turnaround? I have no idea. She just said they was talking about it more. They was talking about it more. Oh, that was It's a shame, you know.
You know, I can't remember.
Yeah, it's taking longer than what I thought. They taking longer than I thought. Much longer than I thought expected. No, CMT, you funny.
That Terrence Scott thing. I went to the gym on Snow Day.
Went to the gym on Sunday?
I gym been open 24/7. The man got me work about me. That was all day. We had to go to the gym.
Yeah, look, what's the deal? What's the deal on this weekend for Monday? Right? Do we need to go upstairs and see that name on this?
What the heck? Your name
Then
was
he
on
said
it.
you were ready.
My name was on
Your name- I think your name probably was on there. I think they did call you that. Let's check.
You were ready.
No, I thought it
I
was.
got it, Eunice Park saying, last night.
Yeah, Tuesday going to Wednesday morning, yeah.
I think they said somebody had updates.
Yeah. Yeah, my wife they gonna be coming back from a room and they gonna if they get stuck, they ain't gonna be able to make it back from line. They're gonna just hang out in Miami. Oh, well,
Yeah, could return to Georgia.
that's gonna be another week. Man, before me, they'll have me 30 hours. Yes, man.
Oh, you want to get some more time?
Hey, Sarak.
Obviously, when it was, when I had that roof in 92, snow was like.
You mean snow again?
Yeah, it was like 3-4 foot. It
The
snowed.
snow again was just really
snowed
ice.
3 days.
Snow again.
No. This is 92.
Oh.
It snowed. It's August snow up to
Oh, we're getting some most snow. Yeah, that's what I was showing
I
them.
remember I had to walk to the Quick Trip. And I remember when the snow finally was melting.
It's warm
on the
outside.
interstate.
What you see? Did you see the temperature?
It's so warm outside, y'all. It's crazy.
19. Is it the 16 to 19? And it's supposed to get no higher than 29 or 30.
For that snow day?
I think so. So it's gonna be ice. Yeah, into the teens and low 20s. Yeah.
Y'all thinking of like 14 when everybody left. All right, 2011 tried to get Atlanta to let them leave, but they let them leave early at the same time in 2014, so everybody was stuck.
I remember.
Because they couldn't treat the road. Because the salt trucks and stuff were trying to treat the roads, it was too late.
I think it was a school bus too that was
I remember
stuck.
2011, and I can't
I
think
think
of
they
the
pretty
word.
much ready now.
Huh?
I think they pretty much ready now.
Yeah, they ready.
That taught them a lesson.
I remember 2011,
Even if it
before
doesn't happen, go
2014.
ahead.
They did it in 2011. And I couldn't make it to work. They can't pick
remember
us
that?
up. Huh?
Do you remember the ice storm we had in 1999 or 96? Probably 1998.
If you had a
We had
flu.
an ice storm, it started popping planted all the trees and power line. It was just ice.
Yeah, that's true.
It wasn't no snow, it was ice.
Yeah. I know they can't pick me up. My coworker, she can't pick me up. And she gave me the car with the chain on. I said, it's your turn.
Uh-huh.
I couldn't get out my driveway. Matter of fact, I took a picture of this thing. This is 2011, watch. And I was stuck in there. There it is. That's in 2011.
Yeah.
See, January 10th, 2011. See,
That's it.
I can't get out the driveway. They can't pick me up. About the same like this.
Yeah, they pick people up.
And the interstate was a block of ice. It was like a parking lot. It was stuck on 25 and more. And all I did was park my car right there. Oh. I just parked my car right there. It just took all reports. I didn't even have to go to this. Give me a report number. They took the information and just gave me a report number. Wow. Yeah, you let it on. Yeah, that was great. Well, let me log on that you had it.
I can't go nowhere.
It's all good.
I don't see another note. Lady Leo, I'm not watching that thing.
She approved. I'm on vacation. She's like 10, 14, right?
I refuse to watch that.
No, you got a whole week. You got a whole another week.
10 more days.
I refuse to watch that, y'all.
That's in me. That's first of the year. See, I put in.
I'm not doing that one.
In December. Right. And then that's the day I was approved. So they get 5 days.
They just gave us 5 extra days.
Yeah, they give 5 days. Hold on, wait.
Take it on, brother.
Hold on. What you say? Where? And I thought you already did that. Oh. Why did this swear y'all in? Why did this swear y'all in on that same day? Oh, so they came back. So what you gonna do? You miss. Yeah. 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 That's good. Oh, just recently? Wow, boy, that little town. Wow, it's crazy, man. So what them down there, man? Yeah. Yeah, it is, man. Where down in Oregon? Yeah. You know. She do, but she just overdo it. Yeah. Safety check.
Tracy, I'm gonna delete that message. I don't want that kind of message in here. Sorry, but I don't like stuff like that. Y'all, why y'all even bringing that nasty taste over here? It's disgusting. I chose not to do that Tracy, because it gets me in a different mode. That's why I chose not to do that case. Y'all coming in here talking about that. It's horrible. It's horrible. I told you guys I'm not doing that. It is very horrible. Disgusting. It is totally disgusting.
Yeah. And what they say? She said what? And you don't know? Who is this guy? He's a new guy?
Y'all can
He's
hear
coming from town.
y'all can hear everything they saying.
Never because you're a sergeant. They don't know nothing now. They don't know nothing. Because you can be a lieutenant, captain still. They don't know nothing. That's why I say they don't know nothing.
CMT, we have the update of everything with
Yeah.
with
See,
Winfrey.
y'all better go. You better go down there and see what they say.
We gotta change
Just don't
our
go down there. Just don't go down there and pick your battle. Just don't go
we
down
gotta
there.
change our
and start
calendar.
messing with folks. They better go see what the city of Oregon wants. Oregon. Just right here. Yeah, that's it.
Oh, Tracy, I made a mistake and hit your thing. I was trying to delete the message and I ended up hiding you. Hold on, Trace. I apologize. What side was Tracy on? I made a mistake and hit. I was trying to delete the message and I ended up blocking her. My apologies, Tracy.
Yeah.
I was trying to delete her message. That's what I get. Hold on.
Okay. There was this one here, right? Yeah. The condenses, right? Yeah. I'm hit you back. When I'm on my way home, I'll hit you back. Who wrote the link? Type your this. Yep. Let's see what I got at the top. Boy, you smart. You smart. This is. Put that in the box. What is it? See it? Is that right? Oh. So they said, now we know when we come check our emails. You can come check email now. But I don't like going and check my email. I sit up there and I just wanted to be able to get on there. And you get on any computer. As long as you type that in your program. I want to use my flash drive. I want to do my commitment. They make a commitment for it. DLC wrap-up. It's DLC wrap-up.
We're gonna do a hard stop, man. What you think? So 36. You think it'll be a hard stop? Look back at that. Is it one of them, what was you talking about? Yeah, they probably, they can't teach my reading right. Can't teach my reading right. Yeah, we probably do like that. Yeah, that's why I hate it. But yeah. That's the culture. I'm talking about. But that's the culture. That's the culture, yeah. Yeah, that's the culture. But you Chinese over there. Already signed, what they gonna do it, what they doing like. We'll teach our kids. Remember that, right? No, we'll teach my read, right? And that's all we're gonna do. You know, that's all we do. Don't teach kids how to read and write. People wonder why I said, man, this is why you thought, man, you didn't teach kids how to read and write. So jumping around all damn day long. Then they come back and we got to be then they come back and we have to be yeah, man. Got a fire, right? That's you might read it right. That's what we do.
Yeah, it's almost 5 o'clock and no verdict.
I think we're gonna do a hard stop. Like at 5. He may come back. You don't think so?
He probably will come out.
He probably come out. Yeah.
Yeah, this is the verdict watch. We're still waiting.
Maggie?
Oh, yeah, jury just delivery, that's cool.
Yeah.
Yeah, Scott. My good friend,
Oh,
yeah. Okay, cool. You had a criminal trial?
Yeah.
What kind of game? Cool. I like the name.
Thank you.
You think they're gonna do that today or?
I thought they would be, quick, but
I have no idea. You never know, try it.
I don't know.
I had a civil trial in Chicago in November. I thought it was gonna be a quick.
Let me take you on the side, my girlfriend. Yeah, do it.
Yeah. Yeah.
I think we really.
Well.
Thank you.
You should be calling me.
Yeah.
Folks, you know. Did I talk right over here? No. Oh, yeah, yeah. They got turned freaking much.
Oh, okay. So y'all want to do dating here?
Yes.
Okay, we're talking this.
That's it.
110 to 1300.
6 o'clock?
Yeah,
Okay, can you go to that time?
yeah,
They sold out.
yeah, we can apply. So.
Okay, okay.
Judge McAfee is judging them.
Oh, his goes in the month, right?
Yeah.
Okay. 5 days operation.
Okay. I'm in the month, so I take my time.
I was trying to tell them that stuff. Oh, I do that every hour. I do it.
Yeah.
Remember, I was saying that. What's that? That part? No. Yeah. This I like grown, right? Sit, face right.
Right.
Maybe he'll come out in the next couple of minutes. It could be no red either. It could be no red either.
During security, like doing the most, I had all the bags.
No, the round. The downstairs, we have no transport. You sure? What happened then?
What time when the ladies transport?
Wow.
What time when the ladies be transported?
For the, like to bring up here.
For the calendar tomorrow. So the ladies are transported separately. Sometimes they use translate. And if you have Hill will be on that. Her attorney's couple. She's scheduled for what? For her attorney's couple. So where they transport in the morning?
I mean, like running. What time?
We have a 9 o'clock calendar at 1 o'clock. So will they transport the 1 o'clock females at 9?
Yeah. To come here? Yeah.
So they don't wait till 1 to
They're
transport?
gonna bring them.
Oh, okay. So the attorney will have, he has topic for that.
No, they just stay down till we.
Okay, well, he needs to follow it.
Okay. It's gotta be done.
Uh, we're on 10, are we not?
Yeah, 9 is the last one, so 10.
There we go. No, this time I think I'm gonna write them a note and try to figure out what we're doing the rest of the day. So is the state still out nearby?
Here's another question, Joe. This is question number 10.
Well, I don't know if I need to actually.
Yes, yeah.
Actually, I don't know if we need to have this on the record now that I think through it. Y'all can tell me if, but I've got like 20 something mock trialers coming in here at 5:30. And so I don't know if y'all have a preference. We can either just continue the course, go until 5:20 and excuse them, or let them know that we'll see you back tomorrow morning. Does anyone have a preference? Say what? Just come on and tell them to come on in?
I mean, how long?
No.
We have the option. I'll say that.
Okay, so that's what I was kind of confirming with you. So I tell them we got until 5:20. We can feel free to let us know if you want to break now or come back tomorrow morning.
I don't want to say the 5:20 rush. We just see if they want to come back today, go later or come back.
A little later is always good, just get it, pick up and have a hard stop.
Yeah.
5, no, more than 5:20.
The court will let them stay here tomorrow.
Well, I guess they could stay as if y'all are. I mean, you might have to. All right. Well, we can start there. But well, yeah, I want to just go ahead and check, see what's going on. Just the logistics of how they can be doing their mock trial thing while y'all are all set up. Then tomorrow's a mega day. Yeah. Oh, we'd have been fine because we've just been out here doing plea and arraignment while they're deliberating, So they can keep going tomorrow. I have no problem with that whatsoever. Chaos. I think yeah, we did that with one of the Trump hearings, I think.
Thank you.
I'll let everyone know.
Next to his son, he's 17, so he can find a way home.
His 17-year-old needs a way home.
He want to text and tell him the way home. So, but I didn't.
So he just wants his cell phone.
He wants his cell phone so he can text him real quick.
Okay, I'll put it on the record.
I'm not too.
All right. All right, ready? All right, we're back on the record. Deputy Scott has just informed me that the jury has reached a verdict. He also gave me a logistical issue, which is juror 19, I believe, has requested to have his cell phone back so that he can text his son to arrange for a ride. We take all their phones during deliberations. And so I know first I would imagine there were a number of folks from both sides watching the trial, and I don't know if we need to hold in place before we would publish the verdict to give them time to come back. I don't know who's out and about. Okay. Is there any reason, are there any concerns about allowing that one juror to have his cell phone back before we bring out the jury?
No.
All right. Okay, well, we'll let him do that. And then when I'm told that that's done, we'll let him do that under the supervision of Deputy Scott, our bailiff. And when that's done, I'll have the jury come back in.
They got the verdict, y'all. They reached the verdict. Took longer than I thought.
All right, Deputy Scott, we're off the record. I'm going to step off. So both parties said that you could get the cell phone, and then just if you could supervise him while he sends that text or makes whatever calls, and when he's done, let us know.
No, MU. Yeah, probably you. Okay. Yeah. This push down.
Oh, taking too long, people. You brought him back yet, y'all? You brought the guy back? Is that him sitting right there? I see an arm next to Sarah. He's sitting right there next to Sarah. Yeah, he's right there. He's sitting in the middle now. There you go. You know he's going to jail, but how long? That's the question. They don't have cuffs on when they're in trial. They don't put cuffs on them when they're on trial. They have these ankle things that they put on them.
Man, see the court will come to order.
All right, let's go back on the record. As I mentioned, I've been informed by our bailiff that the jury has reached a verdict. And so before we bring in the jury, I do want to provide just a note of caution for everyone in the gallery.
No outbursts.
That I certainly understand that this is an emotional thing for everyone involved on both sides. However, we can't have emotional outbursts to this verdict, whatever it is. And so I would ask you to first look within, and whichever way this verdict goes, if you don't think that's something you're going to be able to contain, please step out now and you can watch on our live stream. And then I'll also advise you that our deputies have been instructed that at any signs of any kind of an outburst or any kind of audible disturbance, you're to be immediately removed from the courtroom. All right, if we could bring in the jury.
All rise for the jury.
Have you reached a verdict? Yes, Your Honor. What do you say for the verdict?
Thank you, Deputy Scott. Please be seated, everyone. Deputy Scott. All right, members of the jury. I've been informed that you have been able to reach a verdict. And so at this time, I'd ask the foreperson, again, I have to ask you a few questions. So, ma'am, have you reached a verdict as a jury?
Yes.
And is it unanimous?
Yes.
Has the verdict been filled in, signed, and dated by you?
Yes.
All right, if you could hand that verdict to the bailiff so that I can inspect it. All right, and so at this point, we have to publish the verdict, and what that means is we have to read it into the record. And so, Madam Foreperson, if you could do that now.
All right, here we go, y'all. Read a
Or if you don't feel comfortable doing that, we can have someone else do it.
No, it's fine.
All right.
As to count 1, murder, we, the jury, find the defendant guilty of murder. As to count 2, criminal attempt to commit murder, we, the jury, find the defendant guilty. As to count 3, felony murder, aggravated assault, we, the jury, find the defendant guilty of murder. As to count 4, felony murder, criminal damage to property, we, the jury, find the defendant guilty of murder. As to count 5, aggravated assault, we, the jury, find the defendant guilty. As to count 6, criminal damage to property, we, the jury, find the defendant guilty. As to count 7, possession of a firearm during commission of a felony, we, the jury, find the defendant guilty. As to count 8, possession of a firearm during commission of a felony, we, the jury, find the defendant guilty.
All right, if you could hand that to the bailiff again.
Why they took so long? If we know.
Counsel, the verdict form is available for inspection. Beginning with the state, is there any reason we cannot excuse the jury at this time? And the defense? All right. All right, members of the jury, what I need to do at this point is poll each of you individually. And by that, I mean I have to ask each of you a series of questions. And those questions would be whether this was your verdict in the jury room, whether it was freely and voluntarily made by you, and whether it is still your verdict. And so let me begin with juror number 2. If you could just identify yourself. And I'll ask you, sir, juror number 2, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Juror number 4, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? And is it still your verdict?
Yes.
Juror number 7, was this your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Juror number 8. There we are. Is this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror number 10. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict?
Suppose somebody change
Juror
it.
number 17. Was this your verdict in the jury room? And was it freely and voluntarily made by you? Is it still your verdict? Juror 19. Was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? Is it still your verdict? Juror 22. Was this your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Juror 26. Was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? And is it still your verdict? Juror 31. Was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
And is it still your verdict? Juror 36. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Juror 38. Was this your verdict in the jury room?
Yes.
And was it freely and voluntarily made by you?
Yes.
And is it still your verdict? Is there any other reason on behalf of the defense that this jury cannot be excused? All right, members of the jury, I want to thank you for your service. And at this point, you are released from the obligations I'd placed on you about discussions amongst yourselves or with anyone about this case. And there's no requirement that you have to speak with anyone. But oftentimes, I know sometimes the lawyers do want that opportunity. I know I want to take the opportunity to go back here and thank each of you. But certainly at this point, you are free to leave. And again, it is with the thanks of the court for your service that you are dismissed.
All rise for the jury.
All right. Would any counsel want me to ask them about speaking with the jury? Both sides? I'll do that. And at this point, I would say we will reset for sentencing. And I'll follow up by email with the parties, but I think we'll be targeting next Friday, January 24th, if everyone is available. We'll check and we'll go from there on scheduling. I'm sorry. Well, you'll let me know. We can find a date. If there's nothing else, then we'll stand adjourned until sentencing to be determined.
All right, y'all. I think what did it was when he shot 16 times. It was an overkill.
Not yet.
That's his mother in the front, y'all. That's his mother in the front. All right, y'all. We did the day over. We did the whole trial together. This was very good, y'all. You guys, it's been wonderful doing this time together. It's been fun, wonderful time together. But guys, I will see you guys in a few because I gotta do an update tonight. Very smooth, well organized, not crazy like the YSL case. How much time he's gonna get? He's gonna get a lot of time. Because remember, he got 8 counts. He got 8 counts. Yeah, we're gonna watch sentencing next week. Yes. He got 8 counts. Remember, he got the felony, committed felony, and he got the murder. You know, the murder's going to be some time. That's life. He got all this other stuff. Yeah. So later on, we're going to come back. And we're going to give you update on tomorrow, what's going to happen tomorrow. We're going to give you updates on Roscoe, YSL Roscoe, right? And that's it. Anybody have any questions? Did you guys enjoy our time together? But look, next Friday, they said, but he said, Mr. Gardner said that his he has something to do, and the judge say, he'll check. I'm sorry, he'll check on another date. We don't know if it's actually going to be that date. So. Oh yeah, I'm going to go behind the scene right now. Going behind the scene right now. It was fun, wasn't it? Yeah, only the riders that's been here all day is the one coming back to the back. Only those that's been here all day. We ain't. All right, I'll see you guys in a few. Because I see some people out in other places and they're trying to slip in here now. Haha, y'all think I didn't see you. Bye. Eee.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. this digital world where emotion is shared. Every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click